Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Why is my password not correct? All right. It's incorrect. There. All right, your name, please?
John Edward Pasakowski.
All right, this is a move up. And I'm sorry, it's John Edward.
Pasakowski, but they got me listed as Jack Allen Taylor. Well, they even got my ID as Jack Allen Taylor.
Under the AKA.
That's an alias, Your Honor. It's the same person.
I'm sorry, buddy. I can barely hear you all.
I-
And I understand. I mean, I'm not, let me just get, she's going to help me with it because they know who it is. So once we get to that, we'll be able to, all right. All right, Mr. Taylor, sir, you're here on a violation of probation, sir. And this is in case number MO95-15284, I believe. And that was issued quite a long time ago.
Yes, Your Honor. And
I'll appoint the Public Defender's Office to represent you. Have you all spoken with the state or anything? 2005, 2015.
Your Honor,
Let me let the attorney talk. I'd rather her talk because anything could be said to be used against you. I'm inclined to give a bond. This is a 25-year-old case.
Understood, Your Honor, but unfortunately, as it is a VOP, I think it has to be left as is.
When will it be set? Will they set it for an in-jail arraignment?
Actually, I believe this is a misdemeanor, correct? I think the clerks could set it at this time if they wanted to.
Okay. All right.
Okay.
We'll go ahead then. I've appointed the Public Defender's Office to represent you.
I will enter denial, Your Honor.
Okay, and get it moved up. I know you all will immediately, they're going to immediately get it set up for you, Mr. Taylor. So at this time, I've got the PD appointed for you, and they're going to get you a date, but the attorneys can move that up very quickly, and they could shoot an email out right now to get something.
I need to be back in the hospital, ma'am. I'm very ill.
Okay, well, that'll be something that the attorney can also look at. You know, they'll know the appropriate matters to file, okay?
Division 80, VOP status, April 26th at 9:30, courtroom 9C.
And they're going to move that up if they're able to do so. Okay. Now, do you all want these little sheets back?
Oh, you can just place them up.
Okay, if I throw them away, do they get shredded?
Yeah.
Do they get shredded?
Put on one.
Just a little bit to open it.
Because if not, I'll have a mess up here.
What's your name?
I'm gonna put them here. I'm gonna put them up here and just somebody remind me to hand them to you. All right, we then have the next case. Your name, please?
Spanish, isn't it?
Your name?
Don't speak no English.
Oh. So what do I do to get the interpreter? Just hit interpreter? Go over to this screen. Ooh. And we're gonna hit call, okay?
And they should already be listed.
Just hit that? Okay. And it's calling? Oh, I hit call. And where is my?
Good morning, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
All right, great. Hi, this is Judge Clark. We have an individual that needs to get sworn in, please.
There is contact, Your Honor.
Okay.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Sí.
Please state your name.
Yes.
What is your name?
Keishla Diaz Mendez.
Keishla Diaz Mendez.
All right, ma'am, you're here on a charge. It's case number 2022 CF 294780. It's a charge of false imprisonment with a weapon, aggravated assault with a deadly weapon, and battery domestic violence. You do qualify for the public defender. I will appoint them to represent you. At this time, is there any witnesses here on the matter? I assume there's not. I assume if the witnesses here, we'll have them come up immediately. Is there anything further from the state?
Nothing, Your Honor.
Okay. At this time, you're to have no contact with the victim. Do you understand that?
Sí.
Yes.
I'm going to have you sign the no contact order here in court. All right, thank you. And at this time, I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms, okay? So you need to understand those will be the conditions of your release. And at this time, I will set the bond in the amount of $1,000 under count 1, $1,000 under count 2, and $500 under count 3 with those conditions as a condition of your release. All right? You've got the PD appointed.
Yes.
Were these all interpreter cases then?
Yes, Judge.
Okay, and so that's why my sheet is not in front of these, because they're all commingled, right? That, the little square sheet that is on the top of each of the stack. Okay, that's okay, and it could just be on top of the misdemeanor stack in the fella, I think. Your name, please?
Freddy Amilcar Gómez Ruiz. Freddy Gómez Ruiz.
Freddy Gomez Ruiz.
Sir, you're here on a charge of battery, and at this time, sir, I will appoint the Public Defender's Office to represent you. This is in case number 2022 MM190AW. You do qualify, well, or you want the Public Defender appointed? I don't show a form filled out. Oh, you do qualify. Thank you. That's great. That's what we do that. So you qualify, so I'm going to get you the Public Defender appointed to represent you on the case. At this time, is there anything further from the state?
Nothing, Your Honor.
At this time, sir, I'm going to set bond in the amount of $1,000 with the following conditions. You're to have no contact with the victim. Do you understand that?
Sí.
Yes.
You're also to maintain a separate residence. Okay, you're also, did you sign that? Okay, great. You're also, sir, not to consume any alcohol or illegal drugs. You're not to possess any weapons or firearms, and you're not to return to the scene of where this occurred. Okay?
Sí.
You've got the public defender appointed. Thank you.
Yes.
We know how that ends up. Your name, please.
Buenos días, señora jueza. Carlos Martínez.
Good morning, Your Honor. Carlos Martinez.
Mr. Martinez, sir, you are here on a charge of resisting officer without violence and battery domestic violence. At this time, sir, I've reviewed the affidavit. I do find probable cause. This is in case number 2022 MM2056AO. I will appoint the Public Defender's Office to represent you on the matter. And at this time, I don't see any witnesses that are here. Is there anything further from the state?
No, Your Honor.
This time, sir, as to count one, the bond will remain at $500. Counts two, sir, the bond will be set at $1,000. And, sir, you're going to sign the no contact order, and do you understand that order, sir? And you're also, sir, I'm not sure if I announced it, but you're not to consume any alcohol or illegal drugs. Do you understand that also?
No, no entendí. ¿Me lo puedes repetir?
No, I didn't understand. Could you please repeat?
You can't drink any alcohol, and you cannot have or, use any illegal drugs. Okay? You understand that now?
¿Podría decirle una palabra? Por favor.
May I say something, please?
You've got an attorney there, and your attorney usually does not wish you to say anything. They might speak to you separate because they don't want you to accidentally or blurt out something that could be used against you at a later time, okay? What you may think may not hurt your case quite often does. So your attorney, I suspect, is going to say not say anything, but I'll let you speak with her.
And Your Honor, could you give a one-time return with law enforcement to gather any belongings?
Sure.
Thank you.
At this time, sir, I will allow you to return one time with law enforcement to pick up your personal belongings. When you do that, don't go there and then call law enforcement officer. What you do is you call them, and then they arrange the time and when to meet you and where. Don't go up in the driveway and say, I want to go pick up my items. You have to call them first, and they then arrange the time and the date for you to do so. Okay?
Pero, sí, de acuerdo, pero ¿quién me puso a mí cargos de doméstico si mi esposa y yo nunca hemos peleado y yo llamé a los policías para yo hacer una denuncia?
Your Honor, yes, but I want to know who pressed charges against me because it is a domestic violence charge, and I have never had a fight with my wife. Even I was the one who called the cops because I wanted to file charges against her.
Porque me dispararon.
Madam Interpreter, could you please?
Because they shot at me.
Could you please advise the client not to speak about the facts of the case?
The attorney doesn't want you to talk. Okay. Thank you, sir. You want to come on up? Your name, please?
Javier,
Javier,
Your last name?
Peñate Verbe.
Peñate Verbe.
So you're here, I don't have the court case number says 222-97705. It's internal number, I presume, not an actual court case number here attached to Orange County. You're here, sir, this was an out-of-county warrant, and that court that issued those warrant has set the bond under count 1 and 2 at $15,000 each, count 3 and 4 at $2,000, and count 5 and 6 at $7,500 each. Okay, the county will be notified that you have been picked up, and they will at that time have a number of days. This is out of which county? Let's look. Hillsborough County. So they'll have 72 hours to pick you up. Okay. Not counting the weekends. Thank you, sir. Sure, do you want to come on up? Your name, please?
Camejo Cutino.
Joel Camejo Cutino.
All right, so you're here in case number 2018 CF 11562AO. This was a warrant that was issued, and the case is in Division 15. That court set your bond at none. Are you gonna, do you want the public defender? I don't know if you qualify. Fill out a form, or are you gonna hire your own attorney? Usually there's one case, right?
Ya tengo uno contratado.
I already have a private attorney.
Okay, sir. They'll know, the VOP will be set, and they'll take any measures they need to take at that time. All right, thank you. Your name, please?
Joel Muñoz.
Joel Munoz.
Sir, you're here on three cases, sir, and they are as follows. The first one, public defender qualified. Are you gonna get your own attorney, sir, or do you want me to look at appointing you one? Oh, you qualify. Never mind, you qualify, so I'll go ahead and appoint him. All right, sir. At this time, you're here on the following cases, and I'll just, I believe there's four cases, and they are as follows. First case is CF 2022-2726 AO. It's count 1, burglary of a conveyance, count 2, grand theft of the 3rd degree, and count 3 is criminal mischief. You qualify for the public defender, sir. The bond has been set at $3,500 under count 1, count 2 at $1,000, and count 3 at $500. You are not to have any contact with the victim or return to the scene of where it occurred. As to the second case, sir, this is 2021 CF 15078 AO. That is also a grand theft, sir, charge. That court set bond at $1,500. And once again, the public defender is appointed to represent you on that case. You then have the case of CF 2021 620 AO, and that is a violation of probation, sir. That court has set bond at none. The public defender's office is appointed to represent you on that case also. And the last case, sir, you have is case number 2021 CF 15933 AO. And that is also a grand theft of the 3rd degree. And once again, a warrant was issued for that. The bond was set at $2,500. And conditions of that were no contact with the victim or the co-defendants, no return to the scene, and no weapons or firearms. You do have the public defender's office appointed in each of the cases. Okay? Thank you. And I believe that concludes the interpreter cases? Yes. Okay, I believe that concludes the interpreter cases. Thank you.
Thank you, Your Honor.
So that's it, right? Yeah. Okay, all right. And so we now will start this is the sheet I'm looking for. Oh, got it. That's okay. There they are. There, that's, okay, that's it. All right, your name, please? Okay, this time, does the public defender want to go ahead and get appointed and we take care of it?
Yes, Your Honor.
Okay, at this time, I'll appoint the public defender's office to represent him. Let's see, we have 3 cases. One was a I think a couple of them were warrants. In fact, yeah, 2 were warrants, so let's go ahead and start the case numbers. One is CF 2021-16073 AO. That court set bond at $5,000. That will remain the same. I don't think, were there other conditions on that? Let me make sure. I don't show any other conditions. All right.
Your Honor, I would just ask for no return on all of the petty theft cases.
Some of them had some orders on it. I'll order in addition, no return to the scene.
Thank you.
You're welcome. On the next case on that warrant is case number CF 1828 AO. That is $2,500 plus pretrial release to the judge that signed that. Also, do not return to the scene, do not possess or consume any alcohol or illegal drugs or controlled substance without a valid prescription, and do not possess any weapons or firearms. And again, the public defender's office is appointed on that. There's a new charge, and that's case number 2022 CF 3359 AO. And that charge, there's PC, bond is set at, let's see, I think that was $1,000, and no contact with the victim and no return to the scene. Okay? So we won't reset that. That'll be handled that way.
And any action on the out on bond, Your Honor?
Which was he out on bond on?
It's a petty theft, Your Honor. He has private counsel in that case, so I would
don't
ask.
show it. Nobody, I mean, let me rephrase that. I don't see it. It should be on that information sheet. They don't do it on these anymore? Okay.
Because it's a reset, you won't have.
Oh, okay, got it. Okay, so he's out on bond. Okay, when, I need all kind of information on the out on bond, so let's, okay. Yeah, I didn't have that, so let me kind of get into the right system and let's see what we've got. Maybe, would that be it? Okay, initial appearances. Oh gosh, we did have a busy day compared to some, huh? What is the name of this person? Young, okay. Ooh, I don't know what happened there. And they're in order on this, aren't they? Oh, it's just not gonna even be listed?
No, it'll be inside of the actual case.
Okay, so I need to find the case.
Your Honor, I can give you the case number if that helps.
Is it the 9131?
Yes, Your
Yes.
Honor.
Okay. Okay. Just- So yeah, 9131 AO. At least it came up. When did that occur in relationship to the other warrant? So that's the problem. Okay, this occurred, PC order. Is the state requesting anything? Maybe that's the best way.
Yes, Your Honor, the state would ask that you revoke and hold at no bond.
Okay, well, give me the dates. I need all those pieces of paper back. Sorry, because I've got to look at.
You need the affidavit?
Yeah, because I've got to look, I don't know when these warrants, I mean, these are warrant cases. Were they after he was already arrested and out on bond? Because he shouldn't get revoked if he wasn't.
Your Honor, with regard to the out on bond 21 CF 9131,
Uh-huh,
defendant was arrested on August 4th of 2021.
right. And then he picked, two of these were warrants, and then the other one, I need to know, like, when the warrants were issued.
Understood, Your Honor, but at least one of these cases happened on March 25th of this year.
So just regarding the one matter then, okay. How many thefts does he have? How many prior, I mean, how many? Oh, I don't even have a thing. Last conviction was in 2021. It's a history. All right, at this time, as to the case number 2021 CF 9131 AO, I will revoke that bond. He was out on bond. He's not in the is he still in the hospital?
No, Your Honor, he refused.
Okay. Oh, that's right, that's the gentleman, that's the one that refused. We just had all these other cases. I'll revoke the bond at this time and set bond at none. Okay? And I think that should be the only one that we won't have that sheet on that I can't see. Okay. Next case. Sir, your name, please?
Marquise Rivers.
Mr. Rivers, sir, you're here on a charge of battery domestic violence, and this is case number, sir, 2022 MM1725AO. This was a violation of your pretrial release. The Public Defender's Office has been appointed to represent you, and at this time, state,
Yes, Your Honor.
bond, and he violated the pretrial release. He's out on bond. Is there a request to revoke the bond that he's out on bond on?
Yes, Your Honor.
In Your Honor, I would ask that if you are inclined to revoke for the violation, that you revoke and double as opposed to revoke and holding him at no bond. Even though he picked up the battery, it appears his last conviction was in 2018 for paraphernalia. He is employed full-time. He will lose his job. He's been there for 5 years. I ask that you consider revoking and doubling and maybe setting just a higher bond on the violation.
As to, the court finds, you know, the PC the PC was already found on the violation of the condition of release. And unfortunately, everybody, we're not able to pull some of these up. This was one, so let me take the moment to do that. 01, okay, 1725. Okay, here we go. Affidavit to issue the warrant. All right. At this time, the court does, probable cause has already been found on the violation of the pretrial release, which was 2022 MM1725AO. Public Defender's Office is appointed. At this time, that bond will be set in the amount of $7,000 with the following conditions. Mr. Rivers, do you understand, sir, you'd have no contact with the victim whatsoever?
Can I talk?
No.
Yes, yes.
All right, sir. You're going to sign that no contact order, sir. I'm also going to require you not to return to the scene of where this occurred. You're to have no contact with the victim. You're to maintain a separate residence. You're not to possess any weapons or firearms. Do you understand that, sir?
Yes, ma'am.
Okay, sir. They're going to have you sign that document right there. And then as to the case that you are out on bond on in MM221725AO, sir, at this time, you had just posted that bond and have been in a violation of that pretrial release. I am going to revoke that bond and set bond at none. And again, sir, you're to have no contact with the victim. I know you may say, well, Judge, no phone call, no contact. You're to maintain a separate residence. You're not to return to the scene. You're not to possess any weapons or firearms, okay? So your attorney will have to file for a motion for a bond hearing on that, sir.
Judge, I think that case.
Oh, it's this case number. All right, MM221645AO is the one I revoked the bond on. Okay, all right. I think we now may be in a regular pattern now, right? I think we're on the docket. Okay. Your name, please.
Lanicia Brown.
All right, Ms. Brown, you are here on a charge of aggravated assault with a firearm. At this time, I do show that you do qualify for the public defender. I will appoint the public defender's office to represent you. This is in case number 2022 CF 3577AO. And at this time, ma'am, if you would raise your right hand to get sworn in, please. Do you swear to tell the truth, nothing but the truth, so help you God?
Yes, ma'am.
And would you state your name for the record?
A Precious Lang.
All right, and does the state wish to inquire?
Go ahead.
Or the defense?
Not to inquire, just before we get too far into this case, Your Honor, on the previous case, Mr. Rivers, on the out on bond, you did appoint us. Okay, thank you. I just wanted to make sure.
I initially gave the wrong case number. I
Okay.
gave the case that the new charge, but then I corrected it. Madam Clerk,
Okay.
thank goodness, had me correct it, and that's the one I revoked the bond on.
Okay, thank you.
You're welcome.
Good morning, ma'am.
Good morning.
How do you know the defendant?
I'm her girlfriend, fiance.
Do you live together?
Yes.
Are you afraid of her?
No.
While this case is pending, would you like to continue having contact with her?
Yes.
Were drugs or alcohol involved in this incident?
No.
Has something like this happened before?
No.
I have no further questions, Your Honor.
Does the defense have any questions?
No questions, Your Honor.
At this time, ma'am, just so that, I need to just follow up with a couple of other questions. And do you all live together? I think you said yes.
Yes, we do.
Do you wish to, if the court allows there to be contact, if the court allows there to be contact, do you wish, if you all choose to live together, that you are still able to do so?
Yes.
Okay, so in other words, you do not want the court to order her not to return to the scene of where this occurred or to maintain a separate residence?
No.
Okay, all right, thank you. All right, anything further from the state?
Nothing from the state.
Anything further, or anything regarding the bond on behalf of the state?
No, Your Honor.
Standard conditions with, and no objection to the no contact?
No hostile contact?
Correct.
Yes.
Thank you. All right, at this time, ma'am, I'm going to set your bond at $1,500 with the following conditions. You're to have no violent or hostile contact with the victim. Do you understand that?
Yes, ma'am.
You're also not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
And I'm also going to require you to surrender any weapons or firearms within 24 hours, if there are any. All right?
All right.
You would call the law enforcement agency to do that. And is there anything further, ma'am, that you're requesting?
No, they know that I'm not pressing
Okay.
charges, right?
I just wanted to make sure. I didn't think there was, but I just wanted to make sure. All right.
Okay.
Thank you. I know. I forgot that some of that paperwork we didn't have. Your name, please?
Tory Brown.
At this time, sir, you're here on a charge of, let me go ahead and get the paperwork up here. Okay. You're here, sir, on a charge of robbery by sudden snatching, tampering with a witness to hinder communication with law enforcement, battery, dating violence, petty theft, criminal mischief. This is in case number 2022 CF 3595AO. You do qualify for the public defender. I will appoint them to represent you. And at this time, ma'am, if you would raise your right hand to get sworn in, do you swear to tell the truth, nothing but the truth, so help you
Yes.
God? And your name, please?
Artiana King.
All right, at this time, does the state wish to inquire?
Yes, Your Honor. Good morning, Ms. King.
Good morning.
How do you know the defendant?
Well, he's my boyfriend, but not no more.
Okay. Do you live together?
Yes, at this moment.
If the defendant is released, do you want to continue living together?
No.
Are you afraid of him?
Yes. I don't want to stay with him anymore. I don't want him by me, near me.
Okay.
I'm sorry, we
Sorry, I
can't
couldn't
hear, we can't, that's okay.
I don't want him to live with me no more.
Right, you don't want to have any contact with him or to live with you, you want him to maintain a separate residence?
Yes.
Okay,
Were drugs or alcohol involved in this incident?
No.
And has something like this happened before?
Yes.
Okay. I have no further questions, Your Honor.
does the defense wish to inquire?
No questions, Your Honor.
All right. At this time, thank you. At this time, I am going to require you not to have any contact with the victim. Do you understand that, sir? Do you understand that's directly, indirectly, through a friend, through a text, a message, a letter?
No contact means no contact.
Yes.
Okay, and I don't know if you know that if you violate any conditions of this release, the court will revoke the bond and the bond will be set at none. Do you understand that, sir? Okay. I'm also going to require you to maintain a separate residence. You're not to return to the scene of where this occurred, and you're not to possess any weapons or firearms. Do you understand each of those conditions, sir?
Yes.
Okay, I'm going to have you sign that no contact order. If you, he already did? Okay, great. And at this time, sir, I'm going to set bond in the amount as follows. Under count 1, I'm going to set bond in the amount of $1,000. Count 2, $500. Count 3, $500. Count 4, $500. And count 5, $100. Okay?
And Your Honor, could he have I believe they lived together, the one-time return only with law enforcement?
Is she still here?
I think she's talking outside with someone.
Just outside.
Okay, I just want her to, I'm going to direct it to him, but just so that she knows that I'm going to allow you to return one time with law enforcement. We're going to get her, just so that she knows what's going to happen, you know.
Okay.
So there's no big surprise on that. Okay, I'm going to allow, and she doesn't need to come in. I mean, she's welcome to come in there, but she's not required to. I'm going to allow you to return, sir, one time with law enforcement to pick up your personal belongings. When you do that, I don't think you were in here, you contact law enforcement first. They arrange the date and the time to meet you, and then you will go to there to pick up the items with law enforcement. Do not go up in the driveway and call. Don't go down the street and call and say, oh, I'm ready to go do it. You know, set this up. You call them first and they tell you when and where to pick up those personal belongings, okay?
And yes, I have a question, Your Honor.
You may want to ask your attorney first. Okay.
Thank you, Your Honor.
You're welcome.
Manuel Gordon refused, Your Honor.
Manuel Gordon did refuse? Okay, let me ask the PD what they wish to do. Was Palm Beach notified? I see that, well, he didn't fill out an affidavit, but I'll see. All right, yeah, that's all. You've concluded. All right, we then have the case of Manuel Gordon. This is in case number 2022 CF 3596AO.
I will waive the appearance, Your Honor.
Okay, and does he get notification of the court's order? I mean, I want to make sure he understands the no contact, et cetera. Is that done through corrections or through the attorney?
Your Honor, I know we speak to them, once the case is open, we speak to them personally. But I believe upon release, he gets a copy of everything that the court ordered. Is that not how it goes?
Yes, Your Honor. When he gets released, he gets a copy of his court order, so he'll know.
Okay, I just want to make
Everything.
sure when there's some of the conditions. I'm going to require no contact with the victim, maintain a separate residence, do not return to the scene of this, where this occurred, no alcohol or illegal drugs, you know, possess or consume any alcohol or illegal drugs without a valid prescription, and not to possess any weapons or firearms. At this time, I'll set bond in the amount of $2,500 under count 1 and $750 under count 2. Okay? I think he has a hold for Palm Beach County.
Yes, Your Honor.
Is my understanding also. So they won't, I don't think they transport him until he's released here, right?
Yes, Your Honor.
Got it. That's what I thought. Okay, thank you, but the PD's appointed.
Thank you.
All right, your name, please?
Darrell Highsmith.
Mr. Highsmith, sir, you're here on the following charge, sir. You're here on, just get to the page I'm on. You're here on a charge, sir, of false imprisonment, domestic violence, battery domestic violence, and an assault domestic violence. At this time, you do qualify for the public defender. I will appoint the public defender's office to represent you. This is in case number CF 2022 3586AO. And at this time, I'm going to require you, I don't think anybody's here, I'm going to require you to have no contact with the victim. Do you understand that, sir? And you understand no contact means absolutely no contact.
Yes, Your Honor.
I mean, that's letter, texting, no contact means no contact. You're also, sir, not to return to the scene of where this occurred. You must maintain a separate residence. You are not to possess any alcohol or illegal substances, drugs without a valid prescription. And also, sir, you're not to possess any weapons or firearms. Do you understand those conditions of this bond?
Yes, Your Honor.
Okay, sir.
Can we,
Uh,
the one-time return, Your Honor, with law enforcement?
Sure. I'll allow you to return one time with law enforcement, and once again, sir, I don't know if you were in here when I explained to the other, make sure when you do that, you call them in advance. You just don't drive up and then say, I'm here. You contact law enforcement in advance, and they arrange the time and place to meet you, then to go get those personal belongings, okay? At this time, sir, I will set your bond in the amount of $1,250 under count 1, 1,000 under count 2, and 100 under count 3. Okay? And the public defender's office is appointed.
Nathaniel Jones is mental health, Your Honor.
I'm sorry?
He's mental health.
Okay. That's on Nathan Jones?
Yes, ma'am.
Okay.
Your Honor, I know he wasn't interviewed, but based on the arrest affidavit, it did state he has mental health issues. So I would ask that he at least be screened for mental health pretrial release. And if he does not qualify, to go ahead and set a monetary bond in the alternative, Your Honor.
Okay. Have they been able to do anything with his mental health, or he's unable to be interviewed?
I don't think they screened him yet.
Right.
It says inmate not interviewed.
Right. I see that now, yes. Is there any objection to that on behalf of the state?
Oh, no, Your Honor.
Okay, so court finds probable cause at this time. And just so we get the wording correct, everybody, I know it changes through the years. How is that worded now so that they are able to evaluate? Okay. It qualifies, right. I don't know. Correct, okay. So at this time, we will have the defendant to be released on mental health pretrial release if after the defendant is screened, and if the defendant does not qualify, defendant to be released on the bond as set. Right. Correct? Okay, so at this time, as to count 1, I will set bond in the, let's see, let me look, safe book history. All right, I'm going to set bond in the amount of $1,250 under count 1, and count 2 will be at $1,000 with the following conditions: no contact with the victim directly or indirectly, maintain a separate residence, don't return to the scene of the offense, and not to possess any weapons or firearms, okay?
And I believe he lived with his mom there, Your Honor, so I just asked for the one-time return for his clothes and belongings.
I'll allow return one time with law enforcement to pick up personal belongings, okay?
Thank you.
But of course, if he doesn't qualify for, and those conditions would be the release of mental health pretrial release also.
Okay.
In other words, it's bond or the pretrial, but those conditions of release apply to however he is able to get out.
Yeah, yeah.
Okay, thank you. Is it? And okay, who is this person? Is that person? We can call this person. And then you'll look. Okay, we'll call the other one out of order. If you want to come on up. Your name, please?
Luke Montpremier.
Okay. At this time, sir, you are here on a charge of battery, domestic violence by strangulation, and then count 2, battery. You do qualify for the public defender. I will appoint the public defender's office to represent you. And at this time, I believe, was the co-defendant also arrested? Yes.
I apologize, Your Honor.
I think the co-defendant was also arrested on this one. Was this the one maybe not. Maybe
I don't believe so, Your Honor.
Okay, I've got.
No, actually, it was.
It was?
It's a misdemeanor. She's a misdemeanor.
Yes.
Oh, she is the misdemeanor.
It's Rose.
Oh, Rose.
Remy, or? Yeah, Rose Remy.
Oh, I thought they just sent it to the state.
Oh, thank you. There are too many sheets now, aren't there? Did the state and the defense want them seen together?
Yeah, sure.
Yes, Your Honor.
I think so. I don't know. Can somebody tell me her name again?
Sure, it is Rose Remy. The case number is 22 MM188AW.
Oh, Rose, that was it. She's trying to flip through and get those for you. All right.
She gonna say that.
All right. Ma'am, your name? All right, Miss Remy and Mr. Montpremier, each of you, or Mr. Montpremier, sir, you're here in case number 2022 CF 3578AO. Charge is battery by strangulation, and count 2 is battery. And Miss Remy, I'm sorry, you are here on a charge of battery, and this is in case number 2022 MM188AW. And at this time, does the state wish to inquire? Or do you,
Your Honor, as both the defendants, the general question is why we see them together is, do they want to have contact with each other? Barring that, and usually the court does that inquiry, as they're both defendants.
okay, all right. Miss, I'm going to appoint the public defender's office to represent each of you, and then you can determine the conflict. I mean, you're going to have, I suspect, a conflict, but which conflict? Miss Remy, at this time, do you wish to have any contact with him? And you don't have to. You can say, no, Judge, not at this time, I don't. We need to separate and be separated. We what?
We do have kids together.
Right, well, that would be one thing, but do you all need to live together or anything like that? I don't think so, do you? No, okay. All right. Mr. Montpremier, I'm going to allow you all to have no violent or hostile contact with each other on both of the orders. Do each of you understand that? Okay, and it's not that you have to have contact, but if you do have contact, it cannot be any violent or hostile contact. I am going to require you both to maintain a separate residence. Do you understand that? Okay. Do you understand that, sir? I just need you to verbalize, I see.
Yes.
Thank you. I see you shaking your head, but I need to make sure the record is very clear on that. I'm also going to require each of you not to possess any weapons or firearms. Do each of you understand that?
Yes.
Okay. Now, who resides at the house? Where are the kids? Where are the kids are at the house then? Yeah. Okay. You all are going to have to make arrangements and state. Who is going to stay at the house and who is not going to stay? You pointed she's going to stay at the house with the children. All right. Then what I'm going to require is you all to maintain a separate residence, you both, but I am going to require, Mr. Montpremier, sir, that you not return to the scene of where it occurred, okay, which is the house.
Can we have the one-time return with law enforcement?
Yes. All right. I'm going to allow you to go one time back with law enforcement to pick up your personal belongings, but when you do that, make sure you contact them in advance. Don't go there. Don't just drive up there and then call them, contact them in advance, and they will arrange the time and the date to meet you to go get those items, okay? All right, so you're shaking your head, yes?
Yes, yes.
Thank you. And do you understand the conditions of the court also, ma'am? Okay, thank you. All right, at this time, now, this is what we need to look at.
Your Honor, one other condition, please. It appears that DCF was contacted because children were present. Could they comply with any DCF plan?
Sure. And I'll also put on the order that you are both to comply with DCF, okay? They may investigate, they were notified, I believe, but you must continue to comply with DCF, okay?
And Your Honor, both parties qualify for pretrial release. I just asked for pretrial release.
I think under the, are they, state your position on pretrial release?
I have no objection if they qualify, Your Honor.
You don't?
No.
Okay, without objection from the state, I'll order pretrial release with those as the conditions of the release under each of your separate cases, okay? And pretrial release, they do qualify.
Yes, Your Honor.
Okay. All right, thank you.
Yes.
Correct, no violent or hostile contact. Uh-huh.
And just for the record, Your Honor, Mr. Montpierre does travel out of the state because he's a truck driver. I just asked that he be allowed to continue to work and travel as long as he keeps his court appearances and keeps in contact with his attorney.
Okay, I don't object to that. How should that be worded for pretrial releases to the court staff? Is there any particular wording that would?
Allowed to travel out of state for work.
Okay. Allowed to travel out of state for work. All right. Thank you. But you understand, either one of you violate the conditions, the pretrial release will be revoked and bond will be set at 0. Okay? Either one of you violate the conditions of the release that I've ordered and pretrial release, and they're going to explain to you the pretrial release also. Understand that those pretrial release orders will be revoked, canceled, and the bond will be issued at 0. No bond. Okay? We've got somebody we're going to take out of order.
That's yours.
And who is it? Okay. Okay. Latoni case, if that witness wants to come on in. Sir, your name, please?
Matthew Latone.
Mr. Latoni, sir, you're here on a charge of battery. I do find probable cause, domestic violence. This is in case number 2022 MM. And I was doing so well with my scanning, and now it won't. 2022-2061AO. And ma'am, if you would raise your right hand, I know as best as you can in there. Do you swear to tell the truth, nothing but the truth to help you God?
Yes.
And would you tell us your name, please?
Ryan Latoni.
All right, and does the state wish to inquire?
Yes, Your Honor. Good morning, Your Honor. Can you state your name for the record, please?
Ryan Latoni.
And how do you know the defendant?
It's my husband.
Do you live together?
Yes.
While this case is pending, do you want to continue living together?
Yeah, yes.
Has something like this happened before?
Yes.
When was the last time?
I think July of last year.
Okay. Are you afraid of him?
No.
Were drugs or alcohol involved in this incident?
Yes.
Okay, thank you. I have no further questions, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Ma'am, let me just ask the follow-up questions. The court can order that there be no violent or hostile contact, but the court can include, must maintain a separate residence. In other words, that he not be allowed to live there.
I think it's fine. He can live there. It's okay.
I can't hear you, sorry.
Sorry, no, he can live there. It's okay. It's fine.
Okay, you seem very hesitant.
No, I just have anxiety.
Oh, okay,
Yeah,
and that's fine. My observation, I need to make sure I understand what's going on in the courtroom, and understanding, and I know you've got your baby in your hands, and so you're juggling a lot like that, and that's fine. But the court just needs to also make sure when I'm making these decisions, that I'm observant also.
Yeah.
So is it your testimony today that you are not concerned about your welfare or your baby's welfare, or, concerned about your safety or the baby's safety?
Yeah. Yes.
Okay, and if the court orders him to have no violent or hostile contact, you do not care, when I say care, if you all choose to live together, you do not object to that, is that correct?
Yes.
Okay, and obviously, that's y'all's choice. I'm not ordering it.
Right, right.
Right, okay, all right. Anything further from the state? I'm sorry.
No, Your Honor.
Okay. At this time, I'm going to set bond, I'm going to make the following conditions. You're to have no hostile contact with the victim, and that means, violent or hostile contact. You understand, sir, what that means?
Yes, Your Honor.
I need you to answer very loud and clearly, because this is on the record, and if you violate any of this court's order, the bond will be revoked. Do you understand, sir?
Yes, Your
The
Honor.
bond will be set at 0. It'll be a violation of the court's release, and I suspect that bond will remain the same at 0. So I just need to make sure you fully understand the full consequence of this court's order.
Yes, Your Honor.
Okay, sir. I'm going to require you to have no violent or hostile contact. I'm going to require you not to consume any alcohol or illegal drugs. Do you understand that?
Yes, Your Honor.
And I'm also going to require you not to possess any weapons or firearms. Do you understand that?
Yes, Your Honor.
Okay. Do they do bond plus pretrial release? Yes. Okay. And does he qualify for pretrial release with a bond? I don't show.
He qualifies for.
Okay. I'm going to I'm going to order plus pretrial release so they can do the random testing, the alcohol and the drugs. So I'm going to set your case at a bond of $500 plus pretrial release, okay? Now, pretrial release is going to do random testing, drug testing, alcohol, testing. They're going to make sure this court order is in full compliance, okay? So at this time, sir, the public defender's office is appointed, and you have those as conditions of your release and on the matter. All right? Thank you. Was there anything else you were requesting?
No.
All right. Thank you.
Thank you.
Your Honor, I'm sorry. He doesn't, other than, I guess, the one that was no billed, he doesn't have any history. He qualifies for pretrial release. He's the breadwinner of the house. He just paid all the bills. I would ask for a straight pretrial release since he scored 0 on the risk assessment. Looks like he just started working 2 months ago. Since pretrial release is going to monitor him, I do not believe it will be assisted.
Okay. Any objection on behalf of the state? He
No, Your
does qualify for it straight out. I just was looking at the one other, but I think pretrial release can address those conditions with the alcohol and the drugs. So I'll order just straight out pretrial release. Okay? Yes, with all, when I say straight, I meant all the conditions of pretrial release with still the random testing, alcohol, so it can be breath, it can be urine, it's straight out testing. All right. Your name, please?
Hassan Robinson.
Mr. Robinson, sir, you're here on a charge, sir, of the following: sexual battery by coercing a victim, count 2, false imprisonment, count 3, aggravated assault with a firearm, and count 4, battery, domestic violence. At this time, sir, you do qualify for the public defender. Probable cause has already been found. I will appoint the public defender's office to represent you. And ma'am, if you would raise your right hand to get sworn in, do you swear to tell the truth, nothing but the truth, so help you God?
I do.
And your name, please.
My name is Tanisha Robinson.
All right, and does the state wish to inquire?
Yes, Your Honor. Good morning, Ms. Robinson.
Good morning.
How do you know the defendant?
That's my husband.
I apologize, I don't have an affidavit in front of me. Are you the victim in this case?
I'm the victim, but that is my husband.
Okay. Do you live together?
Yes, we do.
While this case is pending, do you want to continue living together?
Yes, ma'am.
Are you afraid of him?
No, ma'am.
Has something like this happened before?
No, ma'am.
Were drugs or alcohol involved in this incident?
No, ma'am.
I have no further questions, Your Honor.
Do you want to review the affidavit?
No,
Maybe you should. You want to take a few moments?
if you don't mind, yes, may I
do
approach?
not mind. I don't have it printed. I had to look it up in Odyssey.
Oh, I can look it up then, Your Honor.
Okay. Have you had a chance to review it? Okay.
The Probable cause has been found, Your Honor, so you can go forward, but as you continue, I'll just read in the background.
Mr. Robinson, I'm going to require you to have no contact with the victim. Do you understand that, sir? I understand her wishes today and her requests, but based upon the facts of this, that a gun was also used, and the facts surrounding what occurred, I am going to require you at this time to have no contact with the victim. Do you understand that?
Yes, ma'am.
All right. I'm going to require you to maintain a separate residence. Do you understand that, sir?
Yes, ma'am.
You are not to return to the scene of where this occurred, and you are not to possess any weapons or firearms. And in addition to that, sir, you are to surrender any firearms or weapons within 24 hours. Do you understand?
Yes, ma'am.
And ma'am, I understand what your request was, and I respect that, and I've listened to that, but based upon these facts, at this time, and understand this, at this time, the attorney can always request a modification of this, but at this time, the court does find that those conditions are reasonable and should be ordered in this matter at this time.
I understand. Can I just say something, Your Honor, if you don't mind?
You are welcome to.
Okay, like I said, that is my husband. The situation did escalate and get out of hand. During the statement in which I wrote, I was honest, but not 100% honest with the statement, so I want to just put that out there as well. And while I respect the court's...
And that's the thing, if the defense requests a modification on the court's order, they will get that additional information at that time, and I'm sure the state will also want to speak to you, at the appropriate time.
Understood.
Okay?
Understood. Thank you, Your Honor. Appreciate it.
And you understand, Mr. Robinson, I just needed to make it very clear, even though she wants the contact, the court's order is you can't. So, I mean, you understand, I understand what she's requesting, but the court order is what is binding you. Do you understand, sir?
Totally understand. Yes,
Okay,
ma'am.
I'm very clear on my orders.
And one more thing, Your Honor.
If I'm not, I really want to make myself.
One more thing also, when I spoke to the detective on the case, I did advise that I was not pursuing, any charges towards the
I understand.
husband, okay?
Okay.
Thank you so much. I appreciate it.
You're welcome. Thank you. Thank you. All right. At this time, as I say, those are the conditions of the release, though. You understand, and you've stated a number of times that you have. Is that correct?
Yes, ma'am.
Okay. Does he need to return one time to pick up personal belongings?
Yes, Your Honor.
Okay.
Also, he does actually, he's a licensed security guard. If he could keep his weapon at the job and they can lock it up.
Not at this time. He'll have to apply. I mean, you know what you need to do.
Yes, Your Honor.
It just needs to be more of a hearing to determine all those factors. So at this time, sir, I'm going to require you still not to possess any weapons or firearms. Okay?
Yes, ma'am.
Okay, sir. But at this time, I found probable cause, or probable cause was already found, rather. I need to set the bond, and at this time, so I'm going to set bond in the amount of $2,500 under count 1. I will set bond in the amount of $500 under count 2, $1,000 under count 3, and $100 under count 4. Okay? So you do have a bond with the conditions of those release, and I do need, you said you needed to return one time to pick up personal belongings.
No,
Oh, you
you
don't?
don't want me to? Trust me, I won't. I don't
Okay,
even,
you don't even want to,
I don't even.
you don't want to? Okay, all right,
No problem.
okay.
Cool.
The one-time return? Yeah, delete that. He doesn't want it. All right, your name, please? Your name?
Keen and angry.
Mr. Angry, sir, you're here on a charge, sir, of battery, domestic violence, and criminal mischief. This was a warrant that was issued. Probable cause has already been found, sir. I will appoint the public defender's office to represent you on the case. I will appoint them to represent you on the case. And let me go ahead and pull the warrant up. Some of these we weren't able to get up in the system, so I know probable cause has been found, but the court thinks I need to review those. Also determine a bond amount on these no bond cases. I'm first going to order you, sir, not to have any contact with the victim. Do you understand that, sir?
Yes, ma'am.
We're going to have you sign that no contact order in open court. I'm going to require you to maintain a separate residence. Do you understand that, sir?
Yes, ma'am.
I'm also going to require you not to possess any weapons or firearms. And in addition to that, not to return to the scene of where this occurred. Do you understand each of those conditions that the court has ordered, sir?
Yes, ma'am.
At this time, sir, I'm going to set bond in the amount of $1,500 under count 1. Count 2 will remain the same at $500, and those will be the conditions of your release, sir. And it's, okay? And that was in 2021 MM 9162AO. The next case we have, I believe, is Jason Caraballo. Sir, your name, please? Okay. Sir, you're here, I think we have a witness. I don't know. Oh, no, we don't. At this time, sir, you're here on a charge, sir, of battery in case number domestic violence 2022 MM 2072AO. And then you also have 2 cases, sir, of failure to appear. And those cases are as follows. CT 2020-927AW, that court set bond at $500. You also have a failure to appear on a DUI in 2022 MM 2072AO, which also was a failure to appear on a DUI, and that court set bond at $500. I will appoint the public defender's office to represent you on all the cases.
I'm sorry, Your Honor. Are you referencing to his out-on-bond cases? Those are his out-on-bond cases.
Oh, it said failure to appear.
I was
Wait.
supposed to be there today, but I wasn't because I was here.
They're referencing a failure to appear because he failed to appear on it previously, but those are his.
Failed because I'm here. That's the only reason.
Okay, we'll catch that.
So it looks like, but he failed to appear, and they set the judge on that case, reset the bond, Your Honor.
Okay.
So I would just ask that you take no action. He was supposed to be there today, but he was in jail.
Right.
So I'd ask that you take no action on those 2 cases. Since the
Oh, I
bond
forget
doesn't-
all these aren't downloaded. These take forever. I mean, when I say take, I have to go look them all up. 2020. Okay, 2020. So has he ever been arrested on the failure to appears? Yes.
Yes.
It was set for court today, right?
Yes, Your Honor.
AW. All right, we got a capias, it was returned, bond was filed, so he was out on the bond when he picked up the new charge. Anything from the state on the no valid DL?
No, Your Honor.
I won't take any actions on that. He's set today, but I will appoint the public defender's office also. They should catch that. I'm sure they'll catch that out of the jail, yeah. And as to the DUI, anything further from the state on that one?
No, Your Honor.
I won't take any actions on that one, and I will, that bond will remain the same. Sorry, I thought they were failure to appear,
Yes,
and so I didn't know he'd ever been arrested. All right, so at this time, as to the new charge, sir, I do find probable cause. I don't see any witnesses here. And at this time, sir, you're to have no contact with the victim. Do you understand that, sir? It's a real simple question. Do you understand it, sir?
My wife. Yes.
You understand? No contact
Yes.
means directly
Yes.
or indirectly.
Yes.
Okay, sir. I'm also going to require you to maintain a separate residence. You are not to return to the scene of where this occurred. And I also am going to require you, sir, not to possess any weapons or firearms. Do you understand that, sir?
Yes.
Okay. Now, I need to make it very clear to you, Mr. Caraballo, sir, if you violate any of the court's order, the bond will be revoked. Do you understand that, sir?
Yes.
Okay, sir. I'm going to set bond in the amount of $2,000 at this time with those as the conditions of the release. And you do have the public defender's office appointed on all the cases.
Your Honor, Your Honor, two more conditions if I could. Sure. No drugs, no alcohol, and also DCF was
I
contacted.
just now noticed that's DCF. I'm, Mr. Caraballo, sir? I've got to have your attention, sir. I just, that's okay. No, I'll give you the time with your attorney. I just need, you must comply with any DCF. There were the children are involved, I mean, around. So you must you must comply with any DCF, and you're not to possess any alcohol or illegal drugs. Okay?
And, Your Honor, could you have the one-time return with law enforcement to gather any items?
I'll allow you to return one time with law enforcement to pick up your personal belongings, but when you do that, Mr. Caraballo, sir, make sure that you do contact them first. You know, don't just drive up in the yard. Contact them first, and then they will arrange the time and the place to meet you, okay? All right, the next case we have is Casablanca. I don't know of any witnesses here on that. Okay. Here. Because the PTR is a little, okay. Ma'am, if you'd raise your right hand to get sworn in, please. Do you swear to tell the truth and nothing but the truth, so help you God?
I do.
And would you state your name, please?
Allison Edwards.
All right, and at this time, sir, your name, please?
Daniel Casablanca.
I'm sorry, what was your name?
Daniel Casablanca.
All right, sir, at this time, you're here on a charge of battery, domestic violence in case number 2022 MM2059AO. And at this time, does the state wish to inquire?
Yes, Your Honor. Good morning, ma'am. How do you know the defendant?
He's my husband.
Can you step closer to the mic and speak up just a bit?
He's my husband.
Do you live together?
Yes, in Kansas.
Okay. Has something like this happened before?
No.
Are drugs or alcohol involved in this incident?
No.
While the case is pending, do you want to continue living together?
No.
Are you afraid of him?
No.
Okay. I have no further questions, Your Honor.
Okay. At this time, sir, I'm going to require you to have no violent or hostile contact with the victim. Do you understand that, sir?
Yes, ma'am.
I'm also going to require you to maintain a separate residence at this time. While you all can have contact, you cannot live together. Do you understand that?
Yes, ma'am.
And I'm also going to require you not to possess any weapons or firearms.
Yes, ma'am.
And was there any other conditions you were requesting? No.
No.
Okay. And at this time, I will set your bond in the amount of I'm sorry.
Qualifies for pretrial release, given that he has no history, he is a military veteran. I'd ask for pretrial release, because he's out of state, he's gonna have to pay more money.
Would he qualify for pretrial release if he's out of state?
He qualifies, yeah.
Okay. Any objection on behalf of the state?
No objection.
Okay, we'll go ahead and order pretrial release without the objection, and, also noting that the victim testified. Now, understand, sir, that you do understand, sir, if you violate any of the conditions of the pretrial release, make sure you keep your court dates and all the conditions of that release, that if you do violate any of that, the court can revoke the bond or would revoke the pretrial release and set it at 0, okay?
He does live out of state, Your Honor, and, he's in the Army. Is he allowed to travel out of state? Lives in Kansas.
Sure, no objection to traveling out of state, yeah. Thank you. Oh, he didn't qualify, and I just now saw that.
For a PD?
Yeah, he didn't qualify for the public defender. Can we bring him back in?
I kind of figured.
Sorry, I just now realized that little yellow sticker was there. Guess I should kind of look. I don't see any more. Sir, you don't qualify for the public defender. They were acting, I'll just say, as a friend of the court. Are you going to hire your own attorney, sir? You don't qualify.
Yes, son.
Okay, well, have that, you're hiring your own attorney. Just make sure you keep look in the clerk system, keep track of any court dates. And when you do get the pretrial release, stay in contact with them because they'll also keep track of your court dates. So don't get there and then don't show up because they'll issue a warrant and get you arrested and, there. So make sure you just keep track of that. And if you're not able to hire an attorney or if circumstances change, the court can always reevaluate your qualifications for that. Okay? So it doesn't qualify. All right. The next case we have is Noel Crispin. I don't know if we have any witnesses. Noel Crispin. You're welcome. Sir, your name, please? Mr. Crispin, sir, you're here in case number 2022 MM 2076 AO. This is a charge of battery, domestic violence. I reviewed the charge and affidavit. I do find probable cause. You do qualify for the public defender. I will appoint the public defender's office to represent you on the matter. And at this time, I don't see any other witnesses, I don't see any witnesses here. At this time, sir, I'm going to require you to have no contact with the victim. Do you understand that, sir? And I see that you've signed the no contact order here in court. Do you understand that? All right, sir. I'm also going to require you to maintain a separate residence, not return to the scene of where this occurred, and also not to possess any weapons or firearms. And so those will be the conditions of your release. And at this time, sir, I will set bond in the amount of $1,500 with those as the conditions of your release. Okay?
And Your Honor, can we have the one-time return with law enforcement?
Sure. I'll allow you to return one time with law enforcement to pick up your personal belongings. And when you do that, do make sure that you contact them first. I know I sound like a broken record in here, but everybody's not hearing me. Coming in separately, of course. Make sure when you do that, you contact them first. Don't just drive up there and contact them. You have to contact them first, and then they tell you where and when to meet to then go get your items. Okay? All right. Thank you. And once again, I know you all know we've been doing, if there's anything I need to be apprised of, if either the state or the defense would just say judge, and I just don't ask individually each time. Mr. Jackson, I believe?
Yes, ma'am.
All right, Mr. Jackson, sir, your name, please?
Byron Trevor Jackson II.
All right, sir, you're here in case number 2022 MM 2064 AO. The charge is battery, domestic violence. And at this time, sir, you do qualify for the public defender. And ma'am, if you would raise your right hand to get sworn in, please. Do you swear to tell the truth, nothing but the truth, so help you God?
Yes.
And would you state your name for the record?
Krista Hefner.
All right, and does the state wish to inquire?
Yes, Your Honor. Good morning, ma'am. How do you know the defendant?
It's my brother-in-law, my sister's husband.
You live together.
So I live there and my sister lives there and he lives there when they come over like every week, like for 4 days. They basically live in both places.
I'm sorry, I'm not able to hear, and I know
Can I
what
put it
happens
down?
is, that's okay. And what happens
here?
is, let me just explain. Everybody, and rightfully so, turns their head to make sure the
But I
state
look towards
hears.
you.
But we all need to hear, so if that's okay.
Yeah, so basically my sister and him have residence in his mother's house in Mount Dora, but his job is closer to my dad's house where I live.
Right.
And Tiffany, my sister, she babysits at my dad's house. So it's more feasible for them. They go on weekends to his mom's house, but they basically live in my dad's house too.
Okay.
They have a room in there that's for their baby. And it's gotten really territorial, and to the fact it's just really territorial. I don't feel comfortable in my house, in my dad's house. It's really toxic, and this was just something spitting on me was just, I know it's very simple, but it's a lack of respect. And if you can spit on somebody, and he cornered me in like the doorway, and it's just, I can't stand feeling Like somebody.
So the question, I
doing
think,
that,
what the
yeah.
state was asking is do you wish to have contact with him?
No.
I thought so. Okay,
No.
so based upon,
Yeah.
I'll let you
I
conclude.
have no further questions, Your Honor.
Okay. I think that's what where you were going as you were
Yeah.
explaining that you're not comfortable and you
Yeah,
don't want to
and
have
I
him to
feel
have
like
contact.
it's so territorial. I'm not even like it's just you don't feel like comfortable in my house.
Sure.
Okay. And I'm pregnant right now, and I've been really stressed out with this.
All right.
And it's just yeah.
Okay. Well, thank you for your testimony today.
But yeah, I know he's a good guy. I don't feel like he's a horrible person.
Right.
There needs to be a standard and there needs to be a boundary, and boundaries have been broken, and I don't need people in my face.
That's okay. We're going to address this now, okay?
Okay.
Thank you.
Thank you.
All right. At this time, Mr. Jackson, sir, I am going to require you not to have any contact with her. Do you understand that?
Yes, ma'am.
And I am going to require you to maintain a separate residence from her. Do you understand that?
Yes, ma'am.
So you now have to make the move, it's not her, and you're not to return to the scene of where this occurred. Do you understand?
Yes, ma'am.
Okay. I'm also going to require you not to have any weapons or firearms. Do you understand that?
Yes, ma'am.
Okay. And at this time,
Your Honor, he does qualify for pretrial release. Given
Okay.
he has no history, I would ask for pretrial release.
any objection?
No objection.
Okay, I'll order the pretrial release without objection, but the conditions are the same. It just doesn't.
Yeah, so he'll get pretrial.
Right, you'll get pretrial release, but those conditions that I've just ordered that you've heard me announce here in open court. Okay?
Okay.
Thank you.
Thank you. And I was
Yep.
sorry, I was just wondering. It's weird that somebody would just spit or like. It's a weird thing. It just seems a little psychotic, and so it's.
Well, you've got the state attorney's office is the prosecuting authority, so I'm sure they'll be in contact with you. No contact, maintain a separate residence, do not return to the scene, and no weapons or firearms in the pretrial release.
In the one-time return.
In the one-time return with law enforcement.
And no contact. How far of the?
He can't have any contact with you.
Okay.
He can't go back there.
Okay.
But I've got everybody going. Let me just take one moment. Ma'am, let me explain some things, because I know you've got a lot to say, which is great, and that's fine, but I just need to make sure my order is completely understood by him too, okay?
Yes.
So there's no contact. He must maintain a separate residence. He cannot return to the scene. He can go back one time with law enforcement, and I'm going to look at him because the order's for him. One time with law enforcement to pick up personal belongings. Don't just go there. Call them in advance. They arrange the time and the place for you to do that, and you're not to have any weapons or firearms, okay? And I'll order
Gotcha.
the pretrial release without objection. Okay. Thank you, and the
Thank you.
state will be contacting you, I'm sure. All right, your name, please?
Yara Kudrowski.
At this time, ma'am, you're here on a charge as follows, and the charge is battery domestic violence. At this time, I do find probable cause. You do qualify for the Public Defender's Office. I will appoint them to represent you. And you are out on bond on a case also that I believe you were given.
Your
Honor.
Ma'am?
Is that, okay, pretrial diversion, so.
Yeah. Yeah, I'm not on bond.
I
on
see
anything.
that.
Okay.
Okay, I've got Your
I
Honor.
was just wanting to place on record, if you can just take no action on that, that FAT was
Right.
placed in.
I know, I got it, I'm there. I thank you, though, for help, giving guidance on those, because I appreciate. At this time, I'm going to appoint the Public Defender's Office to represent you. I'm going to take no action on the pretrial diversion case. They probably are going to remove you from that. I'm not the state attorney's office, but I believe that is quite often. I believe that's quite often what they do. So no action under 2021 MM 226AA, okay? As to the new charge, 2022 MM 138AA, I do find probable cause, Public Defender's Office is appointed, you're to have no contact with the victim, do you understand that?
Yes, ma'am.
You also are not to have, you also are to maintain a separate residence, do you understand that?
Yes, ma'am.
I'm also going to order you not to return to the scene of where this occurred. Does she need a one-time return?
Yes, Your Honor, they reside together.
Okay.
Yeah, he moved out last night. That's my house and my name.
Well,
But he moved out, though.
Yeah, at
Did I
this-
get the one-time return with law enforcement?
Sure.
Thank you.
If you've got to maintain a separate residence and you can't return to it. So even if he's moved out, there's going to have to be another hearing for that court to make that determination. But I will allow you to return one time with law enforcement to pick up your personal belongings. But when you do that, contact law enforcement. They will arrange when and where to meet you, okay? Don't just go there and contact them. That would be a violation. I'm also going to require you not to possess any weapons or firearms. Do you understand that?
Yes, ma'am.
And at this time, I will set the bond at $750 with those as the conditions of your release. Okay?
Your Honor, DCF was involved in this incident, or notified of it, I should say.
Okay. I'll also require, if DCF is involved, the Department of Children and Family Services, to comply with any of their recommendations.
Yes,
To
ma'am.
comply with DCF. Okay?
Yes, ma'am.
Thank you.
Thank you.
Oh, you weren't? Oh. Well, I mean, I know you did, but I thought you got back in time for it. Your name, please?
Siobhan Lee.
Miss Lee, you are here on a charge of battery domestic violence. This is in case number 2022 MM2060AO. I reviewed the charge and affidavit. I do find probable cause. You do qualify for the public defender. And good afternoon, or good morning. We're not at the afternoon yet. We're getting closer. If you'd raise your right hand to get sworn in, do you swear to tell the truth, nothing but the truth to help you God?
Yes, ma'am.
And would you please state your name for the record?
Benny Roach.
All right. At this time, does the state wish to inquire?
Yes, Your Honor. Good morning, sir.
How are you, ma'am?
How do you know the defendant?
We have 2 kids together.
Do you live together?
No, ma'am.
While this case is pending, would you like to have contact with her?
We both need to contact with our kids. We got kids we're trying to raise.
Okay. If the contact was through a third party, would you be okay with that?
One of our kids have a special need, and I basically take care of the older one, which is one with the special needs.
Okay.
Talk a little
She has the baby, so
Your Honor, I apologize.
need to talk
Sir,
about.
the judge can barely hear you.
I'm sorry.
That's okay. That microphone, as I say, everybody turns and so it gets shifted that way. And
sorry.
so I just didn't hear, I mean, I heard you say, just go ahead and repeat. I don't want to put
One
words
of our
in your mouth.
kids has special needs,
Right.
and I see about him. He stays with me most of the time.
Okay.
She keeps the younger one. So I wish this never happened to begin with. I wish it would just go away.
Right.
But she get mad at me. I'm a knucklehead sometimes. So she harmless. She's
So I guess this is the question is that if the court orders no violent or hostile contact, in other words, you all can have contact with each other, as you need or as necessary, but she can't have any violent or hostile contact. Is that what you're requesting from the court?
yes, ma'am.
Okay. And I believe you said you do not live together,
No,
so
ma'am.
there's no maintain a separate residence.
Yes,
Because
ma'am.
it's your residence and she lives somewhere else.
Yes, ma'am.
And was there any drug or alcohol
No, ma'am.
involved at this time?
No, ma'am.
Okay, I don't know if the state had any other questions?
Nothing from the state.
Okay, thank you.
Did she get released today?
Well, we're gonna talk about the conditions of her bond at this time.
No questions, Your Honor.
Okay, thank you. And not necessarily have been going back and forth, but I know you will speak up if you do. All right, at this time, what I'm gonna order at this time, Ms. Lee, is that you have no violent or hostile contact with him. Do you understand that?
Yes, ma'am.
And I'm also gonna require you to maintain a separate residence. Do you understand that?
Yes, ma'am.
I mean, you don't live together, but now it's a court order. And I'm also going to require you not to possess any weapons or firearms.
Yes.
Okay. And does she qualify?
Yes, Your Honor. I would ask for pretrial release given the victim's testimony.
Does she qualify pretrial? She does. Any objection on behalf of the state?
No objection.
I'll order pretrial release, but the conditions are the same. You'll be under a pretrial release program through corrections, so you don't post a monetary bond, but you still have to comply with all the conditions. And so at this time, I will order that with those as the conditions in addition to the pretrial release. Okay?
All right, thank you.
Thank you. Thank you, sir.
Yes, ma'am. Y'all have a good day.
Your name, please?
Nancy Letourneau.
Ma'am, you're here on a charge of battery. You do qualify for the public defender. I will appoint them to represent you. This is in case number 2022 MM 2058AO. And at this time, as I stated, you do qualify for the public defender. I do find probable cause. I'm going to require you not to have any contact with the victim in this matter. Do you understand that?
Yes.
Okay, I'm also going to require you to maintain a separate residence, not to return to the scene of where this occurred. And I'm also going to require you not to possess any weapons or firearms.
Your Honor, could you have the one-time return with law enforcement?
Yes.
I believe they reside together.
All right, I will allow you to return one time with law enforcement to pick up your personal belongings. But when you do that, make sure you contact law enforcement first. Don't just go there, don't just show up. Make sure you contact them first, and they will arrange where and when to meet you to get those items, okay?
Yes.
And at this time, I'm going to set your bond at $500 with those as the conditions of your release.
Your Honor, my client's not working. Her last conviction was in '73. She qualifies for pretrial release. I would ask for pretrial release in this case.
Does the state object?
No objection.
Okay, and she does qualify?
Yeah.
You don't need the victim's contact anymore?
No, Your Honor.
You don't? Okay. At this time, I will allow the pretrial release without objection from the state, and obviously noting that she qualifies. Okay? Because used to, I think they had to have the victim agreement or something along.
Thank you.
You're welcome, but make sure you comply with the court's order, okay? All right. Your name, please?
Michael Riley.
You're here, sir, on a charge of battery, domestic violence. This is in case number 2022 MM 2077AO. And if you would raise your right hand to get sworn in? No.
Sorry.
Oh, you just couldn't figure out your.
Yeah, I have to turn around and do it. I learned different in school. Sorry.
That's okay. I just wanted to make sure we got you in the right direction here. Do you swear to tell the truth? Nothing but the truth to help you God?
Yes, ma'am.
And would you state your name for the record?
My name is Angeline Riley.
Okay, and at this time, I know you've sat here long enough and have seen the state's going to ask you some questions, okay?
Yeah.
Good morning, Ms. Riley.
Good morning. Sorry.
It's all right. How do you know the defendant?
He's my husband.
Do you live together?
We do.
While this case is pending, would you like to continue living together?
Yes.
Are you afraid of him?
No.
Has
Sorry,
something like
no.
this, has something like this happened before?
It has, but I have PTSD and I'm on a medication called Latuda. This happened a couple months ago, but it was backwards and there was no alcohol involved. I Baker acted myself with the officer and we went and took care of that. Since I've been on the Latuda, it's been fine. But the past 2 weeks, I've had trouble getting my prescription paid for. I have the money today. I got all of it today. So I'm literally leaving here and going to Rite Aid. But he drank a little bit last night, and with me being like I am and with him being like he is, this week it was a really rough night. So, based on my meds, and he's usually really calm. He's not the aggressor in any of the situations ever. Usually I used him to deter that, but last night was not a good night for either one of us.
I have no further questions, Your Honor.
No questions, Your Honor.
All right. At this time, so what I'm hearing is that you don't object. You have no problem with him returning to the house or you all residing together. Is that correct?
No, ma'am, I don't have an issue with that at all.
Okay. And you're not in fear of him?
I'm actually in fear of being without him.
Okay. Okay. But you're not in fear of any contact that, any kind of actions from him?
No.
All right. And I'm glad that you got your medication sorted. That's very important. And
It's
for
the only
you, your
medicine that's
well-being.
worked in 22 years. No.
Okay.
Since I was like 7. So yeah, I love it.
And Your Honor, he does qualify for pretrial release. Given he has no history, I would ask for pretrial release and the victim's testimony.
Correct. All right. Any objection?
No. Objection.
At this time, Mr. Riley, sir, without objection and noting the victim's testimony too, I will require you to have no violent or hostile contact, sir, with the victim. I'm also going to require you, sir, not to possess any weapons or firearms. And I'll go ahead and allow the pretrial release to be the form of release based upon your qualifications and without objection, and in addition to the victim's testimony. Okay? Just make sure you're in full compliance throughout the court with those conditions. All right. Thank you, ma'am.
You're welcome.
We then have, we had a busy morning, haven't we? Yes. Tell everybody I got the luck of the draw, didn't I, today? Mr. Roman?
Yes.
All right, Mr. Roman, sir, you're here in case number 2022 MM2071AO. This is a charge of battery, dating violence. And, ma'am, if you would raise your right hand to get sworn in, do you swear to tell the truth, nothing but the truth, so help you God?
I do, Your Honor.
And your name, please?
Jade Paler.
All right, and at this time, I've reviewed the charge and affidavit, and just for the record, everybody, I know some of these I've said I've reviewed the charge and affidavit on every case and have found probable cause on every case at this point, and just want to make sure that's very clear for the record.
Thank you.
And so at this time, does the state wish to inquire? And the PD is appointed under this case also.
Yes, Your Honor. Good morning, ma'am.
Good morning, Madam Attorney.
How do you know the defendant?
He's my romantic partner of the last 5 years.
Your Honor, can you hear her?
I can.
I apologize. Can you hear me clearly now?
That's okay. Yes, that's fine. Thank you.
He's my partner. We've been together for the last 5 years.
Do you live together?
Yes, we do.
While this case is pending, do you want to continue living together?
Yes, absolutely.
Are you afraid of him?
No, not at all.
Were drugs or alcohol involved in this incident?
No, there were no drugs or alcohol involved in this incident, but he does have a medical condition that reduces his level of oxygenation from his heart. And we advised the responding officers on scene that this was a medical crisis, and they did not take any of his medication with him upon picking him up because he was not able to make rational choices. We advised that he was not giving rational information to the police. However, they did not take that into account, even though I had the records there. So no, there were no drugs and alcohol involved. However, he does have a medical condition that did affect his behavior.
Okay, thank you. Has something like this happened before?
No, never.
I have no further questions, Your Honor.
Okay. What I'm going to require, Mr. Roman, sir, is that you not have any violent or hostile contact with the victim. Do you understand that?
Ma'am.
And the public defender's office is appointed, and at this time, anything further? I believe he does qualify for.
I would just ask for the pretrial release, given he does qualify and make his testimony, Your Honor.
Any objection on behalf of the state?
No objection.
I will then order the pretrial release with those conditions, you know, of no violent or hostile contact, no weapons or firearms, and the PD is appointed. Okay? All right, thank you. Thank you, ma'am.
Thank you, Your Honor.
Your name, please?
DeAndre Shaw.
Mr. Shaw, sir, you're here on a charge of battery domestic violence. I've reviewed the charge and affidavit. I do find probable cause. You do qualify for the public defender, so I will, I will appoint the public defender's office to represent you. At this time, I don't think there's any witnesses here. Sir, I'm going to require you not to have any contact directly or indirectly with the victim in this matter. I know your relationship, but you still cannot have contact. Do you understand that?
Yes, ma'am.
I'm also going to require you to maintain a separate residence from her. Do you understand that?
Yes, ma'am.
And also not to have any weapons or firearms. Do you understand that?
Yes, ma'am.
Is there anything further from the state or the defense?
Nothing from the state.
Nothing from defense, Your Honor.
At this time, sir, I'm going to order your bond set in the amount as follows. I think he has some detainers from out of county also. But as to this case, sir, I'm going to set bond in the amount of $750 with those as the conditions of your release. Okay? Is that satisfactory to the state? He's got the holds and the, and,
Yes, Your Honor.
okay, everybody, I think we now are on the out of county, so we'll probably move a little quicker. Your name, please? EDs don't get appointed on these, do they? Okay. I'm sorry, what was your name?
Alexis Banks.
All right, at this time, you're here, this is an out-of-county warrant.
Yes, ma'am.
And so this is, and the bond on that has been set in the amount of, let me just look, no bond. And this is out of Lake County, and they are given 24 hours to pick you up. And so they've been, they have been or either will be notified to pick you up. And if there's no other holds here, they'll be able to pick you up. Okay?
Extradited.
Yeah, you'll be sent, yeah, they'll take you back to Lake County, okay? You're welcome. So are these our court cases? Do they get case numbers? That's what I thought. I gotcha.
They give us one.
Right, so do I say those out loud? Okay. All right, sir, your name, please? Sir, you're here, this is another out-of-county warrant. This warrant is out-of-county, just take 1 second. This is out of Broward County, sir. That court, this is in case, their case number 2010, 62 CF 10A is their number that they have listed. At this time, sir, that bond has been set by that court in the amount of $1,000 under count 1 and $1,000 under counts 2. Okay? If there's no local hold, sir, you've got a bond on these. If you're not able to post the bond, then they will be notified to get you picked up and sent back to that county. Okay? All right. Thank you, sir. Oh, gosh, I almost put yours in theirs. Oh, are those the do you all keep those? But are those originals, those? Yes. So you all are glad I didn't mark them all up. Those you do? Oh, okay. Your name, please?
Good morning, Ashley Costin.
At this time, ma'am, you're here on a charge. This is an out-of-county warrant. The bond has been set at none. And this is a warrant out of Seminole County. They'll be notified to pick you up. And if they do not, you'll be reset here, but they get notification to pick you up. Okay? As long as you have no local holds. Thank you. Your name, please?
Ashton Doucette.
What was your last name?
Doucette.
You're here on an out-of-county warrant. Also, this is their case number S22000826. They're just so different than our numbers, aren't they? At this time, the court has set those bonds. These are out of Marion County. The court has set those bonds at none. We do show that you're out on bond, I believe, everybody, on a Orange County case, but I'm not going to take any, does the state agree no action on that?
Yes, Your Honor.
Okay, the court takes no action. Your warrant was issued out of county, and so I won't take any action on that one. Okay?
Thank you.
You're welcome. Your name, please?
Desiree Dumas.
Dumas, Ms. Dumas? Ms. Dumas, you're here on a charge as follows. This is a matter of an out-of-county warrant also. And at this time, that warrant is out of Alachua County. They have set your bond at none under both of those matters. They'll be given notification to come pick you up also, okay? As long as you don't have any local holds. Thank you. Why am I all of a sudden wanting to put that there? I don't know. Your name, please? Mr. Rodriguez?
No, Anthony Rodriguez, he had been bonded out.
He did bond out?
Yes, ma'am.
Okay, thank you. Your name?
Mark Ciampa.
I'm sorry, what was your name?
Ciampa, Mark.
Mark, okay. You're here, sir, under case number 2020 CF 181AO. This is a violation of probation. You do qualify for the public defender. I will appoint them to represent you on the matter. That bond has been set at none, okay? So you'll be seen by the the violation of probation judge that handles those. Now we got a system. We don't need it. Just took me a second to get that system going. All right, you want to come on up, please? Your name, please?
My name is Trevor Dolan, Your Honor.
Mr. Dolan, sir, you're here on a charge also of a violation of probation, sir. That's in case number 2020 CF 14757. You do qualify for the public defender, sir. At this time, that bond has been set at none, and you'll be set in front of the violation of probation hearing, okay?
Okay, thank you.
You're
Your
welcome.
Honor, he should have another case.
You should have another case. Oh, Mr. Dolan, you've got two cases. Sorry about that. You've got two VOPs. That bond remains the same. That's in 2021 CF 220AO.
That's a criminal mischief.
Well, just a minute. You've got two cases. Both of them, the public defender office is appointed, sir. And on both of those, the court set the bond at none, though. We just want to make sure we get you I-8 on both of them so they both can be set,
Yes, ma'am.
for court. Thank you.
All right, thank you.
Your name, please?
Cornelis Trey Hickson.
Mr. Hickson, sir, you're here also on a violation of probation, sir, and you do qualify for the public defender. This is in case number 2021 CF 3724AO. That's the case number, sir. That bond has been set at none, and the case will also be set for a violation of probation hearing. You have another case, no? Yes, you have another case, and that is also a violation of probation, sir. Case number 2021 CF 2807AO. And that court also issued the no bond on the matter, and the PD's appointed on that case also. I'm not catching these because they're all stapled. I mean, they're all, yeah, they're paper clipped in one. They're not, I got you.
No.
Now I got a PC. Okay.
It's for quality vehicle, so you have more than, so you look at all these vehicles.
All right.
James Houston is in the hospital, Your Honor.
He's in the hospital, James Houston. Okay, you want to reset that, everybody, or?
No, I will waive the appearance, Your Honor.
You'll waive the appearance?
Yes.
All right, Public Defender's Office is appointed, appearances waived. As to CF 2021 3539AO, that's the violation of probation. That bond will remain, oh wait, is that an on view? No?
Yes, Your Honor.
Is that an on view, everybody?
Mm-hmm.
Okay, let me just. Okay, I do find an on-view violation of probation, and at this time, that bond will be set at none. Obviously, if they filed, then it'll supersede this one. As to 2022 CF 3552AO, I do find probable cause, and that bond will remain at $1,000. Okay? And public defender is appointed on both of the cases, and appearance was waived. Good morning. Your name?
Matthew K.
Mr. K, is that correct? Okay. Mr. K, sir, you're here on a violation of probation, sir. That is in case number 2019 CF 1545AO. The court that issued the warrant set the bond at none, and
Your Honor, I believe it was set at 2,500 is what,
oh, that, you are absolutely correct. I've got the one underneath it, 2,500. Does he qualify for the public defender? Mr. K? Mr. K, sir, you do qualify for the public defender. I just want to make sure I get them appointed. You do have a bond on the matter. Make sure you keep all your court appearances if you're able to post that bond, okay?
Okay, thank you.
Thank you. Your name, please? What's your last name?
Moya.
Mr. Moya. Mr. Moya, sir, you're here on a violation of probation, sir.
Ma'am?
This is in case number 2017 CF 1535 96 AO. Yes, and you do qualify for the public defender. I'll appoint them to represent you, sir. And at this time, sir, that court has set the bond at none on the matter, at 0. Okay?
So I don't know this system.
I said, God, I'm like, some I see, some I don't.
Sorry, sign anything? Good afternoon, Your Honor.
Good afternoon, sir. Your name, please?
Eric Sebastian Torres, January 17, 2000.
All right, Mr. Torres, sir, you're here on a violation of probation, sir.
Yes, Your Honor.
This is in case number 2020 CF 5155AO. You do qualify for the public defender. I will appoint them to represent you on the matter. And at this time, sir, the bond is set at none. Okay?
Yes, ma'am.
All right, thank you.
By any chance, do you know when my next court date will be or no?
They're pretty quick on the VOPs on the, because they're done here out at the, at BRC, but I don't really have a date to give you, but I think they're usually within a week to 10 days.
All right, thank you.
From my memory. Give or take, thank you. Am I close to that date?
Yes.
Okay.
Yes, you're correct.
Oh, yeah.
All right. Your name, please?
David Demings.
Mr. Deming, sir, you're here in case number 2021 MM3022AO. And at this time, this is a misdemeanor battery, domestic violence violation. Bond has been set at none. Do you wish to have the public defender's office appointed to represent you?
Yes, please.
All right, so, and you're set at no bond, so you're not going to be working for at least till you get in front of that court or get the case resolved. So at this time, I will appoint the public defender's office to your bond being at none at this time, okay?
Thank you very much.
And does he get a date?
I will,
Oh.
can you bring it back? I will enter denial.
Okay, it's a domestic.
Division 50, BOP status, May 6th at 9 o'clock, courtroom 7C.
I don't need to. I mean, I don't want to change it. You know, I mean, yeah. Your name, please?
Frank Sanchez, Your Honor.
All right. Mr. Sanchez, sir, you're here on a violation of probation, sir. This is in case number 2020 CT 495AO. You do qualify for the public defender, sir. At this time, the court that issued that warrant has set your bond at none, and I've appointed the public defender's office. Do you wish to go ahead and enter a denial and get a date?
Yes, Your Honor.
All right. All right. You're welcome, sir. They're gonna enter a denial, your attorney, rather, has entered a denial, and we're gonna get you your date, okay?
Your Honor.
Division 63, BOP status, April 20th at 9 o'clock, courtroom 10B.
All right. Thank you, sir. Now what do I do next? Do we have a lot this afternoon? Yeah, yeah. Not crazy, though, was it? I mean, not like, I think the DV. All right, everybody. We will stand in reset. I'll wait till she gets. How much time do you all need? I haven't looked at anything, but I mean, how much time do you all need? You all
1
want-
o'clock, please, Your Honor.
1 o'clock? I understand, everybody. No, it,
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Luis Moreno Ortiz.
Luis Moreno Ortiz.
Mr. Ortiz, sir, you are here on the following case. It's case number 2022 CF 3522AO. This was a charge of a petty theft, having a prior petty theft conviction. An arrest warrant was signed, setting the bond at $15,000, and you're not to return to the scene of where this occurred. You do qualify for the public defender, so I have appointed them to represent you on the case, okay?
Oh, thank you, yes. Thank you.
The attorney. Sir, your name? Wait,
Su nombre, por favor, señor.
I think that concluded. Okay, they're telling me that concludes the case that we have that need an interpreter.
Thank you, Your Honor. You have a good afternoon.
You do the same.
Bye-bye.
Thanks again, and great.
Thank you.
Great hearing you.
Thank you.
Okay, your name, please,
Jonathan Costello,
and your date of birth.
4802.
Okay. At this time, and counsel, your name?
Ashley Parker on behalf of Mr. Costello.
Okay. At this time, Mr. Costello, you're here on an arrest warrant that was 5 counts: aggravated battery with a weapon, robbery with a firearm, grand theft of the 3rd degree, battery, and criminal mischief. Probable cause has already been found, and part of that included no contact with the victim, the witnesses, or the defendant, no return to the scene of the offense, and to surrender and not to possess any weapons or firearms. Okay, and I think the robbery with a firearm is got to pull the, counsel, do you wish to be heard? I don't know if you've talked with the state. I believe it's.
Yes, Your Honor. I've spoken to the state. I hope that they are in agreement. The robbery with a firearm, Judge, it is a first-degree felony, but it is punishable by life. We'd ask the court to exercise discretion and set a bond in the amount of $10,000 on that charge. Mr. Costello is 19 years old. He has no prior criminal history, no prior failure to appears. He resides in Kissimmee. He's been down here for at least the past 3 years. He has ties to the community. He has family who lives in Winter Garden. He has some family present here today, but they were not permitted to come up to the courtroom. He's a business owner.
Well, what do you mean they weren't permitted?
They're outside, but I don't believe that they were allowing witnesses to, or family to come up when they weren't witnesses.
Oh, okay. I don't know what corrections policy is, but if there were a witness.
Yeah, no, they're not witnesses or
Okay, I
victims.
understand.
They were just here in
They're
support, Your
just
Honor.
here. Okay.
The risk assessment results that I received showed that, show low. If you review, I understand probable cause was found, Your Honor, but if you review the affidavit for the arrest warrant, the allegation is not that Mr. Costello, possessed a firearm, brandished a firearm. It seems, at most it was a battery that turned into one of the people who was involved brandishing a firearm.
Let me just read it, if you don't mind.
Sure.
What happened on a couple of these, we tried to download them, and in my office, I don't know why I'm not able to. We printed most of them, but this just happens to be one of the ones that I was not able to review.
And I have a copy, Your Honor, if you'd like me to
Okay,
approach.
I'm fine. What were you saying about the firearm?
Your Honor, the allegation is this is an incident involving 3 people from one party, 5 people from another. There was a battery, in a restaurant. I think, again, taking the affidavit for the arrest warrant is true, that, Mr. Costello, his involvement was really maybe a battery in the restaurant and then potentially a criminal mischief in the parking lot as far as striking a vehicle. But it seems like these 2 groups of people were involved in an altercation. One of them, in the police report, or the affidavit, alleges an Alan Costello threatened the victims and brandished a black handgun. So, again, it's not my client who's alleged to have possessed a firearm, brandished a firearm. he was just simply present. I know that there's some case law, Your Honor, and again, we're not in trial, but, you know, presence or knowledge at the scene of this going on is really insufficient to establish his participation in, you know, the robbery or.
But PC's already been found. So
Correct,
it's
Your
not
Honor.
that issue. The question is if bond is appropriate, and you're just saying, not just, your argument to the court is that based upon the facts presented as to this defendant, you are requesting that the court exercise its jurisdiction and grant a bond as to count 2.
Correct, Your Honor.
Okay, all right. Does the state wish to be heard?
Yes, Your Honor. I have reviewed the affidavit. Based on his age and lack of criminal history, I do not object to the court using its discretion. However, I would ask for more than $10,000 bond. This is punishable by life. This offense is punishable by life. It also appears that they knew each other, Your Honor, and it was an ongoing incident, started in the restaurant and then proceeded again to the parking lot. So based on that, I would ask for more than the $10,000 bond, Your Honor.
Okay. Let me pull his sheet here. Did I have his sheet pulled out of order? Oh, thank you. Got it. Thank you. All right, I do know that he has no prior history. At this time, the court will exercise its discretion. The bond as to count 1 will remain the same at $10,000. As to count 2, the robbery with a firearm, the court will set the bond at $10,000. The bonds will remain the same under count 3, $2,500, count 4, $500, and count 5, $500. Now, you are to have absolutely no contact with the victims or witnesses or co-defendant in this case. Do you understand, sir?
Yes.
And you understand, sir, you violated any of this court's order, the bond will be revoked and set at 0. Do you understand?
Yes, Your Honor.
Do you also understand that you are to possess no weapons or firearms?
Yes, Your Honor.
Do you also understand you are not to return to the scene of where this occurred?
Yes, Your Honor.
Were there any other conditions that are requested by the state? I think I've covered them, but
No, Your Honor, that's pretty much it.
was there anything further from the defense?
No, Your Honor.
And the court does note the total bond will be well in excess, or almost $25,000 total. Surrender any firearms within 24 hours. Okay? And you contact law enforcement. Don't just take them up there. Your attorney can advise you on that. All right, stay in contact with your attorney. And at this time, the bond is set as previously stated. Okay?
Thank you, Your Honor.
You're welcome. Thank you.
Thank you, Judge. Have a great day.
You do the same. Thank you. Okay. Do I talk or not? Oh, okay. You're just gonna. This needed a Creole interpreter, everybody. Jenna.
Creole interpreter present.
Yes, I'm here.
Okay. Have you been sworn in? I don't think they have. Have you been sworn in to the Creole interpreter?
No, ma'am. My name is Stewie. I'm the Haitian Creole interpreter. My number is 111546.
All right.
Do you solemnly swear to translate from Creole to English, from English to Creole to the best of your ability?
Yes, ma'am.
Thank you.
Thank you. Sir, can you tell us your name?
Monsieur, est-ce qu'on est capable de dire non?
Can you hear?
Est-ce qu'on entend? No, I can't. No.
Okay.
I don't hear. Est-ce qu'on est capable de dire non?
Your Honor, she's not responding
Right.
to any English or Creole.
Right.
At this point, I would just ask that you stay the bond or set a bond. I don't know what else we could do at this point.
I'll appoint the public defender's office, and I do find PC, and the bond will remain the same at $500 with no return to the scene, okay? And that'll give your office opportunity to get your interpreter in and discuss. Thank you. What is everybody, I don't know who everybody is. I just know there's a lot of people here. All right, we have the Robinson Noel. I just don't know who's,
Yes,
is
Your
that
Honor.
yours? And did you come out this morning?
I did, Your Honor.
We're sorry, it was it just, my timing was off and
Oh, no.
everybody wasn't ready.
Perfectly fine. I tried to look online and I didn't see his name on either of the posted lists, so just in an abundance of caution, I came.
Okay, thank you.
Spencer Rhodes, on behalf of Mr. Noel, just making a limited appearance today. I've obtained a copy of the probable cause statement. I've reviewed it with Mr. Noel. We're not going to go forward with an Arthur hearing today. Talking about Mr. Noel, I'd suggest maybe a determination of counsel hearing be set in his case because he hasn't made a final determination about counsel. I'm assisting somewhat currently, but not retained fully. So.
Are you just acting as a friend of the court today?
Yes,
then?
Your
Is
Honor,
that what
I am.
you'd like to call it, just so it's clear, and then we'll set for determination of counsel. And I know you've been waiting, everybody's been waiting, which is fine. I just don't know who everybody is.
Yes, ma'am. Good afternoon. Tom Wazorek on behalf of the state of Florida. I'm responsible for this prosecution, Your Honor.
Okay.
That's why I'm out here this afternoon, just in the event that the court were going to reconsider the conditions of release set by Judge Barber, but since it does not appear that that's being requested, there's nothing further from the state.
And I'm not going to an Arthur hearing, we're not doing any of that. That to have any impact later on, I know that. So at this time, the court has reviewed, or another judge has already, Judge Barber has already found probable cause. At this time, the bond will remain the same at none. This is on a first-degree murder with a firearm, and the case number is 2022 CF 3445AO. Okay?
Thank you, Your Honor.
And what they do, you know, I know how it was when I was out here, but so I don't want to presume a lot. Do they set these for determination of counsels, or can we?
I was gonna ask you which date, and I'll put it on here. So when you set for that date.
Okay. How far out do you want to set this? I mean, it's
Probably 2 weeks, Judge.
2 weeks, okay. You know, give or take. I used to do that too. Is that okay with you, if that's said? I mean, I don't think you're going to need to be here for it, but, okay. And if Mr. Rhodes files his notice of appearance, and that will take care of that. Why don't we set it for April the 14th? That's 2 weeks out. Is that okay?
It's perfect. Thank you.
And Mr. Noel, sir, what was your name for the record, sir? I'm sorry?
Mr. Noel, he know pour record là.
She needs to hang up. Oh, okay, sir. We have the Creoles that didn't hang up. So at this time, we'll set, PC's been previously been found, bond will remain the same at none. Okay?
Thank you, Judge.
Oh, there are some conditions that are listed that I do need to pick up on at this time. And at this time, they are as follows. No contact directly or indirectly with the victim, the co-defendants, or the state witnesses. I think it's the state witnesses.
Yes, ma'am. That's
That would be it. Okay, so no contact with the state witnesses, no return to the scene, do not possess any weapons or firearms. And also, I think those were the conditions that she had ordered. All right?
And I would just like to state for the record, no state witnesses have been identified publicly.
Correct.
So in that case, Your Honor, what the state would recommend and request from the court is that the conditions of release, at least at this point, be modified, pretrial release conditions, because the defendant may communicate with people while in custody. He had not had communication with anyone who is listed in the affidavit for his arrest warrant.
And they're not identified by name either. It's witness 1, witness 2, witness 3. I'm anticipating a certain amount of investigation taking place over the next few days, which would involve,
It does say witness.
At this point, I think there are no civilian witnesses who have been identified by name in the affidavit for arrest warrant. So if necessary, then the state will just follow an appropriate motion.
Okay. So at this time, I don't want to change her order because I mean, there's nothing to change. Go ahead.
I have a different suggestion because the address where the offense occurred is listed in the affidavit for arrest warrant. So the state would request that the defendant not have any contact with anyone who was present at that address at the time of the offense. And the defendant should know, since he was there, who was there and who he should or may not have contact with. He does so at his peril that way.
and that's problematic because, of course, the defense has a right to investigate these matters as well.
Oh, Judge, I don't want, if there's counsel for the defendant, I don't in any way intend for that request to inhibit counsel from having contact with witnesses. Only the defendant should be precluded from having contact.
All right.
But how do I
That's
just
a
make an
condition of-
open-ended, I mean, an order should be followed, you know, so I've got to make sure that I'm clear on that. You know what I'm going to do? I'm going to leave it as per Judge Barber ordered in the arrest warrant. How's that, everybody? Because I'm guessing who those names are. I'm guessing who to add or who not to add. I'm adding locations. I think I mean, I know you both are very experienced, and I know you're going to advise your client, as a friend of the court, those parameters on this.
Absolutely.
Okay, so that'll just remain the same as previously stated.
Yes, ma'am.
Okay, is that all right with everybody?
Yes, thank you.
And by then, I suspect the next one, you'll have potentially some names, and if that can always be modified for those. All right. Thank you.
Yes, ma'am.
Thank you. Thank you both.
Thank you, Your Honor.
Good seeing you both.
Good to see you.
Your Honor.
Are we on a regular? Oh, did the interpreter know to hang up?
I don't.
Hello, Your Honor. No, I'm still here, but no, you haven't told me to hang up yet. I'm waiting for your word.
You can hang up, and we apologize because we realized that they were not able to go forward with some of the information. So thank you for hanging on, and thank you for assisting us today.
Okay, you're welcome, Your Honor. Thank you for using our service. Have a wonderful day.
You too. Thank you.
Okay.
What am I?
No, those are what we just did.
Oh,
The intel
okay.
units that we did.
If you have any per the court, virtual contact.
That's their verbiage for that division that automatically prints out. On
Okay, because I didn't order all that.
No, we didn't.
Okay, I think we're ready to get back on track. We've had a day that we've kind of just not been able to do that, haven't we? Okay, your name, come on. You want to come on up? Your name, please?
Kevin Barrow.
All right, at this time, Mr. Barrow, sir, you're here on a charge of loitering or prowling. And at this time, I have found PC, or I do find PC. You don't qualify for the public defender?
Your Honor, there was an offer of an adjudication, as a friend of a court.
Okay, great.
Adjudication of guilt, credit time served, and court costs. And Mr. Barrow would like to accept and enter a plea of no contest.
Okay, thank you. Is this the agreement of the state?
Yes, Your Honor.
All right, and it's 2 days credit for time served. At this time, Mr. Barrow, it's my understanding you wish to plead no contest to the charge of loitering or prowling. Is that correct?
Yes, ma'am.
Is this your signature on the plea form?
Yes, ma'am.
Did you read and understand the rights on the plea form? Did you understand those rights on the plea form?
Yes.
And you understand that by pleading today, you're giving up those rights? There won't be a trial, there won't be any defenses, that we will resolve the case today. And is that what you wish to do?
Yes.
Okay. Are you on probation for any other charge?
No.
Okay. At this time, I do find sufficient facts to take the plea. I will at this time accept your plea. I'll adjudicate you guilty, 2 days in jail with credit for 2 days' time served. You'll be released today under this case. And the court costs, what are they doing on the court cost a year? How much time?
Paying full within a year, and the total is $273.
No, no, I'm not going to appoint the PD. You just wanted to act as a friend of the court. I'll give you a year to make the payments, okay, to make it in full. You can contact the clerk to try to set up a payment structure, but if not, I've given you the full year, okay? All right, thank you. You have the right to appeal the sentence of the court, must do so in writing within 30 days. If you can't afford an attorney, one will be appointed to represent you, all right? Thank you.
Jonathan Bellamy refused, Your Honor.
Okay.
Your Honor, I asked that it be reset for tomorrow. There's an offer.
Okay.
Thank you.
I understand. Reset, state has extended an offer. So they know. All right. Next case. You, Mr. Howard?
Yes, ma'am, I am.
All right, Mr. Howard, sir, you're here on a charge of trespass by not leaving, failing to leave, and you do qualify for the public defender?
I would ask that you not be appointed. There is an offer to resolve of an adjudication of guilt, credit time served, and no return to 1171 East Plant Street. And Mr. Howard would like to accept that offer.
Okay.
And then as far as his out on bond in case number 2022 CF 576 AO, the state has not filed formal charges. He was arrested in January 16th of this year, and I would ask that you take no action since formal charges have not been filed.
Okay. The formal charges are not as persuasive as he's going to be resolving the case today.
Yes, Your Honor.
The new charge.
Yeah.
It's not that I won't listen. I mean, I want you to know that. I'm just, if he's resolving it, I won't be taking action on it.
Thank you, Your Honor.
And is this the agreement of the state?
Yes, Your Honor.
At this time, Mr. Howard, can you hear me okay?
Very well, thank you.
Very well. You're here in case number 2022 MM-189AW. The charge is trespass by not leaving when ordered to leave. It's my understanding you wish to plead no contest to that charge. Is that correct?
Yes, ma'am.
All right. And did you sign the plea form? Did you sign the form that they just handed me?
Yes, ma'am.
Did you understand the rights you're giving up by pleading here today?
Yes, ma'am, I ain't worried about them.
You know, okay. Are you on probation for any other charge?
I am.
You're not? Okay. And at this time, I'll accept your plea. I'll adjudicate you guilty. I'll sentence you to the 2 days you served in jail with the credit for those 2 days. You're not to go back to where this occurred. You cannot go back there
Oh, I
anymore.
won't, I promise you and me that.
Okay, well,
And them.
you can't, because you know you're going to get arrested.
I know.
So you're not to return to the 1117 East Plant Street in, was that in Winter Garden?
Yes, ma'am.
In Winter Garden. Okay? Now, there's court costs, and I'm going to give you a year to pay them. All right?
Okay, I'm in funds right now. I'm going to Kissimmee to try to get my disability there. Possibly left behind. I got.
Okay, well, I've given you a year, so if you know, what you need to do is, you know, maybe in a month or two, go down to the clerk's office and talk to them about what kind of payment you can make, okay?
Yes, ma'am.
And I will not take any action on the out-on ROR case.
Thank
All
you,
right.
ma'am.
Thank you, sir. I previously advised you of your right to appeal.
I bless you. Thank you.
Thank you, sir.
Okay.
Did I do Dorman?
We did.
Thank you.
Move up.
Oh, what did I just do? What did I do? I'm sorry. It doesn't matter, but what did I do with elderly? Did I do elderly? Was that reset? I don't. Maybe I did them, yeah. Your name, please? Jennifer Pumphrey. Ms. Pumphrey, you're here on a charge of prostitution. And at this time, this is in case number 2022 MM2082 AO. I do find probable cause, and at this time, I don't know if there's an offer.
No, Your Honor, there is no.
Didn't think there was. Bond will remain the same at $500, and you do have the public defender appointed, okay? Thank you.
You want to know return to the area? Usually the mapping zone?
Well, see, people don't know where these things are. I mean, to me, and
That's fine, Your Honor.
I get it. When they plead it in probation, we have maps that we give them, or used to give them. They probably don't anymore give them. I know, you're doing your job, but.
Your Honor.
Yes.
My client is currently disabled. She cannot post a monetary bond. She's been in the Orlando area for over a year. I would ask that her whole life, Your Honor. No, you're fine. I would ask that you consider an ROR in this case. I believe there's a program, that's why we can't resolve it today. There's a program that the state has that they can complete now for the prostitution. So I just ask that
Do
you.
they complete, do they get the charges dismissed?
There is a pretrial
Diversion?
Thank you. I just kept thinking detention, and that was wrong.
There's that too, but, I don't know if she'd qualify, but of course that would be up to the, that would
Yes.
be up for them. I do show their last history, it looks like she had it was Dwillis's, or a Dwillis rather, in 2018.
Yes, Your Honor.
And her last failure to appear looked like it was 7 years ago. Okay. She does not know where her mother's living. Where is she gonna go? Where's she gonna?
I got a friend I can go stay with at the mailing address I gave him.
Okay, that you gave the address on? All right. Does the state have any objection? Because if she doesn't appear, she's gonna get a revoked ROR and get picked up. I mean,
No objection, Your Honor.
Thank you.
without objection, I'm gonna go ahead and do ROR. But you need to understand, Ms. Felfer, you need to listen to me now. You don't appear, you don't appear. It's worse not to appear than to appear, because when you appear, your attorneys can make an argument for you and resolve it in your best, but when you don't, all that is lost, okay?
Very much.
All right, thank you.
Eric Ramirez is mental health, Your Honor.
Okay,
Your Honor, I will waive the appearance. However, I don't see a history, so I don't know if he would qualify for pretrial release. Could we have him at least screened for pretrial release, and if he qualifies? And then the alternative, you could set a monetary bond. He's not here, so I don't know what's his status financial.
I'm sorry, Your Honor. Would you better have him screened for mental health PTR? It's looking like he'll be better suited for that than straight PTR.
okay. So if he qualifies for mental health pretrial release or bond, is that how we can put that?
Yes, Your Honor.
Is that acceptable to the state also?
Yes, Your Honor. I think the wording is generally to be screened for mental health, pretrial release, and if he does not qualify, then you set whatever bond.
Okay. All right, at this time, I'll order mental health to be screened for mental health pretrial release, and if qualifies, mental health pretrial release. If not, the bonds will remain the same at $500 under count 1 and $500 under count 2. And I'll go ahead and appoint the public defender's office to represent. He didn't fill out one, but we know, why.
Thank you.
You're welcome. Okay. Your name, please?
Dwayne Lawson.
Okay. What happened with Daryl
He bonded, Your Honor.
Reyes Cruz bonded? Okay.
Carlos Beria.
Carlos Varias, did he bond? Okay, thank you. Okay. So we have done with the pleables. Okay, and I'm sorry again, what was your name?
Dwayne Lawson, ma'am.
Okay, what happened with Clifford Gray?
You already seen him, he was on the move up.
Oh, I moved him up, okay. See, that's why I have my little sheets here. I'm not sure which ones we've moved up. All right, Mr. Lawson, I've got your case, sir. You're here, sir, on this was a failure to appear. This is in case number 2017 MM 11624AO. I will appoint the Public Defender's Office to represent you, sir. That court set your bond at none, and so that'll need to go in front of that court for that determination. It was failure to appear for a violation of probation hearing, okay?
Excuse me, ma'am, can I,
No. Yeah. Oh, yes, yeah. So she wants to enter, do you want to enter a denial at this time then, so we can get them set quick?
I'll enter denial.
Division 81, BOP status, April 19th at 9 o'clock, courtroom 4E.
Did I do Rivers, or did Rivers bond out?
Yes, wait, Rivera
Marquise Rivers? Should I hand that maybe to you? Your name, please?
Kyle Smith.
I do too. I'm just going by this order, and it's. Okay. All right, Mr. Smith, sir, you're here on 3 cases, sir, and let's go ahead and go through those. 2 cases were failure to appears, so let's go ahead and go through that. And then you've got an out on bond, but let's do the failure to appears. First of all, they were 2022 MM 181 AW. The court set that bond, sir, in the amount of $500, and I'm sorry, that was not a failure to appear, that was an arrest warrant for petty theft, okay? And in that, they also have do not return to the scene of where this occurred. You then have a second case, sir, that was for another petty theft, and that was case number 2022 MM 184W, right? Okay, got it. And I'll appoint the public defender on that case also. And the court that issued that bond set bond in the amount of $5,000 with no return and no contact with the victim. The out on bond, I don't think there's any.
Attorney appointed, Your Honor.
There's not, is there? I'm going to get you an attorney on that case. Also, the CF 2022-2109AW. You're out on bond on that. You just 3-4. Let me make sure the dates that we have this. Yeah, these occurred after. So I will revoke the bond under 2022 CF 2109AO. Set that bond at none. But you got an attorney now on all the cases, okay? Because I do show he picked up the new charge while he was out on bond. Oh, yes, that's when we moved up. Your name, please?
Edric Vernon.
Mr. Vernon, sir, you're here on a charge of criminal mischief, sir. This was an arrest warrant, and I'm going to need to review the warrant, sir. Do you want an attorney appointed to help you, sir?
Yes.
I don't show where you filled out a form. You did. Okay, you qualify. You did. I'll appoint the public defender's office to appoint you on the case. And everybody agree he's entitled to a bond?
Yes, Your Honor.
Yes, Your Honor.
Okay, so let me go ahead and review and look at, shatter. Okay, first of all, you're not have any contact with the victim in this matter. Do you understand that, sir?
Yes, ma'am.
Directly, indirectly, text, phone call, through a friend, no contact means absolutely no contact. Do you understand?
Yes, ma'am.
If you violate any of the court's orders, sir, I will revoke the bond, or the bond will be revoked, and it'll be set at 0. So make sure you're in full compliance. I'm going to also require you not to return to the scene of where this occurred. Do you understand that?
Yes, ma'am.
You're not to possess any weapons or firearms. Also, and at this time, sir, I've appointed the Public Defender's Office to represent you. Week dating, married, children together. Okay. Let me look at your prior. I'm going to set bond. Is he out on bond?
No, Your Honor.
I see now. I'm going to set bond in the amount of $1,000 at this time, with those as a condition of your release, okay?
Yes, ma'am.
Is that acceptable to the state?
Yes, Your Honor.
Thank you. Your name, please?
Michael Lawrence O'Neill.
Mr. O'Neill, sir, you are here on a charge, sir, of DUI with property damage, sir. This is in case number 2022 CT. I cannot read people's writings. Somebody's fancy. Is that you over there? Oh, my goodness. 434AE. At this time, I do find probable cause, sir. Are you going to hire your own attorney, or do you want me to get you an attorney appointed?
I'm going to hire my own.
You're going to hire your own?
Honor.
Okay, sir. At this time, the bond is set at $1,000. I do find probable cause. You're not to possess or consume any alcohol or illegal substances, okay?
Okay.
He's going to get his own attorney. You're welcome, sir. Thank you. Okay. And is this Mr. Riley?
Yes, ma'am.
Okay. Mr. Riley, sir, you're here on case number 2022 CT 330AO, rather. And at this time,
Your Honor, there is an offer to resolve the case.
okay.
The offer is an adjudication of guilt, credit, time served, and court costs, and Mr. Riley would like to accept that offer.
Does anybody have his driving record?
I don't, Your Honor.
I can have it printed, Your Honor.
I just want to make sure it doesn't habitualize him or something, you know. So let's, he's got how many days in? The 2?
2 days.
2 days, okay. I'm sorry, yes, Mr. Riley, sir, we just wanted to make sure, we're going to run a driving record real quick. You're not on probation for anything, are you? Okay. If you are, you know, only you know, you just don't want to get violated if you're on probation. Okay. Yeah. So we'll need prints, and I think we're going to get a
My license.
driver's license. It's not that he still can't resolve it, it's just I want to make sure he's, which y'all have now learned, I want to make whatever I say. I'm cleaning up, can't you tell? You know me, don't you? I'd be like, oh, this is. Okay, are we ready, or?
All he has is the marijuana.
Oh, thank you. Oh, it's one of those.
It's not, it's still gonna be the same.
Seriously, that's the only reason I did it, but
It's not gonna matter.
it really doesn't.
No, it doesn't.
If you want to give them a withhold,
I mean-
sure. But that's the reason
Yeah.
that I do it, is that it doesn't make a difference.
Thank you.
Thank you.
I went to an arraignment, so. All right, let's look at his driving record from January and when he suspended indefinitely. I'm showing, this is his, would be his third. So he's got one in Osceola and one in Orange in 2021, one in 2019 and one in 2021.
This will be. It's gonna be mandatory.
I mean,
Your Honor, he understands and he still would like to resolve.
okay. All right, at this time, Mr. Riley, sir, it's and we're going to put on the record, defendant was advised of HTO status. Mr. Riley, you understand that by pleading this, I'm not DMV, but my job is to make sure that you understand that if you resolve this case today, it does appear to be 3 within a 5-year period, and you're going to lose your driving privileges for 5 years. I'm not going to order the 5-year driver's license revocation. The Department of Motor Vehicles is the one that will review that. My job is just to make sure you fully understand the consequence of entering any plea of guilty or no contest. Your attorney can always request a bond hearing immediately. I mean, sometimes people are short-sighted. They're like, let me resolve it because I want out of jail versus the big picture of what is it going to look like in a year from now or 2 months from now or, you know.
I got a job and I got to get to work, so.
But I don't know, I'm not here to tell you how to resolve your case, sir, but I don't know if your job requires you to drive or anything like that, or how you get to work. Yeah.
Your Honor, I explained everything. I explained to him about the mandatory 5-year suspension. He understands and he still would like to resolve.
That's fine, and that's fine. That's okay. Mr. Riley, sir, it's your case. You're an adult. My job is just to make sure you understand, and your attorney also assisted on that, explaining that, okay? All right.
Yes.
Okay. All right. Mr. Riley, sir, at this time, it's my understanding you wish to plead no contest to the charge of driving while licensed suspended with knowledge in case number 2022 CT330AO. Is that correct?
Yes, ma'am.
From where you're standing, sir, is this your signature on the plea form?
Yes, ma'am.
Did you understand the rights that you're giving up by pleading here today?
Yes, ma'am.
How far, did you read and understand the rights? Okay, and how far have you completed in school, education-wise?
Graduated high school and some college.
Okay, and I know that seems like an odd question. It's to ensure that you've read the plea form, you understand the rights, and if there was any question that the court further inquired. Are you entering the plea on your own free will?
Yes, ma'am.
Is anyone forcing, threatening, or coercing you to do so?
No, ma'am.
And have any other promises been made to you other than what was announced here in open court?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication that could affect your thinking?
No, ma'am.
And you understand the Public Defender's Office acted as a friend of the court? Well, you qualified, so I'm going to go ahead and appoint. I'm going to have you sign the form, if you don't mind. The Public Defender's Office was appointed, and are you satisfied with their services? Oh, did they not qualify? Oh, the PD did not qualify. So do you understand that you're proceeding without an attorney today? She's acting as a friend of the court only.
Yes, ma'am.
Okay. And also, you stated, are you on probation for any other charge?
I'm not on probation at all.
Okay, sir. And do you further understand that if you're not a U.S. citizen, it will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
Okay. And now that I've asked all those questions, how do you wish to continue with your plea? Guilty, not guilty, or no contest?
No contest.
And I have advised you of the HTO status that DMV will review. They make that decision, but this does appear to be 3 within the 5-year, which would be HTO. Do you understand?
Yes, ma'am.
All right, sir. I'll accept your plea. I find you're freely and voluntarily doing so, and you understood the rights you're giving up by entering the plea. I'll adjudicate you guilty, sentence you to the 2 days you served with credit for 2 days' time served. There's the court cost, and what I'll do is give you 1 year to make those court cost payments, so it won't cause another suspension to occur for failure to pay. Okay? All right, sir. Do you have any other questions?
No, ma'am.
All right, you'll be released today under this charge. Please put that he was advised of HTO status, and at this time, you have the right to appeal the sentence of the court. Must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed to represent you. Okay? Thank you. Okay, I think we're down to the felony, and we should be in order now. All right.
Jose Serio Garcia, bonded.
Okay, thank you. All right. Sir, your name?
I think this is,
Emmanuel Boulder.
it's not him.
What happened with, okay, there was,
Jamar Atencio, he bonded your offer, Your Honor.
oh, okay, all right, that's what I was stopped on. I just didn't know about him. Okay,
And, Your Honor, I had a PC challenge.
on Mr.,
Baldwin Emmanuel.
okay.
Um,
Before we begin that, I've got something attached that I want to make sure. What happened, I'm just going by what's in my order, everybody. What happened with Glenn Black? I've got, it was Glenn Black?
He's not on our docket, Your Honor. Inmate number 22007299.
All right.
Bonded.
Thank you.
Sir, your name again, Emmanuel Bolden?
Yes, ma'am.
You're here, sir, in case number 2022 CF 35958AO. And at this time, I don't know if you can make that argument. He didn't fill out, did we have a PD appointment on him? You're going to hire your own attorney?
I got a private lawyer.
oh, he said he paid for a private lawyer.
Yeah. Yeah. You already got your attorney ordered? You already hired your attorney?
Yes, ma'am.
Okay, don't say any, I mean, I just don't want you to blurt out anything, okay? At this time, yeah, he's hired someone.
Yes, Your Honor. No, I would ask that you not appoint him.
Without saying anything you've talked to your attorney about, can you tell us who the attorney is?
Sean, I don't know the last name.
Okay, but you have, you've retained that attorney?
It was supposed to be here today. I ain't talked to my baby mama. She's supposed to have had him here today.
Okay. We don't show that they filed a notice to appear yet, but that's not unusual. But we don't want to get in the middle of you hiring your attorney and then, you know, some other issues. What have they been? Okay, what we're going to do, just in case you don't get an attorney, okay, just in case, we're going to go ahead and set it for determination of counsel next week. But you're, because your bond is 1.5 million.
Yes, ma'am.
Right. So I on 2 counts and 2,500 under count 3. Okay. So I don't want to say too much, and I don't want you to say anything, you know. But you say you're hiring your attorney, so per defendant, hiring his own attorney has retained an attorney, okay? So at this time, sir, the bonds will remain the same at this time, okay? All right,
Yes,
sir.
ma'am.
Your Honor, do you find probable cause, and are there any conditions?
I do find probable cause, and at this time, the conditions are no illegal drugs, which, no drugs.
Yes, ma'am.
Y'all just pick days, whatever. How far out do you want it set within 1 week?
Yes, ma'am. I need it immediately.
Okay, all right. Well, you got to give your attorney enough time, because, I mean, that's the other thing. I don't want to set it too quick, and then how about we set it for Wednesday, April the 6th, okay?
Yes, ma'am.
All right, sir. Thank you. I don't want to get into,
No, I understand, Your Honor. That's why I didn't say anything.
right, I know, you don't want to. All right, your name, please?
Deshae Bird.
Mr. Byrd, sir, you're here on a charge, sir. This was a sex offender violation, a failure to register or failure to provide, the registration information. I'm showing you do qualify for the public defender. Bond is set at $1,500, and within 24 hours of your release, you must update and register it as required by law. Okay? Your name, please? Sir, your name? Can you tell me who you are? Mr. Caraway, sir, you're here on a charge of petty theft, having 2 prior convictions. I will appoint the Public Defender's Office to represent you. I don't show the 2 priors contained. I didn't see that.
Understood, Your Honor, but you can also get that information from the attached face sheet.
Okay, do you want to, I would think they should put that in there, but.
Understood, Your Honor,
I know.
yes.
I know we have one case that I saw. It doesn't show me a case number on the face sheet, does it?
It does not, Your Honor. If you like, if you will permit, Your Honor, I'll ask for the 24 hours to get that information.
I think
But
all
if
I
you
gotta
do
do
look
is
at-
go into Odyssey, everybody. I think I can do it pretty quick.
Okay.
I know there was one under 2021-MM124AW. He was convicted and adjudicated on 5/5/21. Does correction show any other case numbers? I mean, there's no reason to reset people when we can, try to take care of them. And everybody can kind of be
Your Honor, I see a grand theft from 1989, case number 89 CR 843. There's also, that's the one today.
So, Your Honor, in case number, looks like 2021 MM124AW.
I did that one.
That's the one.
Yeah, that's the one. I just need one more. Then again, I could just find PC to petty theft and bond. I mean, it just didn't have anything contained in the affidavit. I've got 2021 MM124AW. He was adjudicated guilty of the crime of petty theft. It was transferred from a CF number, and he pled to on May the 5th of 2021. I just need one other CF or MM number.
I have a 2021 MM166AA.
Okay, look at it real quick.
April 16th of 2021.
Okay. 2021 MM.
166AA.
Thank you. All right, at this time, the court does see that, and the adjudication judgment was recorded. I do find PC will put on the order 2 prior theft convictions were provided on the record. Court does find PC, and the bond will remain at the amount stated at $1,000. You're not to return to the scene of where this occurred. Do you understand that? Okay, sir. You've got the Public Defender's Office appointed. Thank you.
Nathan Franklin refused, Your Honor.
Okay.
I will waive the appearance, Your Honor.
All right, this time the court's reviewed the charge and affidavit, find probable cause. Bond will remain the same at $1,250. As to the charge he is out on, the disorderly conduct. Let's see. MO, 2021, 1547 AO.
I believe it's a city case, Your Honor.
Is it? Okay.
Yes, so given that it is a city case, Your Honor, and I believe it will be resolved, I was gonna see about resolving it today, but he's not here.
Right.
I would ask that you take no action.
'Cause he'll be set, won't he, pretty soon? Oh, if he's in jail, well, he might bond out. I won't take any action. Wonder why it's taken 4 months for it to come up.
So originally, he wanted to fight the charge, Your Honor. So it was set for trial.
Okay, is that the trial date then you're showing, or 4/4?
That I'm not sure.
That's okay. I just, it just seemed like it took a long time to pop up, you know, I mean, for it to get into a docket. That's okay.
Thank you.
You're welcome. And, oh, as to him, he is, on the charge of the new charge, he's not to return to the scene of where it occurred, and he's not to possess any, illegal drugs or alcohol, okay? And no action on the MO case, the disorderly. Okay. Your name, please? Mr. Guthrie, sir, you're here on a charge of aggravated battery with a firearm, and this was set as a bond case, or rather a charge and affidavit, a warrant. Another judge has already found probable cause. At this time, you do qualify for the public defender. I believe he's titled to a bond. Does everybody agree?
Yes, Your Honor.
Shoot. I'm going to require you, sir, as a condition of your bond, to have no weapons or firearms. Do you understand that, sir? I'm going to also require you, sir, not to possess, or rather, you're not to have any contact with the victim. Do you understand that?
Yes, Your Honor.
Lineup positively identified him. Let me look at the prior history. Looks like, what is your date of birth? You're 18 years old. All right. So at this time, I'm going to set your bond in the amount of $5,250 with those as the conditions of your release. Oh. Okay. And also, you're not to come within 500 feet of the victim's residence or employment. Okay? You understand that, sir? All right. Thank you. Was there anything further from the state? I'm sorry.
Your Honor.
Your name, please?
Warren Lee Harris Jr.
Mr. Harris, sir, you're here on a charge of petty theft, having two, this was a probable cause order. Probable cause was already found. I will appoint the public defender's office to represent you, sir, and that court set bond in the amount of $2,000 plus pretrial release, and not to return to the scene of where this occurred or any Walmart, okay? Your name, please?
Hughley, Craig Hughley.
All right, Mr. Hughley, sir, this was a failure to appear, and this is in case number 2021 CF 2041AO. The court that issued those warrants have set bond at none, sir, and you have the public defender's office appointed to represent you. All right. Thank you, sir. Yes. Sir, your name, please?
Robert Jones.
Mr. Jones? Okay. Mr. Jones, sir, you're here on a case of possession of methamphetamine, possession of heroin, and trespass on property after warning. This is in case number 2022 CF 3546AO. I'm showing that you do qualify for the public defender. I will appoint them to represent you, sir. Bond will remain the same, 1,000, 1,000, and 500 under count 3. You're not to possess or possess any drugs, and you're not to return to the scene of where this occurred. You are out on bond on a few cases. First of all, the first one is 2022 CF 1001 AO. And I believe pretrial is already set on that. I'm going to revoke the bond, sir, and set that bond at none. You're out on bond, sir. And then there's another case, which I don't know what's occurring quite with yet. I'm going to ask the state, CF 21-15752 AO.
A moment, Your Honor.
Okay, I'm just not sure. He was ROR, so he might have, I think it was an ROR, so there won't, it was a 30-day motion. So that's what it just looks like from the date of when he got out.
Yes, Your Honor. However, formal charges have been filed. A pretrial conference is set for May 11th, so I would ask that you also revoke this case as well.
It's going to be on no bond. He might as well be earning time served.
Yes, Your Honor.
I agree. All right, I will revoke the ROR. State has filed an information, and that bond will be set at none. And again, you do have the public defender, sir, on all the cases, okay? It wouldn't make any sense not to if he wants. You're welcome. Your name, please?
Sabrina Kemp.
Ms. Kemp, you're here on a charge. This was a failure to appear for a pretrial. This was for grand theft of the 3rd degree of a motor vehicle.
Yes, ma'am.
Don't talk, don't talk.
On here, I don't know why, but on my paperwork, y'all do not have my correct address as with the public defender.
Thank you, Your Honor.
Okay, I understand. Your attorney does not want you to say anything because they don't want it to be used against you at a later time. And even though you may feel like what you have is very valuable at this exact moment, they usually want to discuss that with you outside of this room where that's being recorded, because they want to make sure if they prepare a motion to modify or to set bond, that there's not any conflicts. They're doing their job. So that's why she jumped up and said, don't talk, okay?
Okay,
All right. That's okay. I'm just trying to explain the same way as she does. Bond will remain the same at none. And has the PD been previously appointed? Yes. And PD's been previously appointed.
What does that mean?
If she wishes to do an update of address, Madam Clerk handed me a form, but I don't know if you want to do that when you.
Yes, Your Honor.
I can't hear. I'm deaf in my left ear, so I can't hear you.
Okay, well, I've kept the bond at none, okay? The bond was issued at 0 by the judge when you failed to appear. You've got the public defender's office appointed. We do have a change of address form that we were going to, the Madam Clerk just showed it to me. If you wish to get that filled out, we can get it now updated. It doesn't change your bond status today, doesn't change anything, but at least it will update what you say you got something about a new address, okay?
So when will I go back in front of the judge?
Oh, they can request it at any time. Your attorney can request it at, I mean, you know, they can do a motion and request that.
No, put the address. I'm gonna let the attorney know so we can try to get a hearing.
So I can't get a bond?
Not today. It's got to go in the front of the judge that issued it, okay? The court that issued it has jurisdiction. They're the one that issued that and set bond at none. And so your attorney will, I'm sure that is here today, will notify that division in an attempt to get you set as soon as they can, quickly, as soon as they can, for a bond hearing in front of the judge that issued it, that division. get days off now? Days off, pick your days. Then it can be free flow. All right, your name, sir?
Anthony Allen Kimball.
Mr. Kimball, sir, you're here in case number 2022 CF 3580AO. And at this time, sir, you do qualify, I believe, for the public defender. I'm going to appoint them to represent you on the case. This is a charge of possession of methamphetamine. And this was in, I'm going to require you to have no drugs. The bond's going to remain the same at $15,000 with no drugs, okay? All right, sir.
Your Honor,
He has
he also
a
has
second.
another
Warrant.
case.
He's got another case? Oh. Didn't see that one. Mr. Kimball, don't go anywhere quite yet, sir. Fortunately, it was an arrest warrant, that's why. He's entitled to a bond, and I don't have that printed, so another judge, Mr. Kimball, there was another warrant already issued. So let me pull that up, and I have to pull that up by the case, right? Because that's 22. I've got to get them to try to fix my computer, or the computer in there, not mine, but to open these up. All right, Mr. Kimball, you got the public defender on that second case, the 22 CF 3580. It was an arrest warrant. Was under the 638 AO. Look that up real quick. Because you're entitled to a bond under that case, sir. Okay. Under that case, sir, you're not having any contact with the victim in that case. Do you understand that, sir?
Understand, but
Well, this is regarding, and don't say anything, this is regarding an assault that occurred regarding on Polk Street, 1045 Polk Street. Getting into a verbal argument, and you pointed a small black revolver at the victim. And I just don't want you to say anything. Don't say anything because your attorney. Okay, so you're to have no contact with the victim. You're not to possess any weapons or firearms, and I'm going to require you within 24 hours of your release, if you're able to post your bond, or when you're, if you're able to post it, when you're able to turn any weapons or firearms over to law enforcement. And at this time, sir, I'm going to set that bond in the amount of $5,000. Okay? Sir, your name, please?
Gerald Mano.
Mr. Mano, sir, you're here on a charge, sir, as follows. It was a failure to appear for trial management conference. That court set bond at none, sir. I'm showing you do qualify for the public defender, so they'll remain involved with the case, okay?
I had turned myself in.
Okay, well, it'll still have to be addressed by that court. Something you may be able to offer that court at appropriate time. Your name, please?
Michael Angelo Mateo.
Mr. Mateo, sir, you're here on a charge. This was also a failure to appear for pretrial conference. Case number 2022 CF 13394AO. That bond has been set at none. PD previously appointed. Okay.
Thank you, Your Honor.
Uh-huh. Okay, thank you. Your name, please?
Rod Miracle.
Mr. Miracle, sir, you're here on the following charges, sir. Tampering with physical evidence, possession of drug paraphernalia, trafficking in meth and MDMA, ecstasy, and also grand theft of the third degree of a motor vehicle, sir. You do qualify for the public defender. I'll appoint them to represent you. This is in case number 2022 CF 3566AO.
Your Honor.
I think you want to say anything.
Yes, ma'am.
Yeah, your attorney doesn't want you to say anything. She doesn't want it used against you. All right.
Thank you, Your Honor.
You're welcome. At this time, sir, the court does find probable cause. You're to possess no drugs, sir, and the bond amounts will remain the same.
Your Honor, my client can't afford a $100,000 bond. I would ask that you consider reducing the bond amount to $50,000 due to him being unable to pay the $100,000. The last conviction I have in 2019 was a false ID to a law enforcement officer, and it looks like the last failure to appear he had was all the way back in '05. So I just ask that you consider that reducing the bond amount, Your Honor.
State?
To 50,000? No objection.
I'll go ahead and reduce count 3 to 50,000 without objection from the state, okay? But once again, you're not to have any drugs.
I missed 50,000 on that count, Your Honor. What was the bond amounts on the other counts?
150, 100, and 150.
Thank you.
They will remain the same.
Nope.
Thank you for approval. Sir, your name, please? Are you Mr. Owens? Okay, Mr. Owens, sir, you're here, it's a few cases, so let me just start going through them, okay? You're here on the following charges. The first one is grand theft of the third degree and resisting officer without violence. That was an arrest warrant, and probable cause was already found under that. Bond was set at $2,500 under count 1 and $500 under count 2. And that again was in case number 2021 CF 1605AO. You then had a second case of 2022 CF 3182AO. And again, Mr. Owens, that was another warrant that was already signed by a judge finding probable cause. And that was for burglary of a dwelling where the bond is $3,500. Count 2 is criminal mischief with a $1,000 bond. Count 3 is criminal mischief with a $1,000 bond. And count 4 is a grand theft also of a $1,000 of a $500 bond. Yeah, no contact. Okay, let me just tell him. Okay. And then you had a third case, also 2022 CF 3551AO, grand theft of a motor vehicle. And in that one, that was also a probable cause order. Once again, bond was set at $2,500 under that. Under that case, you're to have no contact with the victim, co-defendant, or any witnesses. Under the case number ending in the 3182, there was an inclusion of no contact with the victim under that case. And under the first case, 16054, there were no additional conditions. Now, the other issue is you're out on bond on a driving while license suspended as a habitual.
And Your Honor, on that charge, I would ask that if you take no action, but if you are inclined to take action, that you revoke in double. He was actually in court when they arrested him on these warrants.
Oh,
So he's
was he?
appearing for court, and he's working with the attorney to try to get his license.
Okay.
Because he's working part-time right now at Taylor's Farm, and he has community ties, I would ask that you not revoke the out on bond and hold him at least at no bond, so he can continue to work on his license.
So he was in court on the Dwillis,
Mhm.
and they then had these arrest warrants and served him in open court.
Yes, Your Honor.
Any position on behalf of the state?
No objection, Your Honor.
To not taking any action?
Yes.
Yeah, I won't take any action due to, you were in court, you were doing what you were supposed to do. They did what they were supposed to do, but I won't revoke that bond. I'll take no action at this time due to those circumstances. But you have the bonds on all the others with the other conditions, so that'll assure his appearance at those times. But Mr. Owens, though, I do need to make it abundantly clear, though, you understand the no contact order, don't you? And you know who that is? All of them. All of them. Okay? You're welcome. And one is specifically is Elizabeth Hicks. That was his, were they, oh, that was family. Okay. Your name, please? Okay.
And I will waive the appearance, Your Honor.
All right, on Mr. Porter, PC found 2022 CF 3582AO. Bonds will remain the same at $5,100 and $100. No return to the scene of where these occurred and no contact with the victims. He is out on bond on a petty theft. Oh, they've already got me ready to sign it, don't they?
Mm-hmm.
Didn't take long. Violation of the pretrial release, is that correct, what this is?
Yes, Your Honor.
Okay. Revoke?
We are already appointed on that case, Your Honor.
Okay,
I will let the attorney know.
31st of March. Oh, I don't click all the, I don't, that first set, that first top of conditions, that doesn't apply to me. I'm going to set bond at none at this time due to picking up similar charges. So on the one under 2022 MM909AO, at this time, the court has signed the revocation of pretrial release and has issued a no bond. Okay? Is that all you needed? Okay. Do I hand that to you?
That wasn't for him. That was the one that refused.
Okay, your name, please? Okay, we're on, we got the right. Mr. Ramsey, sir, you're here on a charge, sir, of trafficking methamphetamine, possession of drug paraphernalia, is providing false information to law enforcement officer. At this time, sir, you do qualify for the public defender, sir. I'm going to appoint the public defender's office to represent you. At this time, the court does find probable cause. Let me scan this. I did find probable cause under 2022 CF 3590-AO. Sir, at this time, bonds are going to remain the same, $100,000 under count 1, $100 under count 2, and $100 under count 3. Okay? And you've got an attorney, sir. I'm sure she's already spoken. Okay, thank you. And no drugs. If you are able to bond out, you can't have any drugs.
Resolve this case. They're not gonna send you unless you bond.
I think we got 4 more, and do we have anything else that I'm not aware of? Okay. Your name, please? Ms. Reynolds, ma'am, you're here on a charge of possession of fentanyl and prostitution. At this time, you do qualify for the public defender. I will appoint the public defender's office to represent you. And again, this is in case number CF 22-3600. At this time, ma'am, matter. And what is your name? Is that this person? Does she have an out-of-county hold? No. Yes or no?
This is Brenda Reynolds. She has a
Okay. Okay, got it. Okay, I see it now. That's fine. I've got it. At this time, ma'am, the bonds will remain the same at $1,150. If you are able to post the bond, you're not to have any drugs.
Your Honor, my client is not currently working. She is asking for an ROR. I believe the last way to appear was in 2012.
And she's had a violation of probation for
Yes.
conspiracy.
Mhm. I explained that, Your Honor, but I did want to at least.
Absolutely. You're doing your job, and you're doing an excellent job. I will deny that request, okay?
Thank you.
You're welcome. Sir, your name, please?
Desmond Reynolds, ma'am.
All right, Mr. Reynolds, sir. Mr. Reynolds, sir, you're here on a charge of possession of a firearm by a convicted felon, possession of a firearm with a serial number removed, and resisting officer without violence. And you don't need to say anything. That's just what the officer wrote, okay? I just don't want you to say anything to be used against you. This is in 2022 CF 3589AO. I will appoint the public defender's office to represent you. You also have a failure to appear, sir, in the case of 2021 CT 2121AW. The court, and that was for driving while licensed suspended with knowledge. Public defender's office is appointed on that one also. The court set that bond at $2,000 under the CT case. And at this time, sir, the bonds will remain the same under the CF case at $4,000 under count 1, $500 under count 2, and $500 under count 3. If you are able to post a bond, though, sir, you are not to possess any weapon or firearm. Do you understand that, sir?
Judge, may I say something, ma'am?
Your attorney wants to probably, she just doesn't want you to say anything to be used against you, so she's. And I believe he has a hold for Seminole County.
Thank you.
Okay. Your name, please?
David Span.
Mr. Spain, sir, you have a private attorney already, they said. Did you know that?
Yes, ma'am.
Okay, all right, just wanted to make sure. This was a failure to appear for pretrial conference. That court has issued bond at none. And so, and that's in case number 2020 CF 13045AO. Okay? Your attorney will know any appropriate motions or speak with you regarding that.
So I'm being released or no?
You're not going to get released today in this courtroom, but your attorney would know any appropriate motions or discussions regarding that and failure to appear. Okay? All right. Thank you, sir. This is Cody Stout. Mr. Stout, is that correct?
Yes, ma'am.
All right, Mr. Stout, sir, you're here in case number 2021 CF 8265AO, and this was a failure to appear also, and that court has also issued a warrant setting your bonds at none. The public defender's office was previously appointed, so as I just told the other gentleman, that at that time they'll know any appropriate motions that can be filed. Okay?
Thank you.
You're welcome, sir. All right, everybody, I think that concludes this long day, and I want to thank everyone for their patience and their courtesy and their help. Okay? Thank you.
Thank you.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good afternoon, ma'am. State your name and date of birth, please.
Buenas tardes, señora. Por favor, diga su nombre completo y su fecha de nacimiento. Angélica González, August 31st, 1996.
Ma'am, you've been picked up as a result of battery, touch, or strike.
Señora, usted fue puesto bajo arresto como resultado por una agresión física, toque o golpe.
I have reviewed the charging affidavit and find there's sufficient probable cause.
Habiendo repasado el documento acusatorio, determinó que existen suficientes indicios de criminalidad.
You do not qualify for pretrial release.
Usted no cumple con los requisitos de la libertad provisional.
Bond to be set in the amount of $1,000.
Se concede fianza en la cantidad de $1,000.
You are not to return to 4626 Tribute Trail, Kissimmee.
Se le prohíbe regresar al 4626 Tribute Trail, Kissimmee.
You can go one time with the assistance of law enforcement to obtain your personal items.
Se le permitirá regresar en una ocasión acompañada de las autoridades para recoger sus pertenencias.
You are not to have any contact with Mary Lozama de Gonzalez.
Se le prohíbe todo tipo de contacto con Mary Lozana de González.
No contact means no in-person contacts.
La prohibición de contacto significa que se le prohíbe el contacto en persona.
No third-party contact.
Se le prohíbe también el contacto a través de terceras personas.
No social media contact.
Se le prohíbe comunicarse con ella a través de las redes sociales.
No telephone contacts.
Tampoco podrá comunicarse por teléfono.
No contact whatsoever. Do you understand?
Ningún tipo de contacto en lo absoluto. ¿Ha entendido esto, señora? Yes.
I apologize, Your Honor. I needed to say that she came in with a Baker Act from law enforcement, so our mental health department at the jail is requesting a ROR so that she can be Baker Acted.
Su señoría, perdona que le interrumpa, cuando ella llegó aquí venía también con un Baker Act y el personal de salud mental en la cárcel ha solicitado que se le conceda caución juratoria para que entonces pueda procesarse el Baker Act.
Court will remove the bond of $1,000 for the sole purpose of an ROR for a Baker Act.
Se elimina entonces la fianza de $1,000 con el único propósito de que se pueda conceder caución juratoria y que pueda efectuarse el Baker Act.
If that Baker Act does not happen, she is to be held and brought before the court the next day.
Ahora, si no se va a celebrar el Baker Act, entonces tendrá que permanecer bajo custodia y traerse nuevamente ante un juez al día siguiente.
Not to possess or consume any alcohol or drugs.
Se le prohíbe la tenencia y consumo de drogas y alcohol.
You are to take all prescriptions as they are prescribed.
Y tendrá que tomarse todos los medicamentos recetados según fueron recetados.
Thank you.
Gracias.
You can have a seat, ma'am.
Puede tomar asiento, señora.
Christian Rodriguez Rodriguez.
Your Honor, he has refused.
Do you want to waive his appearance or do you want me to waive his appearance? Oh, he is there. Okay. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, diga su nombre completo y su fecha de nacimiento. Christian Omar Rodriguez Rodriguez, 4/11/1987.
Your Honor, we would ask for a waiver of the readings.
Su señoría, estamos renunciando que se lea la acusación.
Is there anything else, counsel?
¿Algo más, licenciada?
No, Your Honor.
No, su señoría.
Sir, do you know what you're being charged with?
Señor, ¿usted sabe de qué se le acusa? Yes.
Court has reviewed the charging affidavit. I do find that there's sufficient probable cause for all 11 counts.
Habiendo repasado el documento acusatorio, determino que existen indicios de criminalidad ante los 11 cargos.
Bond to be set on count 1 in the amount of $2,500.
Las fianzas se conceden de la siguiente manera. Cargo número 1, $2,500.
Count 2, the amount of $150.
Cargo número 2, $150.
Count 3, $2,500.
Cargo número 3, $2,500.
And counts 4 through 11, $150 each.
Y los cargos del 4 al 11, $150 cada uno.
Thank you.
Gracias.
You can have a seat, sir.
Pueden tomar asiento.
Julio Viret Santiago. One moment, please, sir. Someone's here for your case.
Un momento, señor, por favor, hay alguien aquí presente en cuanto a esta acusación.
All right, good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor, por favor, diga su nombre completo y su fecha de nacimiento.
Julio Viruet Santiago, 12 de febrero del 1992.
Julio Viruet Santiago, February 12, 1992.
Sir, you've been picked up as a result of battery, touch, or strike.
Señor, usted fue puesto bajo arresto ante una acusación de agresión física, toque o golpe.
The court has reviewed the charging affidavit. I find there's sufficient probable cause.
Habiendo repasado el documento acusatorio, determino que existen los suficientes indicios de criminalidad.
Good afternoon, ma'am. Can you raise your right hand to be sworn, please?
Buenas tardes, señora. Por favor, levante la mano derecha para prestar juramento.
You solemnly swear or affirm that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Jura y promete que el testimonio que va a prestar será la verdad, solamente la verdad y nada más que la verdad. ¿Lo jura ante Dios?
Sí.
Yes.
Thank you. You can lower your hand.
¿Puede bajar la mano?
Can you state your name, please?
Por favor, señora, dígame su nombre completo.
Jacqueline Sierra Morales.
Jacqueline Sierra Morales.
Ms. Morales, as the victim in this case, you have the opportunity to speak with the court.
Señora Morales, como usted es la víctima de este caso, se le concede la oportunidad de dirigirse al juzgado.
This is not a time to talk about what occurred.
Este no es el momento para hablarnos de lo que sucedió,
It's a time to tell me what you would like to see with regard to release restrictions.
sino que es el momento para que usted nos diga qué es lo que usted desea en cuanto a las restricciones de la puesta en libertad.
While I will take what you say under consideration,
Lo que usted me diga, yo lo tomaré en consideración,
I am not obligated to order that which you seek.
pero no estoy obligada a ordenar lo que usted me haya solicitado.
Do you understand?
¿Esto lo he entendido?
Sí.
Yes.
What would you like the court to know?
Así que entonces, señora, ¿qué desea usted que sepa este juzgado?
Sí, le pasa, ¿verdad? Pues con la situación, no, o sea, no hubo ninguna situación, solamente pues lo único que quiero es el papá de mi nena, somos, o sea, él es mi equipo, somos una familia, él no le hace mal a nadie. Quiero que pues, o sea, no quiero ningún cargo para él porque él no hizo nada, él o sea, no hay nada. Tampoco quiero una orden de restricción, no quiero nada porque él es el papá de mi hija, tenemos una niña muy saludable que tiene 7 años, es la primera vez que nos pasa esto. No, por otras personas, porque yo tampoco llamé a la policía, eso no fui yo. No soy víctima.
Señora, permítame por favor interpretar.
Okay.
Well, regarding the situation, well, actually there is no situation. He is the father of my child. He doesn't do any harm. We're a team. We're a family. He didn't do anything, so I don't want to press any charges against him. Also, I don't want any restrictions toward me. We have a very healthy 7-year-old. Nothing like this has ever happened before, and I wasn't the one that called the police. Someone else called the police. We've never had anything like that happen to us before.
Is there anything else you would like me to know?
¿Algo más?
No, sería todo por el momento. Lo único es eso, que o sea, él no es mala persona, él no le hizo, no hizo nada mal. Fue otra persona, llamó, yo no soy víctima porque yo no llamé a la policía.
No, that's all for now. I just want you to know that he's a bad person, that he didn't do any harm, that I didn't call the police, someone else called, so I am no victim because I didn't call the police.
All right, well, the court has reviewed the charging affidavit.
Muy bien, habiendo repasado el documento acusatorio,
The facts in that affidavit cause me concern.
los hechos que constan en la declaración jurada a mí me crean preocupación.
including your inability to cooperate with everyone involved.
lo que incluye su falta de capacidad de cooperar con todas las personas que estaban involucradas.
No habían,
Mr. Santiago qualifies for pretrial release with a bond.
El señor Santiago cumple con los requisitos de la libertad provisional con fianza.
That bond will be set in the amount of $1,000.
Se concede fianza en la cantidad de $1,000.
He is not to return to 2729 North Poinciana Boulevard, apartment 130.
Se le prohíbe regresar al 2729 de North Poinciana Boulevard, apartamento 1302.
May go back one time with the assistance of law enforcement to obtain your personal items.
Se le permitirá regresar en una ocasión acompañado de las autoridades para recoger sus pertenencias.
You may have non-hostile contact with the victim by telephone or email only.
Se le permite tener contacto, pero sin hostilidad con la víctima, solamente por teléfono o por correo electrónico.
And you must maintain separate residences.
Y se les prohíbe la convivencia.
Thank you.
Gracias.
Ms. Britannia, can you make a quick announcement just to make sure that we haven't missed anyone?
Yes. ¿Alguna de las personas que permanecen en la sala necesita los servicios del intérprete al español?
Yes, Your Honor. Christian Rosa Algarin is approaching.
Thank you.
What's his name, sir?
Christian Rosa Algarin. 2021 CF 1315.
Este es el caso número 2021 CF 1315.
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, diga su nombre completo y su fecha de nacimiento.
Cristian Rosa Algarín, 12-20 del 96.
Christian Rosa Algarín, 12/20/1996.
Sir, you've been picked up as a result of a warrant.
Señor, usted fue puesto bajo arresto porque tenía una orden de arresto en su contra
For violation of probation.
por haber incumplido con el régimen de libertad vigilada.
There's no bond on that, sir.
No se concedió fianza.
Thank you.
Gracias.
Thank you for your services, Ms. Britannia. Have a good afternoon.
Thank you, Your Honor.
Juan Hurtado Marga.
Your Honor, bond has been posted.
Really? Because it was a zero bond. And there's a gentleman walking up behind you.
I'm sorry, Your Honor. I was looking at the top of the sheet. My
Okay.
apologies.
Good afternoon, sir. State your name and date of birth, please.
Good afternoon. Juan Hurtado, January 22nd, 91.
Sir, you've been picked up as a result of a warrant on a violation of probation out of Highlands County, case number 21-000-120 CFMA. There's no bond on that, sir. They'll be notified that you're here and ready for pickup.
You have a good day. Thank you.
Thank you.
How many days will it take for them to come get me?
You can talk with the attorney about that, sir. Thank you. Jackson Adrian J.
He is present and approaching, Your Honor.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Adrian James Jackson, November 4th, 1997.
Thank you. Mr. Jackson, you picked up as a result of a warrant for violation of probation in case number 21CF1639. There's no bond on that, sir. Thank you. Joseph Patrick Knaus.
He is present and approaching, Your Honor. And I have some information for the court regarding this.
Good afternoon, sir. State your name and date of birth, please.
Joseph Patrick Knaus, May 16, 1974.
Thank you. Counsel, what information do you have?
Yes, Your Honor. Mr. Naus has provided me with information that he was sentenced in 20 CF 3243 and has been in custody
serving concurrently with cases. What was that?
Sir,
With Palm Beach County. And so I know that this is showing that he failed to appear for a status or a failure to register, but he has been in custody since sentencing.
No, that counts.
And then was transported here. So,
Yes, sir.
all right, well, he'll have to take that up with Judge Young, who's the one who issued the warrant. It's at 0 bond. Thank you.
yes, Your Honor.
Bobby Muse?
Yes, Your Honor. If I could, if we could waive the readings, and he is present and approaching.
Yes, ma'am. Good afternoon, sir. State your name and date of birth, please.
Bobby Muse, 6/20/69.
Mr. Muse, do you know what you've been picked up on?
Yes, ma'am.
Thank you. Court has reviewed the arrest warrant. The arrest warrant initially found probable cause. I concur with that finding. As to each of the charges, there will be no bond. They are punishable by life. You're not to have any contact with Jaden or persons under the age of 18. Thank you. Ruth Odell.
She is present and approaching, Your Honor.
Thank you. Good afternoon, ma'am. State your name and date of birth, please.
Ruth Odell, 53081.
Thank you. For the record, this is violent felon of special concern. Ms. Odell, you've been picked up on 2 matters. The first one is a warrant for violation of probation and case number 20CF1511 out of Osceola County. There is no bond on that warrant, ma'am. Additionally, there was an order of modification, restoration, and revocation of probation that was entered in case number 20CF1178. There's no bond on that either. Thank you. Marcos Carasballo.
He is present and approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Marcos Caraballo, October 1st, 2003.
Thank you. Mr. Caraballo, you've been picked up on 2 charges. First is resisting arrest without violence. The second is a false name or identification provided by the arrestee. The court has reviewed the charging affidavit. I do find sufficient probable cause for both charges. You do not qualify for pretrial release. Bond to be set on count 1 in the amount of $250, count 2 the amount of $250. Thank you. Olga Della Torre.
She is present and approaching, Your Honor.
Thank you. Good afternoon, ma'am. State your name and date of birth, please.
April 24th, 1996.
Thank you. Ma'am, you've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $1,000. You are not to return to 130 Teakwood Drive in Kissimmee. You can go back one time with the assistance of law enforcement to obtain your personal items only. You're to have no contact with Wilfredo Margini. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes.
Thank you. You may have a seat.
The parties do share a child in common. If there could be third-party contact regarding the provisions for the child only.
Not today, counsel. Thank you.
Thank you, Your Honor.
You can have a seat, ma'am.
Your Honor, I'm sorry, could you repeat which one that was?
The one that I just handled?
Yes, ma'am.
That was Olga Della Torre.
Thank you.
You're welcome. Blanca Hansen.
She is present and approaching, Your Honor.
Thank you. Good afternoon, ma'am. State your name and date of birth, please.
Blanca Hansen, 4/16/93.
Thank you. Ms. Hanson, you've been picked up as a result of possession or use of drug paraphernalia. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. You qualify for direct pretrial release. The court will grant that with the following conditions. You are not to possess or consume any alcohol or drugs, and you're to report for random urinalysis. Thank you. Sean Jewell.
He is present and approaching, Your Honor.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Sean Christopher. October 7th, 1983.
Are you awake and coherent so that we may proceed?
Huh?
Are you awake and coherent so that we may proceed?
Yeah.
Thank you. Yes, ma'am.
Oh, yes, ma'am.
Sir, you've been picked up as a result of trespass, occupied structure, or conveyance. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. You do not qualify for pretrial release. I will, however, release you on your own recognizance. Do not return to the Wawa located on Vineland Road. Do you understand?
Yes, ma'am.
Thank you. Alice Matheny.
Your Honor, she has refused.
All right, well, I will be going ahead and waiving her appearance.
Yes, Your Honor.
So on 22CT975 and 22MM734, she has a charge for no valid driver's license. I've reviewed the charging affidavit. I find there's sufficient probable cause. Bond to be set in the amount of $500. She's not to drive a vehicle without a valid driver's license, and she is to follow all laws. With regard to 21 CF 3111, the court will be revoking and setting at 0. Her next case is possession or use of drug paraphernalia. State, I don't see the probable cause finding for it actually being hers. It's just a very blank statement that said that it was in the car when they conducted a search of the car. I'm going to give you 24 hours to see if you can get a supplement, and if not, we'll deal with it at that point. Ashley McLaughlin.
She is present and approaching, Your Honor.
Thank you. Good afternoon, ma'am. State your name and date of birth, please.
Good afternoon, Ashley McLaughlin, January 14, 2000.
Thank you. Ma'am, you've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $1,000. You're not to return to 3050 Station Square, apartment 404. You can go back one time with the assistance of law enforcement to obtain your personal items. You're not to have any contact with Jaden Ortiz. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
I understand.
Thank you. Tatiana Reyes.
Your Honor, she is present and approaching, and there is a probable cause evidence here.
I'm waiting for the victim.
Yes, Your Honor.
All right, good afternoon, ma'am. State your name and date of birth, please.
Good afternoon.
October 8th, 1994.
Thank you. Ma'am, you've been picked up as a result of aggravated battery, bodily harm. Counsel, you said you had a PC argument?
Yes, Your Honor. The aggravated battery bodily harm charge, it requires either a great bodily harm, permanent disability, or permanent disfigurement, or the use of a deadly weapon. There's nothing in the charging affidavit that indicates that there was something that rises to the level of a great bodily harm, a permanent disfigurement, or a permanent disability, as there is a small statement in here that he suffered an injury to his left ear. Without more to that, I don't think that that would rise to that level. And as to, it could also be with, and it states in here that the officer, the fact that she struck him with a deadly weapon. I don't think that a toothbrush rises to the level of a deadly weapon. There's nothing indicating in the charging affidavit that it was like sharpened to a shiv or anything like that, just that it was in her hand.
State.
The definition of a deadly weapon is broad. It can be anything used or threatened to be used in a way that's likely to produce death or great bodily harm. I mean, I think there are ways you could use a toothbrush that would cause great bodily harm, but if there's not PC for the aggravated battery, there certainly is for a standard battery.
I will not be finding PC for the aggravated battery because there's no indication in this affidavit that there was a permanent injury, just a simple injury to his ear. There was no elaboration. Additionally, while a toothbrush can be used as a weapon, there's nothing in this affidavit to support that it was, as counsel said, shaved down or put into a shank. If we were talking about different circumstances, like maybe inside the jail or the prison, might be a little more believable, but on the regular outside, I need more facts than that. So we will be finding PC for a regular battery. Sir, can you raise your right hand to be sworn, please? You solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can lower your hand. Can you state your name, please?
My name is Hector Reyes.
All right, Mr. Reyes, as the victim in this case, you have the opportunity to address the court with regard to release restrictions. It is not a time to talk about what occurred that evening or in the previous evening, which is what she was actually arrested for. It's just a time for you to indicate to the court what you would like to see with regard to her release. Now, while I will consider what you're saying, I am not obligated to order that which you request. With that in mind, what would you like me to know?
I would like to not press surcharge and stuff, you know.
All right, well, if you don't want to press charges, I can't control that today. What you can do is you can go down to the third floor to the state attorney's office and ask to speak with an advocate. You can express your wishes about charges to them, and ultimately the state is the one who's going to determine whether those charges will be brought or not. Okay?
I already went this morning.
All right, but at this point, she's in front of me on the arrest, okay? Yes, state?
In this case, Your Honor, Mr. Reyes has already been in contact with the state attorney's office, and we have no objection to a no hostile contact condition as opposed to a no contact condition.
What about separate residences?
We do not require separate residences.
All right, well, based upon the state's recommendation, because it certainly was not going to be my initial order, I will allow her to come home. There is pretrial release with a bond. That bond will be set in the amount of $1,000. There's to be no hostile contact. Also, no possession or use of alcohol or drugs. She'll need to report for random urinalysis. Ma'am, if you find that you're getting aggravated with him, you need to remove yourself from the situation, because if you do not and someone calls the police, whether it's him or someone else who overhears you guys, you will be the one coming back to jail and you will be violating this release. Do you understand?
Yes, ma'am.
All right. Sir, if she gets aggravated with you, you need to call the police. I've given everything that you've asked me to give and everything the state has asked me to give against my better judgment. Okay? Thank you. Eileen Serrano.
He's present and approaching, Your Honor.
Good afternoon, ma'am. State your name and date of birth, please.
Eileen Serrano, 103196.
Thank you. Ms. Serrano, you've been picked up as a result of petty theft first offense. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. It appears you qualify for direct pretrial release. The court will grant that. Part of your conditions of release is that you are not to return to the Walmart on Vineland Road. Do you understand?
Yes.
Thank you. Denny Zug.
Is President approaching, Your Honor?
Good afternoon, sir. State your name and date of birth, please.
Denny Zug, 3979.
Thank you. Sir, you've been picked up as a result of burglary of an occupied dwelling unarmed, as well as criminal mischief. The court has reviewed the charging affidavit. I do find there is sufficient probable cause. You do not qualify for pretrial release. Bond to be set on count 1 in the amount of $5,000. Count 2, the amount of $500. You're not to return to 2295 East Earlo Bronson Memorial Highway. With regard to 22 CF 692, the court will be revoking and setting that bond at 0. Thank you. Counsel, did we get everyone today?
Yes, Your Honor.
Thank you. Have a good afternoon.
You too. See you tomorrow.
Yes, ma'am.
Please enjoy this pre-COVID bond court session. Starting in 3, 2, 1. Bond court.
Looks like we're on the record right now. Okay, well. The system's been on the whole time. Good morning, everyone. I'm Judge Amy Carter. This is courtroom 1, session 1. Could I have the attorneys place their appearances on the record, please?
Morning, Edith Bush for the Office of the State Attorney.
Thank you.
And Attorney Manuel Soto Diaz with the Office of Public Defender.
Okay. Good morning, sir. Your name?
Guillermo Peralosa.
Sir, you're here in case number 18 CF 16871. You failed to appear for case management conference on March 13th of 2019. Your bond on count 1 is $2,500. Your bond on count 2 is $500. If the public defender's office wasn't previously appointed, I'll appoint them as well. And in case number 16 CF 1299, I'll take no action at this time, sir. Thank you. Good morning, your name, sir?
Michael Hoggleville.
Mr. Hogbook, you were here in case number 19MM2477, sir. You were arrested for the offense of battery. I do find probable cause for that, and I'll appoint the public defender's office to represent you. I'm gonna set your bond, sir, at $1,000 and order that you not return to the Chevron gas station at 3501 Old Winter Garden Road, and you're not to have any contact with Nur Nobi or Mohammed Jabbar. Thank you, sir. Okay. Yeah. Could you give me the case numbers? Thank you. All right, Mr. Hogbook, in case number 19MM1647 and 19MM1622, I'm revoking your bond at this time, sir, and both of the bonds will be set at none. Thank you. Good morning, your name?
Lance Bennett, ma'am.
Mr. Bennett, you're here in case number 19MM2512. You were arrested for trespassing. I do find probable cause. I'll appoint the public defender's office to represent you. Is there an offer for Mr. Bennett?
Yes, Your Honor. It's an adjudication of guilt, 5 days, 2 days credit time served, no return to the McDonald's at 5890 South Orange Blossom Trail, and abide by all trespass warnings and court costs.
Okay.
Anyway, I challenge this with, I guess, the corporation or the company, because this is, it's not right.
Okay.
Regardless, if it's, I understand this is judicial system and
Sure.
whatever, you're just doing your job, but I want to fight it because I'm an American citizen and I pay taxes.
Okay, no, you absolutely can fight it, Mr. Bennett. So, as I said, I've appointed the public defender's office to represent you. Your bond is $500, sir. Thank you.
But I'm saying they said they have a plea right now that I can take.
They do, but you just told me you don't want to take the plea. You want to fight this charge because you
No,
think
I
it's
want to
unjust.
fight I wanted to fight the trespassing. That's why I want to fight with the corporation or with whoever it is, because that's just not true. It's just an employee. We're talking about an employee, then we're talking about a corporation. She's an employee. She wants to. I don't know what the problem is. But
Mr. Diaz,
that's
do you
her
want to
problem.
speak to him for a moment to determine what he wants to do?
That's her. My medical status and go and do all this headache stuff I've been trying to do, and I didn't even get a chance to even get my medicine, my pain medicine, because everybody just knows everything. I go to the pharmacist, he want to be the doctor and the pharmacist. I can't deal. What can I win? I want to get my pain medicine, but he's looking at me like, well, I think it's drugs. It's drugs. You don't supposed to have drugs. Yeah. Well, all right. I'll take it. Wednesday, what day? Monday, Tuesday, Wednesday. Okay. Like I'll
You
leave.
can accept the state's.
Okay, I just need the plea form,
I'm not
please.
even going to argue no more with nobody. Thank you. Not arguing with anyone. Just do us right and keep going. If it calls me to do whatever, it will. So I sign right here. Like, good grief. Like, I have a job. That's the only thing about it. I got a good job.
All right, Mr. Bennett, your attorney just informed me you'd like to accept the state's offer and enter a no contest plea this morning with the agreed upon resolution of an adjudication of guilt, 5 days in the Orange County Jail with credit for 2. You're also not to return to the McDonald's, sir, and abide by all trespass warnings. Is that your understanding?
Yes, ma'am.
And that's what you'd like to do?
Yes, ma'am.
Okay. Did you read and understand this plea form before you signed it?
Yes, I understood.
Do you have any questions about any of the rights that you're giving up?
No, I really don't.
I can't hear you.
No, ma'am.
Okay. Sir, do you understand if you're on probation for anything, anywhere, that this plea may violate your probation?
I'm not on probation, ma'am.
Okay. Do you understand if you're not a United States citizen, that this plea will subject you to deportation?
I'm American like apple pie, ma'am.
Okay. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court this morning?
If I can maybe get them, yeah, I maybe take them.
Well, my question to you, sir, is do you understand everything that's happening in court this morning?
I do. I understand them. I understand that Donald Trump is our president.
Thank you, sir. I will accept your plea, adjudicate you guilty, find that there is a sufficient factual basis to do so. Sentence you to 5 days in the Orange County Jail with credit for 2 days' time served. You also need to pay court costs. Those need to be paid by March 25th of 2020. You have 30 days to appeal the judgment and sentence of the court in writing, sir.
Yes, ma'am.
All right, thank you.
You have a wonderful day.
Lake Cobb is refusal, Your Honor.
All right, we'll reset. Mr. Cobb. Good morning, your name?
Julian Amante.
Mr. Amante, you're here in case number 19MM2529. You are arrested for trespass. I do find probable cause and will appoint the public defender's office to represent you. Is there an offer for Mr. Amante?
Yes, it's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, no return to the Wawa at 1200 West Colonial Drive. Abide by all trespass warnings and court costs.
Yes, Your Honor, that was going to be my request. He
Okay.
qualifies for release to PTR.
Sure, I'll release him to PTR.
Any conditions, sir?
No. Well, I mean, except for not going back to the Wawa. There's already a trespass warning, so. Good morning, your name?
Cameron Barnett.
Mr. Barnett, you're here in case number 19MM2532. You are arrested for trespassing. I find probable cause and will appoint the public defender's office. Is there an offer for Mr. Barnett?
Yes, it's an adjudication of guilt, 5 days, 2 days credit time served, no return to Langford Park on East Central Boulevard, abide by all trespass warnings and court costs.
Okay.
He's going to accept the state's offer, Your Honor.
All right. Thank you. Mr. Burnett, did you read and understand the plea form before you signed it?
Yes, ma'am.
Okay. And you understand that the plea agreement is an adjudication of guilt 5 days in the Orange County Jail with credit for 2 days time served?
Yes, ma'am.
Okay. And you can't go back to Langford Park?
I understand.
All right. Do you have any questions about any of the rights that you're giving up by entering into this plea?
No, ma'am.
Do you understand if you're on probation for anything anywhere that this plea may violate your probation?
Yes, ma'am.
Do you also understand if you're not a United States citizen that this plea will subject you to deportation?
Yes, ma'am.
Okay. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court this morning?
No, ma'am.
All right, I'll accept your plea. I'll adjudicate you guilty, sentence you to 5 days in the Orange County Jail with credit for 2 days. You also cannot return to Langford Park. You have to pay court costs. Those need to be paid by March 25th of 2020, and you have 30 days to appeal the judgment and sentence of the court in writing. Thank you.
Thank you. Everybody have a blessed day.
Good morning. Your name?
Morning, ma'am. My name is Juan Carabao Rivera, ma'am.
Sir, you're here in case number 19MM2518. You were arrested for trespass. I do find probable cause and will appoint the public defender's office to represent you. Is there an offer for Mr. Rivera?
Yes, it's an adjudication, 5 days, 2 days credit time served. No return to the 7-Eleven at 2160 Americana Boulevard. Abide by all trespass warnings and court costs.
Out of set, ma'am.
All right, so I just need the plea form, please. Thank you. Mr. Rivera, did you read and understand the plea form before you signed it?
Yes, ma'am, I did.
Do you have any questions about any of the rights that you're giving up this morning?
No, ma'am.
Do you understand if you're on probation for anything anywhere that this plea may violate your probation?
Yes, ma'am.
Do you also understand if you're not a United States citizen that this will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court this morning? Sir, I will accept your plea. I'll adjudicate you guilty, sentence you to 5 days in the Orange County Jail with credit for 2 days' time served. You're not to return to the 7-Eleven at 2160 Americana Boulevard. You're to abide by all the trespass warnings, and you need to pay court costs. Those need to be paid by March 25th of 2020, and you have 30 days to appeal the judgment and sentence of the court in writing. Thank you, sir.
Have a nice day, ma'am.
Good morning. Your name?
Mario Chambers.
Mr. Chambers, you're here in case number 19MM208. You were arrested for possession of cannabis less than 20 grams and resisting officer without violence. I do find probable cause and will appoint the public defender's office. I'll stay your bond on count 1 at 500 and your bond on count 2 will be 100. And 18 CF 10446, I'll take no action, sir. Thank you.
Okay.
Good morning. Your name, sir?
No contest. Jean Antoine.
Mr. Anton, you're here in case number 19MM2520.
No
You were
contest.
arrested for possession of drug paraphernalia, sir. I do find probable cause. I'm going to appoint the public defender's office to represent
No
you.
contest.
Is there an offer for Mr. Anton?
Yes, Your Honor. It's an adjudication, 3 days, 2 days credit time served.
Did you hear the offer, Mr. Anton?
No contest. Yes, I heard the offer.
You want to have a brief moment with him?
Yes, thank you. Thank you. Are we ready to proceed?
I think we are, Your Honor. Go ahead.
Okay. All right, Mr. Anton, did you have an opportunity to read this plea form before you signed it?
Yes, sir. I plead no contest. I mean, yes, ma'am.
Okay. Do you have any questions about any of the rights you're giving up on this form?
No.
Okay. Do you understand, sir, if you're on probation for anything anywhere, that this plea may violate your probation?
Yes, ma'am.
Do you also understand if you're not a United States citizen, that this plea will subject you to deportation?
Yes.
Okay. Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court this morning?
No.
Sir, I'll accept your plea. I'll adjudicate you guilty, sentence you to 3 days in the Orange County Jail with credit for 2 days' time served. You also have to pay court costs. Those need to be paid by March 25th of 2020, and you have 30 days to appeal the judgment and sentence to the court in writing.
Yes, ma'am.
Thank you, sir.
Thank you. All right.
Good morning, ma'am. Your name?
Brianna Johnson.
Pardon me?
Brianna Johnson.
All right, ma'am. I'm going to have you speak up, okay? Right into the microphone so that I can hear you.
Yes, ma'am.
Thank you. You're here in case number 19MM210. You were arrested for disorderly conduct. I find probable cause. I'll appoint the public defender's office to represent you. And she qualifies for pretrial release.
She does, Your Honor.
Do you want to hear an offer or resolve your case today, or do you want to be on pretrial release?
Yeah, I want to do a trial release.
Okay, I'll order pretrial release then. Thank you, ma'am.
In your honor, we'd like to have a no return to the Brunswick lanes.
Yes. Ms. Johnson, you're not to return to the Brunswick-Wakaiba lanes at 2160 East Semron. Do you understand?
Yes, ma'am.
Okay, thank you. Good morning, sir. Your name?
Coiro Lewis.
Sir, you're here in case number 19CF4087. You were arrested for possession of methamphetamine, possession of drug paraphernalia, and resisting officer without violence. I find probable cause. I'll appoint the public defender's office to represent you. Your bond on count 1 is $1,000, count 2 will be $100, and count 3 will be $100. Thank you, sir.
Jared Lasky, mental health.
Okay, we will reset Mr. Lasky, please. Good morning, your name?
Good morning, Your Honor. Jose Mayo.
Mr. Mayo, you're here in case number 19CF4103. You were arrested for aggravated assault on a law enforcement officer with a deadly weapon. I find probable cause for that offense. I'll appoint the public defender's office to represent you, sir, and your bond is $5,000 in that matter. You're also here in case number 19CF4104. You were arrested for fleeing and attempting to elude, reckless driving, and driving while license suspended. I find probable cause for those offenses as well, sir, and will appoint the public defender. On count 1, your bond is going to be $7,500. Count 2, I'll stay at $500, and count 3, I'll stay at $500. Thank you.
Your Honor?
Yes.
Before we dismiss Mr. Maya, may we briefly discuss the aggravated assault on a Leo charge? Because from my reading of the incident report, it just appeared to have been an accident. It doesn't seem as if he intended to crash his four-wheeler into the car.
Yeah, I was just riding my...
Ooh, don't do that.
Okay, so you're saying you don't believe that there's probable cause because there's no intent. Is that what you're saying?
I'm just saying that even if law enforcement believed there had been intent, I would have expected a felony criminal mischief charge, because I think the officer's theory is that he meant to hit me. He meant to cause damage to the car, but it read to me as if it was just an accident. Maybe, I don't know, maybe he got upset about the accident, for which I suspect the aggravated assault, or why he charged him with the aggravated assault, but I don't.
Ms. Bush?
Your Honor, within the four corners of the arrest affidavit, the officer describes how he became surrounded by a group and that of riders, that some slowed down, others pulled up on both sides of him, and suddenly the defendant came up and smashed the mirror of the driver's door. The officer's perception is that this was intentional of the group that surrounded him, that Mr. Maya's behavior was an intentional act, and that I believe stands for probable cause for the assault that the officer perceived. And the standard would be the reasonable officer.
Yeah, I think that there are sufficient facts within the affidavit to establish that a reasonable person can conclude that the crime was committed, so I do find that there is probable cause. Thank you, sir.
Your Honor, my other question, I'm sorry, for the driving while license suspended, maybe I missed that. Was that in the,
There's tickets, I have 2 affidavits, so there's 2 police reports, and then there's a driving while license suspended ticket.
oh, because I didn't see anywhere where he had done a search.
Pardon me?
Confirm that his license was suspended.
I did, it's attached to the face sheet. If you want to approach and look at it,
okay.
you're welcome to.
No, that's okay. Thank
Okay.
you.
Mr. Diaz, do they not give you a copy of the driving record?
No.
Oh, okay.
Your Honor, Mr. Messenger, Miss Messenger is mental health.
Okay, then we'll reset Miss Messenger. Good morning, are you Mr. Davis?
Yes, ma'am, I'm surely is.
Mr. Davis, you're here in case number 19MM2530. You were arrested for battery. I do find probable cause. Did you want to hire your own attorney, or do you want to see if you qualify for the Office of the Public Defender, sir?
Public defender.
Okay, do you have a job?
Yes, I'm supposed to be at work today.
Okay. Sir, how much money do you make every 2 weeks after taxes?
It depends, it fluctuates. Sometimes I make 5, sometimes I make every bit of.
Just give me your best
300.
estimate.
About an estimate, about average after taxes, about 338 or something
All
like
right,
that.
so about, we'll say 350. Does that sound reasonable? Do you have any kids or anybody you take care of?
Yes, I do. I'm on child support for one of my kids, and I'm fighting for DCF for my other kid in
Okay.
Georgia.
Sure. So based upon your testimony, sir, I will appoint the Public Defender's Office to represent you. And sir, your bond is $500. Thank you.
Your Honor.
Yes.
He'd like for the court to consider RR release. He can't afford the $500 bond.
Does Mr. Davis?
Yes.
No, Mr. Diaz, based on his history, he's got 14 felonies, 9 misdemeanors, and a failure to appear. Good morning, sir. Your name?
Edward Lewis.
Mr. Lewis, you're here in case number 19MM2523. You were arrested for possession of drug paraphernalia, sir. I do find probable cause. I'll appoint the Public Defender's Office to represent you. Is there an offer for Mr. Lewis?
Yes, Your Honor. I may have just one moment to look at his face sheet. The offer is an adjudication, 5 days, 2 days credit, time served, and court costs.
Okay.
Your Honor, before he makes that decision, he wanted to know if the court was inclined to take any action on his out on bond.
I'm not going to take any action on that case.
Would you be able to bond? You could do that too. So it's going to be about $100 for the bonds. Yes, she's not going to do anything. So. Okay. Your Honor, he's going to reject the state's offer.
Okay.
Bond set at 500.
Yes, if that's what it came in as, I'll stay at 500.
Okay.
Yep. Thank you. Oh, I have it right here. I thought I did it. Good morning, your name?
Corey
Corey, what's your last name?
Ingalls.
Mr. Ingalls, you're here in case number 19MM2527. You were arrested for petty theft, sir. I find probable cause and will appoint the public defender's office. The bond is set at $250. I want to release Mr. Ingalls' ROR.
Your Honor, may we have a no return to the scene?
Yes.
7-Eleven.
Mr. Ingalls, you can't go to the 7-Eleven at 846 South Kirkman. Do you understand?
Yes.
Did you hear what I said?
No.
Okay,
Sorry.
I didn't think you did. You cannot return to the 7-Eleven at 846 South Kirkman. All right?
Okay.
Thank you. Good morning, ma'am. Your name?
Kiana.
What's your name?
Kiana.
What's your last name?
Johnson.
Ms. Johnson, you're here in case number 19MM209. You were arrested for disorderly conduct. I find probable cause and will appoint the public defender's office. And I'm going to order you to pretrial release, ma'am. You're also not allowed to return to the Brunswick Wakaiva Lanes bowling alley. Do you understand? You need to answer out loud, ma'am.
Yes, ma'am.
Okay, thank you. Good morning, your name?
Rashid Mahoney.
Mr. Mahoney, you're here in case number 19MM2533. You were arrested for possession of cannabis less than 20 grams and resisting officer without violence, sir. I find probable cause. I'll appoint the public defender's office, sir, and I'm going to release you to pretrial release. Thank you.
Brian Rock refused.
Okay, we will reset Mr. Rock's case. He refused. Good morning, sir. Your name?
Donald Eugene World, W-O-R-L-E-S.
Mr. Worrells, you're here in case number 19MM2524. You were arrested for petty theft with a prior conviction, sir. I do find probable cause. I'll appoint the public defender's office to represent you. Is there an offer for Mr. Worrells?
The offer is an adjudication of guilt, 7 days, 2 days credit time served, no return to the scene, abide by all trespass warnings, and if I may, I just need to make sure that there was recovery. And as it was non-perishables, there would be an order of restitution for $106.90.
Okay.
Or it was perishables, I'm sorry.
Yes.
They didn't recover the food?
they can't restock the food once it's,
It was steak and shrimp. I don't think they can put it back, is what she's saying.
Oh.
Okay, my bad.
Okay, Mr. Worrells. Did you read and understand this plea form before you signed it?
Yes, ma'am.
Okay. Do you have any questions about any of the rights that you're giving up today?
No, ma'am.
Okay. You understand the plea agreement is an adjudication of guilt, 7 days in the Orange County Jail with credit for 2 days, no return to Walmart, and you have to pay back the $106.90 to Walmart.
Yes, ma'am.
Okay.
They gave me a trespassing warrant, but because I had the past record, that's why the cop brought me in.
Okay. Mr. Worrells, do you understand if you're on probation for anything anywhere that this plea may violate your probation?
I have no probation.
Okay. Do you also understand if you're not a United States citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, sir, I'm going to accept your plea, adjudicate you guilty, sentence you to 7 days in the Orange County Jail with credit for 2 days. You cannot return to the Walmart at 12550 South Orange Blossom Trail. There's also going to be an order for restitution in the amount of $106.90. You need to abide by all the trespass warnings and pay court costs. Those need to be paid by March 25th of 2020, and you have 30 days to appeal the judgment and sentence of the court in writing, sir. Thank you.
Yes, ma'am.
Good morning, sir. Your name?
Sedino Martino.
Mr. Martino, you're here on an out-of-county warrant from Seminole County, sir. This is for a failure to appear for a pretrial conference. Your bond is currently set at none, and you'll see a judge when you get to Seminole County, sir. Thank you. All right, we'll reset Mr. Aim. And we'll reset her as well then. What about Mr. Davis, Charles Davis? It's a motion for ROR.
He was released, yeah.
Oh.
He's been released.
Okay. Then I'll take no action on that. Are we ready for 33 day?
yes, Your Honor.
Okay.
And Your Honor, I put a 33-day list, annotated list at the bench.
I do see that, Ms. Bush. I have it right here.
CF 12515 Anthony Mells. That will be denied and information was filed. Eighteen CF 17847 Michael Hernandez. That information, that motion will be denied. The information was filed. Nineteen CF 1650 Jonathan Sedeno. Ms. Bush, I don't see that on the list.
What was the name?
Jonathan Sedeno, 19 CF 1650.
One moment. It is number 3 on the ROR list that I have, 2019 CF 1650.
I don't see it. Is it granted or denied?
It should be denied, Your Honor, and information was filed. And the filing ID is listed, and it depends on which list the court is. If you're looking at the list that I annotated, it is not in the same order as the ROR list.
I don't have an ROR list. I just have the.
Well, the list from corrections that has misdemeanor arraignments at the top is in a different order from the list that it appears the court was reading from.
Okay.
It's Jonathan Lewis Sanchez Sedano.
I'm just gonna look them up on
And it's
Odyssey.
on this list as Jonathan Lewis Sanchez.
Okay.
It does not have Sedano on the corrections list, Your Honor. Because it's a hyphenated name. It's not actually hyphenated.
All right. 19 CF 1759 Glenn Wright. That motion will be denied. The information was filed. Nineteen 1430 Daryl Mitchell. That motion will be denied. Nineteen CF 2416 William Rafferty. That motion will be denied. CF 2579 Shaquande Lockhart. That motion will be denied. 19 163 Corsair Azula, that will be granted. Nineteen CF 2551 Anthony Jones, that motion will be granted.
Yeah, I'm sorry, who was that? That last one?
Anthony Jones, granted. Nineteen CF 2551.
I don't have any.
I don't have an
I have
Anthony
it, and the notice
Jones.
of non-filing was filed on March 21st.
And Your Honor, I don't have an Anthony Jones on either list.
The order was in, I didn't bring the order to court, so it was in the list. But it should be granted. The motion was filed on March 22nd. The notice of non-filing was filed on the 21st.
And that was 19.
And, I'm sorry, 19 CF 2551.
Thank you.
Mm-hmm.
Jones.
19 CF 1977 Eric Rios, that motion will be denied. And 19 CF 1824 Randolph Chamberlain, that will be granted. CF 2541, that motion will be granted. Willard Ellis.
Did you just see the one I sent you?
19 CF 2307 Nelson Rushing, that will be denied.
Request for
19 CF 2549 Annette Stallman, that motion will be granted.
Your Honor, that should be denied. A request for administrative transfer was just emailed to Defense Counsel, and it was transferred from felony to county court where a misdemeanor information has been filed.
Is that correct, Mr. Diaz?
I don't have the MM number. What's the MM number?
There is no MM number. That's a clocked-in copy from where they walked it over.
No, I mean, where is he? Was he in the new case?
They have not, they just get a clocked-in copy. They don't get an MM number. It's not assigned right then. It's the request for administrative transfer filed in court this morning at 8:36. And it's a misdemeanor information. That's the way the requests for administrative transfers are done. They're walked over to the clerk clocks them in, and then a MM number is assigned later.
But that doesn't make sense. The case has to exist first before you transfer
No, that's the way CF felony cases are transferred to county court, and county court cases are transferred to felony or circuit court. It's done by a request for administrative transfer, and then that misdemeanor information is filed. It just has, if you'll look at the information on there.
But the case has to exist first.
The case does exist in felony court. It's being transferred from circuit court to county court. It does exist. We're just not filing felony charges. We're filing misdemeanor charges.
So the misdemeanor information was filed at 8:30 this morning?
Yes, Your Honor, and if the court wishes, I will provide the court also with the clocked-in copy.
No, Ms. Bush, I take it at your word. So the motion will be denied.
Your Honor, I'm sorry. I would like to see the misdemeanor information.
She said she sent it to you.
No, the request for the administrative transfer.
And the second page is the misdemeanor information.
There's nothing here. It's not even signed.
That is those are the clocked-in copies, along with the capias, and the clerk's office clocked in the top copy, which was the request. That whole packet is taken to them, and they just stamped that top page. And unless defense counsel feels that this is not true, and takes exception to this, this is the standard procedure for the clocked-in transfers, Your Honor.
Your Honor, it's not that I believe that it's been private. That's not it. It's just my understanding of transferring a case is that there has to be another case to which the felony record can be transferred to. It has to exist. And jurisdiction doesn't attach at the county level until the misdemeanor information is filed. And there's no way for me to confirm right now that it's filed other than the stamp that exists on the request for administrative transfer. But I have no way of confirming right now, nor does anybody, I guess, that anything exists at the county level, and that's exactly what the language of the notice reads, that where a misdemeanor information has been filed.
And Your Honor, the request for administrative transfer, along with a misdemeanor information, is taken to the clerk of the court. They stamp that request for administrative transfer. They have the signed misdemeanor information. Our office then, because they walk over with the signed information and they have that original information that they just printed out an extra copy of. Mm-hmm. They put it together, and that's what I receive. There is a misdemeanor information, signed misdemeanor information in the court file along with that request for administrative transfer. It has not yet been scanned in, nor has it been assigned a misdemeanor case number at this point.
Okay, Your Honor, I propose then that we...
Good afternoon, I'm Judge Amy Carter. This is Courtroom 1, Session 2. Could I have the attorneys place their appearances on the record, please?
Good afternoon, Edith Bush for the Office of the State Attorney.
And Attorney Manuel Soto Diaz with the Public Defender's Office.
Okay. Ms. Bush?
Yes, Your Honor. The state has asked the court to address the earlier release on own recognizance motion that defense filed in Annette Marguerite Stallman's case 2019 CF 2549AO. And the state asked for this to be addressed again and at the beginning of the session, because the court had asked the state to provide the court with a signed copy of the misdemeanor information that accompanied the request for administrative transfer, that the state provided defense counsel with a clocked-in copy of that request for administrative transfer,
Yes.
along with an unsigned copy of the misdemeanor information. The state asserted that a misdemeanor information, the signed information, is what was filed with the clerk's office, along with that request for administrative transfer. To that end, the state attempted over the break to, via email to the clerk's office, their intake unit downtown, and requested that they send us a copy of that signed information. They have not been able to respond to that request. Therefore, the state does not have a copy of that signed information. However, the state would assert to the court that as an officer of the court, having received notification that that signed information was filed by another officer of the court, the downtown assistant state attorney that filed it, and from his assistant who walked the request and the information to the clerk's office, having put on the record that an information has indeed been filed, under Rule 3.134, the state has met its obligation and has filed an information in this matter. Additionally, the state would point the court to the administrative order that governs initial appearances and requests for administrative transfer. In the administrative order, it says that for administrative transfers, the state is obligated to provide the clerk and the court with a signed request for administrative transfer. The state has done that. The state has fulfilled its obligation under the rule and under the administrative order. The state asked that the court deny the motion for release on own recognizance.
Mr. Diaz?
Your Honor, the defense in this case filed a motion in which we allege that the state had failed to file charges against Ms. Stallman within 30 days. The state was provided with additional time to file the information. We arrived at a hearing today, and the obvious paper that would defeat the defense's motion would be producing an information that had been filed, either in felony court or in county court. The state asserted earlier that it had filed an information in county court. Now, I've seen many informations filed, either one electronically or handed in directly to the clerk's office. A copy of that information should exist somewhere, either in the possession of the state, which I would argue is only obvious since they had possession of the original, or somebody has to have proof of that filing. If the state is unable to produce a copy of an information either filed in county court or in felony court to defeat our motion, then that motion should be granted, Your Honor. With respect to the request for administrative transfer and whether that should presuppose a previous filing, I think it's tempting, but Your Honor, to be quite honest with you, that misses the mark. There has to be another case that exists first. And if that other case exists first, well, then why don't we have evidence of that other case? Because we wouldn't transfer a case to something that doesn't exist. So I suspect that, I don't know, not even the request for administrative transfer has been signed. The information, which might be evidence of a future filing, for all I know, wasn't signed. And I'm not ready today to accept this as evidence that an information has been filed such that it would defeat the defense's motion for RR release under 3.134.
Your Honor, if the state may respond just briefly.
Sure.
While the state acknowledges Mr. Soto Diaz's argument, however, the state would assert that unless Mr. Soto Diaz has a good faith belief that an information was not filed, along with the request for administrative transfer, then Your Honor should stand with the original ruling, which was originally denying the motion for release on own recognizance, as the state has provided sufficient proof that not only was the request, and the request is asking the clerk to transfer a circuit court case to the county court. That's all the request is. That request is, and traditionally has been, accompanied by that information. Here, the clocked-in copy of the request for administrative transfer is also unsigned, but it was clocked in because that is merely the receipt process that the state utilizes between the state and the clerk's office.
Okay.
Your Honor, if I may just briefly respond to that, and this will be the last of my argument, because I have, there's a suggestion here that I believe that there's something nefarious going on. That's not it, Your Honor. It's just that we filed a motion. The easiest way to defeat that motion is just to show up with an information, or to allow me to see that information has been filed in any court, county or otherwise. There doesn't have, I'm not trying to cast aspersions. It's just that is what's required. We made an allegation that information hasn't been filed, and it's incumbent upon the state now to prove me wrong. And so I would ask that this court, if I remember correctly, by the way, the court granted the motion originally and then backtracked when we started discussing the propriety of the administrative transfer and what weight it has with respect to the motion. My contention is going to continue to be that this is meaningless unless there is, in fact, a county case or some misdemeanor case, some information filed related to Ms. Stallman's, to the incident related to Ms. Stallman, for which I would ask that this court grant the motion.
I am going to deny the motion. I do think that I'm satisfied that an information was timely filed in this case. I understand that there's not the actual signed copy here in court, but I am satisfied by the testimony or the information provided by Ms. Bush as an officer of the court in her office that there was an information signed that was submitted with the request for administrative transfer. And I'm going to deny the motion. Thank you.
Your Honor, I'm sorry, before we conclude the hearing, I'd like to go ahead and have this entered as an exhibit. The record is not complete. I didn't see this on the felony case record.
What is it?
The request for administrative transfer.
Okay, it has not been scanned in.
Right, there's a lag time between what's filed and given to the clerk's office and what's scanned in, but you can approach and we can have it made part of the record here. Thank you.
what interpreter?
Interpreter is available.
Oh, okay.
Oh, great. So first, we have Alexis Benitez Martinez. Good afternoon, sir. Your name?
Bien. Alexis Ali Benítez.
Alexis Ali Denite.
Sí.
Mr. Interpreter, I didn't hear what you said. Could you repeat that?
Alexis Ali Denite.
Adalid Benítez. Alexis Adalid Benítez.
Alexis Adalid Benítez.
Okay. Mr. Benitez, you're here in case number 19 CT 618, sir. You were arrested for driving under the influence and driving while license suspended or revoked. I do find probable cause for driving under the influence. I do not find probable cause for driving while license suspended or revoked.
Sí, por la licencia que la.
I'm going to set your bond at $500 on count 1. I'm going to ROR you on count 2. And he does not qualify for the Office of the Public Defender, according to his form. Mr. Benitez, it says that you make $900 every week. Is that correct?
Yes.
Okay. And you have 2 dependents, is that also correct?
Sí, correcto.
Yes.
All right, sir. You're going to need to see if you can hire an attorney. I'm going to set your case for a determination of counsel hearing in 1 week. If you're unable to hire a lawyer, we'll readdress that issue then, sir.
Yes.
All right. Thank you.
I apologize, Your Honor. The court did not find the count 2 charge, driving with suspended revoked license.
Correct.
Based, and the court does have the information sheet that has his out-of-state criminal history as well.
I do, but I don't have a ticket. I don't have any allegation. The 4 corners of the
Okay.
affidavit say
All
nothing
right.
about it. So no, there's no PC
Thank you,
for
Your
count
Honor.
2. Good afternoon. Your name, sir?
Víctor Hernández Soriano.
Victor Hernandez Sori.
Sir, you're here in case number 18 CF 14498. You failed to appear for pretrial conference on February 6th of 2019, sir. At this time, your bond is none. I will appoint the public defender if they weren't previously appointed, sir, and you'll need to see the court downtown to see if the bond can be modified. Thank you. Sir, you also have 18 CF 14499. In that case, you failed to appear for pretrial conference as well on February 26th of 2019. Your bond is also set at none in that case, sir. Thank you. Good afternoon. Your name?
Mi nombre es Juan Veloz Costa.
My name is Juan Veloz
Acosta.
Acosta.
Okay, Mr. Acosta, you're here in case number 19 CF 4112. You were arrested for possession of cannabis with intent to sell or deliver and possession of cocaine. I find probable cause for both of the offenses, and I'll appoint the public defender's office to represent you, sir. I'm going to release Mr. Acosta, ROR, as to both counts. Thank you, sir.
Gracias.
Thank you.
Good afternoon, sir. Your name?
Carlos Modesto Zip Balán.
Carlos Modesto Zip Valor.
Balán.
Balán.
Sí.
Sir, you're here in case numbers 19 CT 623 and 19 CT 622. You were arrested for DUI with property damage and no valid driver's license, sir. I find probable cause for both of those offenses. I'll also appoint the public defender's office to represent you. And at this time, I'll say your bond on count 1 at $500 and count 2 $100.
Una cosa que no tengo que llamarme a nadie. Tengo que el celular.
Good afternoon, sir. Your name?
Eduardo Galarza.
Perdón.
No te escucho mucho. Can you put some more, a little bit, no? Mi nombre es
Repita su nombre.
Eduardo Galarza.
Eduardo Galarza.
Sí.
Sir, you're here in case number 19MM2541. You were arrested for assault, domestic violence. I do find probable cause, sir. Your affidavit that you filled out indicates that you do not qualify for the office of the public defender, sir. It says you make $1,000 a week. Is that correct?
No, la quincena.
No, every 2 weeks.
Okay. Is that after taxes?
Por ahora yo no estoy haciendo taxes porque no tengo seguro social.
For now, I'm not filing taxes because I don't have a social security number.
And you have no dependents? You don't take care of anybody?
Sí, tengo 2 hijos.
Yes, I have 2 kids.
Uno
Okay.
de 10 y uno uno de 10 y uno
So
de
if he
11.
makes 1,000.
110 and 111.
Okay. Sir, I've corrected that on your form, and you do qualify for the Public Defender's Office, and I will appoint their office to represent you. I don't have a face sheet for Mr. Galarza. Pardon me? I don't. Mm-mm. Thank you. No, are there no witnesses here for Mr. Galarza?
No, you're.
Okay. Mr. Galarza, I'm going to set your bond at $500. I'm going to order that you not have any contact with Keisha Villalobos, and you are to maintain a separate residence from Miss Villalobos. You're also not to possess any weapons or any firearms while you're out on bond, sir. Do you understand?
Sí.
Okay. Do we have a
Yes.
no contact form for Mr. Galarza to sign? We do, okay. Thank you.
Your Honor,
Yes.
he's likely going to need a one-time opportunity to recover his personal effects.
Sure. Sir, you can go back to the house one time to collect your belongings if you need to. You have to coordinate that with the police before you go over there. Do you understand?
Sí.
Okay.
Yes.
All right, sir. Thank you.
Thank you, Your Honor. I'm sorry.
Sure, no problem. Thank you. Sir, good afternoon. Your name?
Jonas Perez.
Jonah Perez.
Mr. Perez, you're here in case number 19MM2538. You were arrested for battery, domestic violence. Were the DV victims told to be in this courtroom, or do they think they're supposed to be in courtroom 2?
I see that there's some here.
Okay,
So I believe they were told to come.
okay, thank you. Sir, you were arrested for battery, domestic violence. I do find probable cause for that offense. Did you want to see if you qualify for the Office of the Public Defender, or do you want to hire your own lawyer, sir?
¿Puedo preguntarle a al abogado que está presente?
Can I ask the attorney that is present?
As to what you should do? Or are you saying you want him to represent you?
Porque no entendí bien la pregunta que me hizo, tú sabes, si fui arrestado ciertamente, porque como ella, sabes, la situación no fue así como...
Well, the thing is, I didn't really understand the question, because if I was arrested because things didn't really happen the way they...
Can I have a brief moment with him?
Sure,
I think I can
please.
maybe just clarify that. We're ready, Your Honor.
Okay. So, Mr. Perez, do you want me to see if you qualify? Oh,
Try again, please.
Mr. Perez, do you want to see if you qualify for the office of the public defender?
Yo mismo me representaré.
I will represent myself.
Okay, sir. Are there any witnesses here for Mr. Perez?
No, Your Honor.
Okay. Mr. Perez, I'm going to set your bond at $500. I'm going to order that you maintain a separate residence from Livians Gonzalez. You're not to possess any weapons or any firearms while you're out on bond, sir. Oh. Yes, that's right.
Oh, that's right, Your Honor.
She is.
She's here.
Mhm.
How did that happen? Oh,
She must not need an interpreter.
Ah, that makes sense.
Okay.
You
Yes,
did
please.
tell me that earlier.
Okay.
And I didn't see on here a codependent.
Yeah, I didn't make the connection because of the interpreter. Mr. Perez, I'm going to set your case for determination of counsel hearing in 1 week. That way, if you change your mind about representing yourself or you don't hire a lawyer, that we can readdress the issue, okay?
Yo estoy de seguro que puedo representarme.
I'm certain that I can represent myself.
Okay. Did you happen to bring her paperwork with you? Good afternoon, ma'am.
Good afternoon.
Your name?
Livanis.
Are you Livanis Gonzalez?
Yes, ma'am.
Ma'am, we were just addressing Mr. Prez's case, where you are an alleged victim in that matter. And I wanted to ask you a couple of questions. Did you want to have contact with Mr. Prez?
Yes, Your Honor.
Okay. Do you live together?
We do live together.
Do you want to continue living together?
If that's possible, yeah.
Okay. Are you afraid of Mr. Prez?
Actually, no.
Okay. If you thought that your safety was in jeopardy, would you feel comfortable calling law enforcement to report that? If you thought that Mr. Prez was going to hurt you, would you call the police?
Is he able to translate? I can't understand very well what you're asking me.
You need a translator?
Yeah, just for that question.
Okay.
Your Honor, I'm sorry. So that it could be fair for both, if the defendant is saying that she only needs an interpreter for one question, then the interpreter can do it over the loudspeaker and both can hear at the same time. It's up to Your Honor.
I don't have any objection to that. Do either of the parties?
No, Your
No.
Honor.
Okay, that'll work.
It's just only for that question. Okay.
Can Your Honor repeat the question, please?
Sure. Ma'am, if you were afraid of Mr. Perez, if you thought he was going to harm you, would you call the police to report that?
Oh, yes,
Señor.
Sí, yeah. Now I understand, sorry.
Okay. So as I understand it, you would call the police if you thought that Mr. Perez was going to hurt you. Is that right?
If I thought.
Okay. Ms. Bush, do you have any questions for the witness?
No, Your Honor.
Okay. Mr. Perez, do you have any questions of the witness?
Que si me ama.
If she loves me.
Okay. Well, just questions related to what I asked her, so.
No, it's okay.
Okay.
Sorry.
Now, ma'am, you're here in case number 19MM2539. You were also arrested for battery, domestic violence, ma'am. Mr. Perez, I'm going to ask you the same questions that I asked her. Do you want to have contact with her?
Sí.
Yes.
Are you afraid of her?
No.
No.
If you thought that she was going to hurt you, would you call the police to report that?
Yes.
Yes.
Ms. Bush, do you have any questions?
No, Your Honor.
Okay. And I am going to appoint the public defender in Ms. Gonzalez's case. Mr. Diaz, did you have any questions for Mr. Perez? Okay. Yes. Okay. Would he, if I'm going to order no hostile contact, would he qualify for pretrial release as well? The only thing that I see is, I don't think that he qualified because you couldn't verify any community ties, or, because he has no history at all.
He did, but if you ordered to, like, a re-interview to see the PTR or above, you can do that.
Okay, then that's what I'll do. All right, so I'm going to order for Mr. Perez, I'm going to order pretrial release or $500 bond. I'm going to modify what I said before, and you're going to have no hostile contact with Ms. Gonzalez, but you're not to possess any weapons or any firearms while you're out on bond. Do you understand? Mr. Perez, I see you shaking your head, but I need you to answer out loud, please.
Yes. Yes.
Okay. And Ms. Gonzalez, I'm also going to order for you that you not have any hostile contact with Mr. Perez. And you are not to possess any weapons or any firearms while out on bond. And I'm going to order pretrial release for you as well. Thank you, ma'am.
Thank you.
And Your Honor, just for the record, on Ms. Gonzalez, the state would object to pretrial release as it is a crime of violence.
Okay, thank you, Ms. Bush.
Your Honor, are those all the interpreter cases?
They are? Oh, okay, yes, then I think we're finished.
Okay, thank you.
Thank you very much.
You're welcome.
Ahmed, is that?
He's Arab.
Huh?
He's Arab.
What about Nelson Velazquez Alaski? All right, and then same with, oh, no, this is our Arabic, okay. You're on? Good afternoon, ma'am. Are you there?
Good afternoon. Yes.
Okay. It's been working fine. Today's the first day that it's not. Good afternoon, sir. Your name?
مصطفى عماد.
أنا بحضرتك شو اسمك سيدي؟
Excuse me?
Might need a redo.
Madam Interpreter?
Yes. Yes, ma'am?
Yes, I'm going to call the case at this time.
Yes.
Okay, this is case number 19 CF 4114. Sir, could you tell me your name, please?
مصطفى عماد.
رقم القضية
Mr. Ahmed, I know that you may understand some things that I'm saying, but I need you to wait until the interpreter finishes what she's saying and then answer. Go ahead, ma'am.
رقم القضية 19C1114. ما هو اسمك سيدي؟
مصطفى أحمد.
مصطفى أحمد.
Thank you, sir. You're here. You were arrested for false imprisonment, domestic violence, and battery domestic violence. I find probable cause for both of those offenses, sir. I'll appoint the public defender's office to represent you. Good afternoon, ma'am.
حضرتك سيدي تم اعتقالك بتهمة العنف الأسري أو العنف المنزلي وأيضا الاعتداء، وأنا شايفة أن هذه التهم ثابتة وسأقوم بتعيين محامي عام أو مجاني للدفاع عنك.
Okay.
Madam Interpreter, I know I was speaking very quickly. I don't know if you need me to repeat anything or if Mr. Ahmed needs me to repeat anything.
No, Your Honor, I interpreted what you said. Would you like me to ask Mr. Ahmed if you...
Yes, please.
Yes. السيد أحمد، هل بدك، أنا بعرف إن حكيت بسرعة، هل بدك إني أعيد كلامي مرة ثانية؟
لا.
No.
Okay. Good afternoon, ma'am.
أهلا حضرتك سيدي، سيدتي، عفوا.
Madam Interpreter, we do have a witness here as well who I believe is going to need the... No? Ma'am, you speak English? Okay. Then we just need you to translate for Mr. Ahmed.
Yes, Your Honor.
Hi, ma'am. Could you tell me your name, please?
Manal Arafat.
Could you move closer to the microphone?
Manal Arafat.
Ma'am, what would you like to tell me?
I'm scared. And I'm scared for my children. And I don't want to fear what he can do to retaliate or out of spite, like take my kids away from me, out of the country, or anything of that nature. Wanted peace.
Okay. Thank you, ma'am. Ms. Bush, do you have any questions?
Yes, I have one question. Ma'am?
Yes.
Have you obtained a protective injunction against Mr. Ahmed?
Yes, this morning.
Thank you. I have no further questions.
Mr. Diaz?
Nothing from the defense.
Okay. So at this time, Mr. Ahmed, I'm going to order that you not have any contact with Ms. Arafat. You are not to return to 202 Sienna Gardens Circle. You are to maintain a separate residence.
That's not my address.
Are you the Fishtail address? Okay. So take that off. But you're not to return, so you can return to the Sienna Gardens address, sir?
No, that's my brother's address. I have an injunction where he can't, if I'm there, go there either. So where I reside is the 1991. That's my home. That's my
Okay.
kid's home.
Your Honor, law enforcement just responded to her brothers, but the events took place in the home.
Okay.
I was there because I didn't want to go home.
I understand, ma'am. Okay. So,
Your Honor, the state would ask for a no return to the 1991 Fishtail Fernway and also a no return to the Sienna Gardens Circle address.
okay. Mr. Ahmed, I'm going to order that you not return to the Sienna Gardens Circle address or the Fishtail Fernway. You're not allowed to, or you're also to maintain a separate residence from Ms. Ahmed and abide by the injunction that she says is in place. You're not to possess any weapons or any firearms, sir.
السيد أحمد، يعني أنا أمرك أنك يعني ممنوع أنك ترجع إلى العنوان اللي هو في سيانا جاردن، وأيضا العنوان اللي هو 1991 فرنواي، وأيضا مفروض أنك يكون عندك سكن منفصل عليها أيضا، وممنوع أنه يكون في حوزتك أو يكون معك أي أسلحة أو أسلحة نارية.
Okay.
Your Honor, he'll need a one-time return to recover his personal effects.
Mr. Ahmed, I am going to order that you can return to the house one time with the police to get your belongings.
سيد أحمد أنا سأعطي أمر أنك ترجع إلى البيت مرة واحدة مع الشرطة حتى تأخذ متعلقاتك أو أغراضك.
Okay.
Okay, but I want you to understand that you need to contact the police and coordinate that with them before you go. You cannot just show up at the house to get your things. Do you understand?
لكن بدي إياك تفهم أنك ضروري تتصل بالشرطة وتنسق معهم ذهابك إلى البيت يعني ممنوع تروح للبيت لوحدك من غير شرطة.
If you show up to the house without the police, sir, you will get arrested. Do you understand me?
حضرتك سيدي لو ذهبت إلى البيت من غير الشرطة سيتم اعتقالك. هل حضرتك فهمني؟
Fair. Yes.
I understand.
And I have this is a no contact order, sir, that you just signed. Do you understand what this is?
Yes.
في هذا الأمر بعدم الاتصال وأنت وقعت عليه. هل حضرتك مفهوم شو اللي مكتوب فيه؟
أيوة.
Yes.
Okay. I know that we're using the services of an interpreter right now, and this is in English. Do you have any questions about the form that you just signed?
أنا أعرف إن إحنا نستعين بخدمة الترجمة وهذا مكتوب باللغة الإنجليزية. هل حضرتك فاهم الورق شو مكتوب في الورق اللي وقعت عليه؟
مش كله.
I don't understand everything.
No, not everything.
Okay. Well, we'll go over it so that everything's very clear.
سنراجع معك حتى يكون الأشياء تكون معك واضحة.
Okay. This says that you cannot have any in-person or face-to-face contact with Miss Arafat.
وهو مكتوب هنا إنك ممنوع يكون عندك أي لقاء شخصي أو وجها لوجه مع السيدة عرفات.
You cannot write to her. You cannot call her.
ممنوع إنك يعني تكتب لها أي شيء أو تتصل بها.
You cannot page her, fax, or text her.
لا يمكن إنك تتصل بها أو يعني تبعت لها رسائل خطية على التليفون أو تبعت لها فاكس.
You cannot email her.
لا يمكن إنك تبعت لها بريد إلكتروني أو إيميل.
You cannot leave any notes or cards on her car, or at her work, or her home.
ممنوع إنك تضع أي ورقة مكتوبة على سيارتها أو أي بطاقة مكتوبة على سيارتها أو مكان عملها أو بيتها.
You cannot have anyone, including your children, send messages to her or contact her on your behalf. Do you understand?
لا يمكن إنك تطلب من أي شخص يعني وهذا يشمل أطفالك أيضا حتى الأطفال إنك تبعت لها أي رسالة أو تحاول اتصال بها عبرهم. هل حضرتك فاهم؟
Yes.
You cannot do anything that intimidates her in any way.
لا يمكن إنك تعمل أي شيء اللي ممكن إنه هو يشعرها بالخوف بأي طريقة.
In other words, sir, you cannot communicate with Miss Arafat in any way. Do you understand?
يعني بطريقة أخرى ممنوع سيدي إنك تتصل بالسيدة عرفات بأي طريقة من الطرق. هل حضرتك فاهم؟
Yes.
Okay. This also includes contact with your children.
وهذا يشمل أيضا الاتصال عبر يعني عن طريق أطفالك.
You will need to have a hearing set in the division for this case to determine whether or not contact with your children will be allowed. Do you understand?
Yes.
سيتم عقد يعني جلسة يتم تحديد موعد لتحديد لو ممكن أنك تتواصل مع أطفالك. هل حضرتك فهمت؟
Your
Yes.
Honor,
طيب.
I'm sorry, go ahead, Madam.
Your Honor, the state would also ask, in addition to a no weapons order, that he surrender his passport.
سيدتي القاضية الولاية تطلب أيضا بالإضافة إلى ممنوع إنه هو يكون معه أي أسلحة. الولاية تطلب منه أيضا إنه هو يعطيها جواز سفر.
Within 24 hours of his release.
لازم إنه هو يسلم جواز سفره خلال 24 ساعة من إطلاق سراحه.
Your Honor, I'm going to object to that request for a reason that Mr. Ahmed is going to share with the court. He wanted to explain to the court that he now has nowhere where he can go. He might have to return to Egypt just to, in effect, not be homeless. I understand the state's concerns, but Mr. Ahmed is not permitted to go to either one of the two properties. Go ahead, Mr. Ahmed.
I know this is going to be lost chance to me to talk. If you don't mind, I can talk.
Say in
Well,
Arabic. Speak in
Mr.
Arabic.
Ahmed, I don't
No?
want to deny you your opportunity to speak, but I don't want you to tell me anything about your case because everything in this room is recorded and can be used against you.
I'm just going to say something, even be against me. I don't have no problem if you don't mind to let me speak.
Mr. Diaz?
You could tell her that, but don't talk about what happened. Okay.
I'm not going to talk about the case, what happened.
Okay.
I'm going to talk about if she don't want me, why she let me go? Why she want me here? I want to go see my family. My mom passed 2 years ago. I didn't get a chance to see her. My father now got a cancer in the hospital. And I want to go. I don't want to come back. I'm not going to come back.
Okay. Thank you, Mr. Ahmed. I am going to order, sir, that upon 24 hours of your release, you are to surrender your passport to the clerk of the court. But before I continue and finish with the conditions, I want to make sure, sir, that you don't have any questions about the no contact order because I went over it with you piece by piece. So do you have any questions about this whatsoever?
No, I understand.
Okay. All right, and at this time, sir, on count one, I'm going to set your bond at $5,000, and count two, I will set at $500. Thank you. Ma'am, do you have any questions?
No, thank you.
Okay, thank you. Did I miss something? Oh, okay. Sir, do you have any other questions?
سيدي هل عندك أي أسئلة أخرى؟
I don't know why she want me here. She want me stay. If she not gonna give me the key, she got the key, she got the phone, she got the money. If I'm walking from here, I don't know what I'm gonna do.
Okay.
She have everything.
All right. Thank you, sir. Madam Interpreter, I think we're finished. Thank you very much.
You're welcome.
Okay.
Is there anything else I can help you with today?
No, ma'am. Thank you very much.
You're welcome. Thank you for choosing our services. Have a good day. مع السلامة.
Good afternoon, ma'am. Your name?
Shania Basley.
Ms. Basley, you're here in case number 19 CF 2172. You were arrested pursuant to a warrant where probable cause was previously found for grand theft, third degree, retail theft, $300 or more, and possession of an anti-shoplifting control device, ma'am. I will appoint the public defender's office to represent you. I'm gonna set your bond at $1,500 on count one, ma'am, $150 on count two, and $100 on count three. You're also here in case number 18 MM 11048. That is a violation of probation. where it's alleged that you committed the new law offense that we just discussed, ma'am. And your bond in that matter is set at 0. I'll also appoint the public defender in that matter as well. Thank you. Good afternoon. Your name, sir?
Ramon Brodo, Miss.
You Ramon Baroto?
Yes, sir.
Sir, you're here in case number 18 CF 5989. You failed to appear for the reading of a jury verdict on February 19th of 2019, sir. Your bond is 0, and I will appoint the public defender's office if they weren't already appointed. Thank you, sir. Pardon me. Good afternoon, sir. Your name?
Good afternoon. My name is Robert Lee Gillard.
Mr. Gillard, you're here in case number 19 CF 4116. You were arrested pursuant to a warrant where probable cause was previously found. I'll appoint the public defender's office to represent you, sir. I'm going to set your bond at $500 on count 1, sir, and $100 on count 2.
Your Honor, I'm sorry, what was the bond amount on count 2?
100?
100? Okay. Mr. Gillard, can you make that bond? 500, 100?
I can make the bond. I can make the money. I got my money. You got my debit card is in the down here. Ain't nobody there to use it. There's no point. I gotta do it. Well, I mean, I can get the money. My money's be posted Monday. On the first of the month.
Dexter, can you explain to him how to release property? The gentleman right there, you got a solution for it. I promise.
Good afternoon. Your name, sir?
Kenneth Ray Jenkins.
Mr. Jenkins, you're here because it's alleged that you violated your pretrial release conditions by failing to report on January 22nd of this year, sir. I'm gonna set bond, sir, at $500 on count 1 and $100 on count 2. Just want to make sure with pretrial services or with corrections, I had this in the other courtroom because he was brought in on the violation of the conditions of pretrial release. And the other time it was a separate charge, so we had to close out the PTR. Like, the bond is not on the violations of pretrial release. That's not a case. Just want to make sure that's clear, that the bond is being set on the 19 CF 303 matter. I just don't want there to be a double case.
Double case, okay. Is there another call?
Well, because see, he
That
on
will
pre-trial
be.
release for this case. They brought him in on the violation.
So is that it?
But when I was in the other courtroom, there seemed to be an issue with the way that it was in the system, that this was a separate case, and it's not. Okay, that's the only paperwork you have? Okay. Mr. Diaz, do you understand what I'm saying?
I do.
You just might want to be
I
on
just
the
don't know how
lookout for
to
it.
convey that. Meaning that you don't want this to be looked at as another case for which there are new conditions of release, rather these are different conditions of release on the old case. Is that what I understand?
Right, I just know
Correct.
that when I had this issue before, it was a holdup in someone trying to post their bond because it looked like there were two separate, like he still didn't have a
Cases.
bond on the underlying
Right.
case. So I guess the clerk's paperwork will be clear that it's on the 303. Okay.
All right. See you.
All right. Good afternoon, ma'am. Your name?
Rochelle Lynch.
Ms. Lynch, you're here in case number 19 CF 4107. You arrested for burglary of an occupied structure and criminal mischief. I do find probable cause for both of the offenses, and I'll appoint the public defender's office to represent you. I'm gonna set your bond, ma'am, at $2,500 on count 1 and $100 on count 2.
Your Honor, she also qualifies for release to PTR, at least according to my information. The court consider PTR?
Yes, I will order PTR for Ms. Lynch.
And Your Honor, may we have a no return and no contact with victim?
Yes. Ms. Lynch, you understand you cannot return to 1304 North Powers Drive, the residence. Do you understand?
No,
You can't go back there.
I can't go back there ever.
No, ma'am. No. You cannot go back to 1304 North Powers Drive. If you do, you're going to get arrested.
Oh, okay.
Okay?
Okay.
And you cannot have any contact with Jamal Imanali
Okay.
or Roger Southwell. Thank you, ma'am. Good afternoon, ma'am. Your name?
Amanda Sanchez.
Ms. Sanchez, you're here in case number 19 CF 4110. You were arrested for battery on a law enforcement officer. I do find probable cause. I will appoint the public defender's office to represent you, ma'am, and I'm going to order pretrial release. Thank you.
Thank you. So I get
And Your Honor, for the record, the state would object as it is a crime of violence.
Thank you, Ms. Bush. Oops. Good afternoon, sir. Your name?
Richard Schuler.
Mr. Schuler, you're here in case number 19 CF 4106. You were arrested for possession of cocaine. I do find probable cause, sir, for the offense, and I will appoint the public defender's office to represent you. I'm gonna set your bond, sir, at $500. And case number 19 CF 2943, I'll take no action, sir. Thank you.
I was supposed to pay that.
Pardon me?
I was supposed to pay that.
How are you supposed to pay the bond?
Yes.
Mr. Diaz? Well, I don't know if you want to put anything on the record about what he can afford. I don't know what he can afford.
Yeah. Huh?
Your Honor, do you wish that I examine Mr. Schuler about his ties to the community, income, things of that nature? We'd like the court to consider RR release.
Did you want to put on any testimony from Mr. Schuler?
Sure. Mr. Schuler, let's talk about your,
Well, first of all, could you swear Mr. Schuler in?
Raise your right
Thank you.
hand.
raise your right hand, Mr. Schuler.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Mr. Schuler, how long have you lived in this area?
In the state of Florida? Here, Orlando.
In Orlando. How long have you lived in Orlando?
Ever since I was 6 years old.
Okay. Do you have any other family in the area?
Yes.
Okay. Who are those?
Betty Robinson, Ida Robinson, and Francis Robinson.
Okay. If you were released on your own recognizance, how would you get to court? How do you get around?
On a bike?
On a bike?
Yes. Or you catch the bus.
Okay. Mr. Schuler, what's your current income right now?
0.
Talk to me about your family. What immediate family do you have?
Well, me and my family don't get along that, but that's why I'm homeless.
Okay, so you're currently homeless?
Yes, we don't get along that well, you know. Because they don't like what I do, and they can't tell me how to do this.
Okay. If you're homeless, where exactly do you normally hang out, or where do you stay usually if you're homeless?
Anywhere and everywhere.
Okay. Locally, or what does that mean?
Beg your pardon?
Locally? Where do you go?
Well, I'm mostly down at the Daily Bridge around by the Coalition.
Okay, so you stay close to downtown?
Yes.
Okay, do you know where the courthouse is?
Yes.
All right. You said that you don't get along with your family?
Well, we speak, you know, but we don't sit horses too much.
Is it fair to say they're unlikely to help you bond out?
No, they ain't gonna do that. That's out the question.
Okay. I have nothing further, Your Honor.
Ms. Bush?
I have no questions of Mr. Schuler. Thank you, sir. Your Honor, the state does have argument, though.
Sure, go ahead, Ms. Bush.
As to release on his own recognizance, the state would ask the court to take into consideration he was released on his own recognizance in 2019 CF 2943AO when he is alleged to have committed this crime. And the state would also point out to the court that in his 33 prior convictions, 15 felony, 18 misdemeanor convictions, there are crimes of violence mixed in those convictions, as well as escape conviction, and then the rest of the convictions are all drug-related convictions. He has a prior failure to appear as well. The state would submit to the court that he should not be released on his own recognizance. The state would also ask the court that any release conditions include random urinalysis through pretrial services.
Mr. Dion?
Your Honor, with respect to the prospect of Mr. Schuler being violent, I don't have any information. I know what what Madam State's talking about. I don't know whether any of those offenses are recent. It's often the case, Mr. Schuler is 67 years old. It's often the case that one as a young man commits violent offenses, and then as time progresses, you know, and especially one battling with addiction, will continue to have offenses related to his addiction, but not so much dealing with the impulse control problems that are related to, well, being a young man and being addicted to drugs and committing violent crimes. So I can't speak to that. Mr. Schuler was released RR, and there's other two cases, Your Honor. I would ask that if you believe RR release is not appropriate, that you at least consider a very low cash bond to see if maybe his family, I don't know, might come around to liking him a bit more. They might want to help him post his bond and get out of here.
All right, Mr. Schuler, I'm going to release you on your own recognizance. I don't want to see you back in here. Do you understand? I
Yes,
just
ma'am.
saw you
Yes, ma'am.
on the 28th.
Yes, ma'am.
You understand me?
Yes, ma'am.
Okay, I'm not going to take any action on 19 CF 2943 at this time. You need to make sure that you stay in contact with the public defender's office and that they have a good address for you, so that way you get notice of court and that you don't miss court, because if you do, you're going to end up right back here. You understand, sir?
Yes, ma'am.
All right, thank you. Sir, good afternoon. Your name?
Good afternoon. Nathaniel Lane Wiseman.
Mr. Wiseman, you're here in case number 19 CF 4108. You were arrested for aggravated assault with a deadly weapon, armed burglary of an occupied dwelling, and battery. I find probable cause for those offenses, and I'll appoint the public defender's office. Ms. Bush, are you asking the court to make a finding at this time as to count 2?
Yes, I apologize, Your Honor. Yes, the state would ask the court, based on its reading of the sworn to arrest affidavit that alleges significant facts by identifiable witnesses and victims that can identify Mr. Weissman. The state is asking the court to find that proof is evident, or presumption is great, that Mr. Weissman is indeed the individual that did enter the curtilage of one victim's home and also committed the additional assaults and batteries on that victim and other victims. The state would ask that the court on count 2 hold Mr. Weissman at 0 bond. He is entitled to a bond as to counts 1 and 3. The state would also ask that the court's order include a no contact with victims or witnesses, possess no weapons, firearms, or ammunition, and no return to the scene.
Okay. Mr. Diaz.
The defense is not offering anything in response to the proof evident or presumption grade argument.
Okay.
We would like the court to consider setting bond nonetheless if it finds it appropriate in its discretion.
Okay. At this time, I do believe that the court has met its burden to establish that there is proof evident or presumption great based upon the information in the sworn arrest affidavit. So bond as to count as to count 2 will remain at 0, or I'm sorry. Yes, count 2 will remain at 0. Count 3 will be $5,000. I'm sorry, excuse me. Count 1 is $500, count 2 is 0, and count 3 is also going to be $1,000. Count 1 is $5,000, count 2 is 0. And sir, you're not to return to 914 Indigo Avenue. You are not to have any contact with Zachary Beck or Robert Lyons. You're not to possess any weapons or any firearms as well, sir. Do you understand?
Yes, Your Honor. I do.
Okay, thank you.
I'm sorry, count 1 was 5,000?
Correct.
500.
No, 5,000.
5,000, okay.
Yes.
I thought.
Okay. Sorry.
You okay? Sir, good afternoon. Your name?
Brandon Wolf.
Mr. Wolf, you're here in case number 18 CF 458. Sir, this is a violation of probation matter as well as 19 CF 4109. In that case, sir, you were arrested for possession of ecstasy. I find probable cause. I'll appoint the public defender in both cases. Your bond on 19 CF 4109 will be $500. And your bond, I do find probable cause for the violation of probation, sir, and that bond will be set at 0 at this time. And 19 MO 538, yes, sir, you do have an open container offense as well. I find probable cause. I'll set your bond at $100 and appoint the public defender as well. Good afternoon, your name?
John Beluso.
Sir, you were here in case number 19. It says 19 MM 211, and that you were arrested for possession of a controlled substance and possession of drug paraphernalia. I do find probable cause, sir, for both of the offenses. I'll appoint the public defender's office to represent you. Bond on count 1 will be 500, bond on count 2 will be 100. And 19 CF 1930, sir, I'm going to revoke your bond in that matter. And count 1 will be set at $2,000. I'm sorry, count 1 will be set at $2,000. Count 2 will be set at $200. Good afternoon, ma'am. Your name?
Autumn Goodley.
Ma'am, you're here in case number 19 MM 2542. You were arrested for resisting officer without violence and disorderly intoxication. I find probable cause for both of those offenses, and I'll appoint the public defender's office to represent you, ma'am. Your bond on count 1 is $500. Your bond on count 2 is $100.
Yeah, my mom forgot.
Ma'am, in the 19 MM 2542 case, I'm also going to order that you not return to the Andover K subdivision,
Yes, ma'am.
okay? And you're not to have any contact. With Stephanie. I don't have Stephanie's last name in the report, but you're not to have any contact with her. Do you understand?
Yeah, that's fine.
Okay. Case number 19MM1307, I'll take no action in that case at this time. She lives at the house. Good afternoon, your name?
Dane Laporte.
Sir, you're here in case number 2535. You're arrested for resisting officer without violence and disorderly intoxication. I find probable cause for both offenses, sir. I'll appoint the public defender's office to represent you. You're also here in 19MM2534. You arrested for battery. I do find probable cause for that offense as well. And I'll appoint the public defender's office in that matter. In 19MM2535, sir, I'm gonna set your bond at $500 on count 1 and $100 on count 2. And in 19MM2534, I'm gonna set your bond at $5,000. Thank you, sir.
And Your Honor, may we have a no contact with the victim in 2534, please?
Yes, sir, you're not to have any contact with the alleged victim in that matter, and you also can't return to the Andretti indoor karting. Do you understand?
Yes.
All right, thank you. Good afternoon, sir, your name?
John Jeffrey Pownell.
Mr. Pownell, you're here in case number 19MM2536. You were arrested for battery. I do find probable cause for the offense, and I'll appoint the public defender's office to represent you, sir. Your bond is $500. You're not to have any contact with Mila Migoloni, and you are not to return to 3435 South Orange Avenue. And you're not to possess any weapons or any firearms while out on bond, sir. Thank you.
Your Honor,
Yes.
he's going to need a one-time return to recover his personal effects.
Sure, sir. You can go back one time. You have to coordinate that with the police before you show up. You can't just go there on your own to get your stuff, okay? So just make sure you call and make arrangements to do that first.
Yes, Your Honor.
Okay.
So I can bond out today if that's what...
If you can post your bond, yes. Good afternoon, ma'am. Your name?
Shikari Thames.
Ms. Timms, you were here for an out-of-county warrant
Yes, ma'am.
for grand theft, ma'am.
Yes, ma'am.
This is from Broward County.
Yes.
Your bond is $0. They'll come pick you up and you'll see a judge at first appearance.
Thank you, ma'am.
Thank you. Anybody else?
That's it, Your Honor.
Anything else? Okay. No, we'll be in recess.
So that can be asked to see more.
It's not, I don't know what's going on.
Did we do Pownell?
Yeah.
Did we do Pownell? Pownell, okay. Okay. My paperwork got separated here.
I don't know, this thing's not acting right.
Okay, so.
Oh, there. Yeah. Ooh, look at ice in here.
You're so tough.
This is Autumn Goodley.
During court, the clerk's office did
See?
respond. So I'm going to print that affidavit for you.
So we have someone new joining us. Hi. Welcome.
Thank you, Judge.
What's your name?
Robert Williams.
Mr. Williams? Well, welcome. Are you going to be starting out here?
Yes. Yeah, he'll be with us.
Okay. Good deal.
He'll be our tallest PD to date.
Pardon me?
He'll be our tallest PD to date.
Yeah, he might even give Bob a run for his money.
Yeah, I think he might be tall. Well, Bob told me he was shrinking, so he's kind of hunched over a little bit too. So I think you're taller than Bob, aren't you? Yeah. Yeah.
All right.
I thought so.
Well, all right. I'll see everyone tomorrow. All right. Thanks, everyone. I'll see you tomorrow.
What's that? Oh, I know, right?
Judge is laughing.
Listen, I was going to when
There you are. Now, they did not send the signed request for administrative transfer.
Oh, no, I don't care
They
about
just
that.
signed
This is
that.
what matters.
Yeah.
This is what matters.
But see, and it's been done this way for quite a number of years on those walked-through, clocked-in copies. All the assistants do is they take the packet, but they print out a page for the clerk, because the clerk won't make copies there. So they print out a page. When they do the request for administrative transfer, they print that, they print 2 copies. One copy the ASA signs and the information the ASA signs. Then they take just what they printed out in addition to hand to the clerk for the clerk to stamp it, and then they walk back with it, that's all.
Steve, you've been practicing long enough to remember when we used to have to issue service in the mail.
Yeah.
Right. So you're not going to send somebody an unsigned, whatever copy. If you had to
No,
issue
but
service of something.
in the mail,
No,
that's why.
You with me, Ms. Arlene?
I ain't hear what you
33-day
said.
motions, which are still in the order, by the way. For instance, the order says if a 33-day motion is filed on Friday, it will be set for
She ready to go, he
the
ready to go.
following
He wanna go back. She
weekday,
don't wanna,
as long
she
as
don't
it
wanna let
doesn't
him go.
fall on a holiday, et cetera, et cetera. But
She don't want that.
No.
She
at
do
that
whatever she
time,
gotta do. to keep
it's
them kids
still,
out. That's what this-
still, if it was something that was walked over
Because,
in a clocked-in copy,
according, now they bringing up stuff from.
way back when, in the day, when I started,
Come on, man.
15 years ago,
She talking about all this
they
speed.
would, actually, the clerks would actually take that signed copy, they clock it in, they walk to the copy and copy it, and give us a copy. Because there are many times that I ran over there at the last minute with my own filings and went, here it is, at 4 o'clock. But they stopped doing that. They said, our clerks do not have time to make copies. So just bring us a piece of paper.
Just make copies and be over.
Well, that's, well, because through the years, what, and your office has accepted it every time, because locked-in copies are not the norm. They're the exception.
Well, I know that because we're supposed to be filing everything electronically. That was the first thing I told my young buck over here. Because
But there's
But it
some
sounds like
reason,
she got
I
the
don't
money.
understand why they do it, but
It
when
sound like she
it's
has the
a
money.
request
She
for
won't let it go.
administrative transfer,
So
they
he's
cannot
stuck.
file those electronically.
Yeah. Why she won't let me go?
They can't file them electronically.
why though? That makes
Every
Yeah, but you gotta have money to go. You can't just go without a ticket.
I got that.
Yeah.
So you can initiate a case electronically?
No, we can
Right.
initiate a
Right.
case
Right.
electronically. We can't do the request. When the case comes in, like this did, as a felony.
I have my
Right.
passport.
And then we request to have it transferred to county court. That's fine, well and good, but the administrative order still says that the administrative judge has to sign off on a transfer.
I'm just saying.
So, and that's why it's not assigned a case number right away.
Yeah. I saw her. I was looking at
So,
I was like,
and I've
I caught that off.
Why don't you just file the information? That's, no, we do. That's the whole packet. We have to file
But
the
instead of doing
request.
it all
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.